Thank you so much, everybody who came here so early in the morning to attend Russian Arbitration Day. And I'd like to say a few words just on behalf of the organization. My name is Yulia Mulina. I am the Director General of the Russian Institute of Modern Arbitration and Russian Arbitration Center. This conference is a unique conference because what's different from many other conferences, it's not a business conference. This is an event for the people who write research papers. They've been working for many months on these issues under the guidance, also with the assistance of the distinguished moderators, their research mentors. I hope that sessions today are going to be of interest to you. You'll learn something new. And I'm grateful to the moderators. And now I give the floor to the moderator of the first session, Anna Arkhipova. Thank you. Distinguished colleagues, I was asked as the moderator of the first session to say a few words about the conference this year. And I'm going to say that, first of all, we should thank the organizers, Russian Institute of Modern Arbitration and Legal Academy. And I really like this mood of the organizers. They're going to overcome all the difficulties. And it's not just having the conferences after break, not just publishing one more book of the articles regarding international commercial arbitration, but also there are new projects that are emerging. And Russian Arbitration Day is different from many other conferences because in order to participate, there was a real serious selection procedure. Dmitry, Kaisin, Andrey, Panov, and myself, the moderators, had to use certain criteria to evaluate the applications, and we had to choose to select the speakers. It was really difficult to do it, because a lot of applications were filed. We had a really serious competition. We had articles from Russian lawyers, foreign lawyers, and the standards were really high. And I'm going to take advantage of the situation, and I would like to address people who failed. Thank you for participation. Good luck with your future research, and please continue cooperation with such serious events as Russian Arbitration Day. And this year we couldn't select all the applications, and today we have very different issues that are going to be covered. Of course, we can see some topical issues that have concerned sanctions, limitations, attempts to influence international commercial arbitration, new architecture of solutions. Maybe some of us would prefer not having those reasons to discuss all these things, but all the authors that are going to address you today, they're looking for the ways to overcome these problems. We're going to have 3 sessions, and the speakers are going to be introduced by moderators. The first session is going to be dealing with the general issues in arbitration. So we have interim relief, powers of arbitrators, arbitral clause, and so on. And then the second one, sanctions and arbitration, moderated by Andrey, Panov, and a third one, investment arbitration, arbitrator, and the moderator is Dmitry, Kaisin. And we have all the stars, our speakers. We're going to introduce them later. And we have quite an interesting agenda, topical agenda. It's going to be quite important for all of you. You all have the books, and this is book number 8, New Horizons of the International Arbitration, which includes the articles written by the speakers you are going to hear today. And of course, this is just a different format. And we're really happy to have this book, and not just the presentation. This book is going to be available to everyone who is interested in international commercial arbitration. And publication of the book is the tradition of the Russian Arbitration Day. Now, in conclusion, I would like to thank the platinum partners of the conference, law firm alumni partners, and KIAP, Legal Bureau, and we must really appreciate the effort of everybody who prepared this conference. And now, thank you for your attention, and let's get to the essence. Thank you. Now I'm coming to the head table, and I'd like to introduce our very first speaker. Today we start with quite a general issue regarding the powers of arbitrators, and the presentation, which is called Freedom of Discretion in the Arbitral Tribunal or in Institutional Arbitration, is going to be presented by Sergei Ivanov, legal advisor of the Russian Arbitration Center. Welcome, everybody. Thank you for this opportunity to address you all. And I am the first one to make a presentation. And now I'll try not to lull you to sleep. And then again, some of the issues also overlap with the presentations of other speakers, and I'll try not to get to their territory. I would like to start with something which is quite romantic. In Spanish, they say comprate bosque and perdete. If you speak Spanish, you can correct me later. And the translation is you can buy a forest and get lost in it. So this is something you say to somebody you have a dialogue with to stop the conversation. And sometimes the parties actually create their own forest of procedural documents, evidence, oral evidence, and so on. And finally, the parties need a guide who is going to take them of that forest of their own. And arbitrator should be this guide. But the situation is such that such a guide should ask them, are we going in the right direction? Although the arbitrator often knows better what to do, better than the parties. And that position is not very efficient. And that's why we have this need to get to better procedure of just dealing with the disputes. And now I am getting to the definition of freedom of discretion of the arbitrator. And here we have this mixed theory of arbitration. The status of the arbitrator is status of a quasi-judge, because there are a lot of works that prove that when administration of justice is the activity which is not just the activity of a government judge. So it's more than just judicial proceedings. And we can make this conclusion that arbitrators, they have certain duties to maintain fairness, equity. And that's why sometimes they can digress from certain regulatory provisions that they were put in originally. That's why the methodology provides that I'm going to compare the discretion in government courts and discretion in arbitration. And the features are as follows. So in the beginning, any powers, judicial or arbitral powers can emerge in the framework of a specific dispute, or in connection with this specific dispute. Because we have also enforcement stages. The arbitrator has confidentiality issues and so on. And then the implementation in the framework of certain powers following strict procedural format, notwithstanding a certain flexibility of arbitration procedure. We provide for certain stages, time frames, and so on. And the judge has the powers in accordance with the procedure provided by appropriate legislation and has total discretion. And the powers are actually provided by the government. The arbitrator actually has the powers because of agreement of the parties and arbitration agreement, and the powers of the arbitrator are limited. So we cannot say that in the framework of the dispute, the arbitration tribunal has unlimited competences. Well, now the government court is empowered to interpret certain legal provisions regarding a specific dispute. So he is the fact and the legal structure. But the powers are limited by the rights of the court. Arbitrators, especially in international arbitration, they don't face this lex fori that would say what is and what is the extent of interpretation by the arbitrator. That's why, on the one hand, the arbitrator, to a certain extent, has more freedom than a government judge, but not every arbitrator is ready to exercise super creative approach, because there are procedural documents of the parties. There are also forensic reports, also assessments of legal experts, and quite often the arbitrators don't see the grounds to get outside the framework of those documents because the award should be enforceable. And also we must pay attention to the fact that a government judge has the duties to defend the values of the legal system, legal policy. The arbitrator, at least initially, we have the impression that arbitrators don't have that duty. For the arbitrator, first of all, it's to respond to reasonable expectation of the parties. Also, we're interested in the issue of establishing the foreign law. So for the government judge, lex fori, our own law, and foreign law. And different procedures can differ, but a government judge always has this luxury of saying that we cannot find out what happens in your law, that's why we'll apply our national law. Arbitrator doesn't have lex fori right. And in any case, you must take into consideration applicable provisions that exist. That's why we have the importance of adversary principle when the parties are interested in conveying to the arbitrator the interpretation of the provisions that they believe is right. Also, we must mention the following, that the government court, when it's interpreting the law, applying the law, it's looking, willingly or unwillingly at the position of higher courts there could be some kind of a judicial review, a reversal, but the position of the court is somehow aligned with the position of higher courts. In arbitration, we don't really have stages with certain exceptions. On the one hand, there is no higher court. You can be creative in your approach to the procedure, but the arbitrators reasonably believe that it's not necessary to take an initiative. So the arbitration has greater freedom and quite often doesn't really have application. For example, a typical case, and the arbitrator saw about 50 of such cases of this type, or in the interest of enforceability, they try to be in the same rut. But also it's possible to limit other types of enforcement. For example, the government court ruling is of legal force to an unlimited circle of individuals. So the government court has preclusionary rules. For arbitration, we don't really find it, but we could, scientists could argue about it. But the arbitrator doesn't have any legal duty to take into consideration previous arbitration awards as mandatory. So when we have freedom of discretion, it's possible to make the decision on procedural and substantive matters in the framework established by the arbitration agreement and applicable law. And now it's wonderful opportunity to get to the sources and limitations of the discretion of arbitration. So autonomy of the will of the parties. The competence of the arbitrator is determined by arbitration agreement. It's really good when we have a typical arbitration agreement and the parties didn't add anything creatively. But we cannot exclude the situation when the parties have just a very narrow interpretation of the arbitration agreement. But in the framework of the discussion, that issue could be of critical importance for the dispute, and the whole process actually is becoming kind of void. It doesn't lead to the results that parties were craving to get. And can we think that in such cases, arbitrator can get outside the framework of the arbitration agreement? In this case, the arbitrator needs some kind of provisions to support it. So for example, Swiss lawmakers made decision regarding internal arbitration, and they included the principle that arbitrator is going to deal with all the objections against the lawsuit, and Mr. Nessie can correct me later if I am wrong in interpretation. So even if it's not covered by arbitration agreement, the arbitrator has the right to accept those objections. On the other hand, in the absence of the lack of provisions available, the arbitrator is always working on the cutting edge, and the decision could be made to say that the arbitrator exceeded his or her powers, so that could lead to no enforcement. So logically, we are getting to soft law. which is the set of standards that were outlined by different communities, for example, Institute of International Law, Royal Institute of Arbitrators, International Association of Lawyers.
And they should be supplementary to the national regulation in order to provide for the possibility to have independent way of approaching the decision-making processes. As to applicability, considering the preamble of any act or ABA principles or whatever evidence there may be, or impartiality and unbiased of arbitrators, the applicability of these acts is based on the settlement of the parties. But even if there is none, the arbitrator can refer to such acts while taking the decision. This is an authority or a reference for accepted practice, which is implied in these acts, and which is current now, is for the procedural and other ways. The question is whether these acts are actually typical for the accepted practice, or is a result of certain kind of lawmaking or creativity research by the lawyers, and whether it can be used for the entire landscape. Then, sources and limitations for freedom of discretions for the national arbitrators is the regulations of the arbitration institutions, which is current for the Russian Federation, because according to the Ministry of Justice, they're much more popular than the ad hoc arbitrations, I mean permanent arbitration institutions. In terms of statistics, we cannot actually assess how popular it is, but still this is part of the arbitration agreements anyway, because there's a reference to all regulations and norms of the arbitration regulations in the arbitration agreement, I mean. At the current stage, arbitration institutions cannot be accepted as a source of infrastructure. Here's the premises, here are arbitrators, the infrastructure, etc. No, they have their own interests. Sometimes it is, it may be interested in certain things on their own and have their own interests. Otherwise, what's the point of doing it? And what's the point of the arbitration dispute and administrative dispute? And within any arbitration institution, certain internal regulations or protocols emerge, like the arbitration decisions, model arbitration decisions, etc. And they vary, these arbitration institutions. And the best example is the ICC Chamber of Commerce Arbitration Center, and it is more of a technical nature. And still, so far, we have not considered the possibility of interfering in the powers of arbitrators on merits substantially, but still the arbitration institution makes it clear for the arbitrator at the very initial stage that the institution expects certain actions or certain model things like practices, etc. And the next source is the norms of the national legal order, and they usually affect greatly or impact the discretion of the arbitrators or arbitration. And first of all, this is the category of arbitrability of the dispute. If the seat of arbitration is accepted, And if they say that it cannot be settled by arbitration, you can do anything about it. The same goes for the seat of enforcement, or the place of enforcement. And also, arbitration is not entitled to take into consideration the seat of the enforcement because they may be unaware of the fact where it will be enforced, in which jurisdiction, etc. And within applicability or enforceability of the arbitration award, the arbitrators should think of their steps to be taken next. It goes for internal arbitration as well, because arbitrators usually speak the national tongue. Please, the time is expiring very fast. National legal order also lays down certain guarantees, and they are implemented through the principle of due process and jure novit cura principles, which will be dealt with the next speaker. And thus, we should state that there is a large amount of sources which establish the discretion of the arbitrators, and they may give priorities to some of them, or to create a kind of an illusion. When you see the picture of moving water like waterfall, but this is only pictures. Thus, the sources, they act differently. The major subject which affect the discretion of the arbitrator's powers, these are legal orders which I discussed and the specific arbitration institution. Thank you very much. My time has expired. Sergei, thanks a lot. This is a very interesting topic as a beginning, because the regulations of our arbitration, they are very strict, because we have a lot of speakers. And the next one will be Alexander Lamport from VTB Bank and the Moscow University academics. And he will take on the topic which has been started by Sergei. That is inherent powers of arbitrators as a tool for the protection of sanctioned designated partners, which will be much more specific than the previous presentation. Ladies and gentlemen, good morning. I hope that our guests and all those who are residents of Moscow will be satisfied with our program, and that is why I prepared slides and presentation for you. Well, it works. Thank you. So the first question emerges usually. Inherent powers of arbitrators. What it is about at all? Well, it is much closer to our practitioners than you think, as compared to those who have never come across it. Inherent powers is an instrument of defending sanctions persons. This is a very current topic for any lawyer now. The change of the seat of arbitration, changing the applicable law, changes of circumstances because of the sanctions. And these are only part of the problems that we're going to discuss, and we will combine theory and practice, because each of us has used such instruments as bona fide principles or good faith. And sometimes when considering a norm, you see that something is lacking. And often we think of this particular principle of bona fide, and perhaps we can find it in the arbitration system or something similar to it. What it is about, inherent powers of arbitrators. Well, there are various concepts and theories. They may be called inherent or indirect or implied or discretionary. Each of them has nuances, but the basic powers either are laid down by national laws or by arbitration regulations or agreements or clauses, or it is something that that is contained indirectly in the documents. This is one of the practical concepts. As I have already mentioned, the most numerous group of inherent powers that could be enumerated, these are a part of them on the slide. Well, the principle of competence, which is well known. On the one hand, it is a clear and direct principle laid down by any national law and any arbitration regulations. But this is a power which may be called inherent. Inherent powers are such powers which are not laid down by the national law or regulations, but it is inherent in the functions of the arbitrator as such. Perhaps you have encountered such a problem as changing the place of seat of arbitration. And those who studied the topic know it well enough. That is why, very briefly, the change of the seat of arbitration is an inherent power as well, because neither law or arbitration clause or agreement has it. But in practice, it is widely used. It is applied by arbitrators because it may be indispensable for the integrity of arbitration. And mostly the approach is accepted abroad. The change of arbitration seat is a typical example which is used very frequently. Well, here are some examples. And usually it is extraordinary circumstances which provide for it, because they usually become known during the settlement of the case. The same goes for the change of applicable law. In practice, arbitration and the parties, they agreed that the arbitration agreement or the contract should be interpreted in such a way as to avoid uncomfortable applicable law, like, for example, Russian jurisdiction, because it may entail unfavorable consequences for a party, and thus changing the applicable law is done according to the Vienna Convention and other documents. So the change of applicable law is the same as changing the seat of arbitration. These are just parts of inherent powers. Well, the next slide. So I can send you my slides if necessary. So the most current topic at the time is the issue of doing away with the sanctions, of how to reverse them. Perhaps the European sanctions, or part of them, will be reversed. And now we have disputes whether it is possible for the Russian sanctions company, which is a part of the dispute, to change the unfavorable law in terms of the Russian legal system, and in order to change, to review the case and to change the facts after the arbitration award has been taken, and but the sanctions were done away with after this. So arbitration has come to an end. The arbitrator's mandate has come to an end, but there's a principle justifica which establishes the general liability. And on the other hand, in terms of certain acts, there are exceptions, like 51 article of the Washington Convention on using the investors and states dispute. It presupposes that it can be used, because we had something similar to what existed before on changing the applicable law, the seat of arbitration, etc. There should be a unique, extraordinary situation that will make it possible to change the arbitration award or to review it, which was not available at the point of proceedings. There's arbitration practice which proves it, because there are certain interim awards, for example, jurisdiction disputes or the size of damages, which is usually used for investment arbitration, and whether this approach could be used anywhere, including international commercial arbitration. And why? Because certain legal orders allow it, like Switzerland, the United States, the Netherlands, because there are certain specific norms which allow to use the review of the case. And the arbitrators usually take a conservative approach in changing the seat of arbitration or applicable law. They're usually conservative. But on the other hand, we should look ahead at what will happen in the near future. We are hoping that the sanctions will be done away with, and the new contracts will make it possible to have a flexible approach. But the question is, what should be done with the previous arbitration awards, whether they could be changed or reviewed, etc. But the slides which I have shown to you, well, perhaps these are those slides and the cases given as examples. So when the decisions, awards were reviewed due to changing circumstances, which are similar to the sanctioned potential collision of
было отменены санкции и арбитраж.
Reversing the sanctions. But these are cases which are not true for fraud cases. Fraud is a very popular dispute, and they usually call for changing arbitration awards because the circumstances of facts of the case change. And these examples are unique because they are taken from commercial arbitration, like in the human rights courts, for example. Though these are unique cases, but still they are typical. And lifting sanctions is another similar case. So the question emerges, what should be done? Because there are a lot of potential problems in implementing the mechanism, because on the one hand, the adverse party may react to changing actual changes, that is, changes of the facts or circumstances of the case. But on the other hand, the new legal norms allow for changing the position of the counterparty. For example, it can wish to bring back the previous regulation, etc., thus changing the award. And with a lack of dispute on merits, does it affect the result? Could we review the arbitral award? On the other hand, the parties can sign amicable settlements. So there are various ways and versions for this. If the parties have come to agreement to settle the dispute, that then they change their minds and decided to bring in a new claim. So what should be done? The previous Arbitration Act is due to what happened before, whether the arbitration is entitled to change the panel of arbitrators based on the new facts. And is this discretion available?
So in this way, there is just no way they can avoid enforcing the enforceable law. In fact, this kind of legal collisions are something I have not identified yet. Perhaps my colleagues have. The other thing is that these are the issues and the kind of discussion we should really focus on right now and here, because otherwise, in some time, we will be thinking about the cancellation or the lifting of particular arbitration judgments that will have to do with the lifting of the sanctions. We have some examples of the negative approach here in terms of, if we could just go one slide forth. So there is also the opposite practice, demonstrating that there is no way you can revisit the arbitration rulings. And here it's exactly the same thing as the change of the venue of arbitration, the location, because either the one taking the risks and the most exposed will win, or we may not gain anything there. So in fact, that might be a great field for experimentation. Here is another example of the potential change of the conditions and the implementation of the arbitrator's discretion, which is about the application of the arbitrator's recusal submitted or initiated by another arbitrator, because these days we very often suspect the arbitrators of their being biased or prejudiced. In fact, I've had a case where one arbitrator, in fact, reports another arbitrator and requires that he disclose the information. So there seem to be no national laws on that, no national regulations, and I'm coming back to the inherent powers topic here as a substance that makes it possible to explore the powers of arbitrators we're not aware of at times. I mean, this certainly is about a number of pretty one-off cases, but still that is the case. In fact, I am referring to one case here on this slide whereby one arbitrator, in fact, reports for the recusal another arbitrator and turns to the High Court of Kuala Lumpur. And now the grounds for this recusal were changed because the arbitrator had participated in the high disputes as the arbitrator on the side of the country. Why? The arbitrator here acts as the expression of the party's will. That is, the party or the country, in this case, selects its arbitrator because it really wants to have a word to impact the proceedings. There was another slide referring to the actual stance of the High Court, the Supreme Court of Kuala Lumpur, saying that the arbitrator, in fact, is the reflection of the country that has selected or appointed it. It's the third party of the process of the entire procedure, and being the third party, it can indeed have a say and impact whatever regards the challenging or the recusal. Now, to conclude, I would like to refer to another tool, a well-known tool, as the arbitration funding provided by the third party. Now, what inherent powers can we refer to here? I mean, can they at all be present here? Indeed, they can, and then they can even affect the parties or the individuals subjected to sanctions. Take a situation whereby the arbitrator has considered it important and necessary to disclose the funder of the arbitration procedure. Now, this individual in some ways has to do with the person subjected to the litigation, or that is part of the litigation. Now, the funder, or otherwise the one involved in the whole litigation, is subjected to the sanctions, especially if this is an investment-related arbitration. Now, what are the procedures both are susceptible to? Because any information that may come out will be immediately disclosed to the broader public. So, anyway, there will be the risks whereby the particular individual that did not want to be subjected to the sanctions or to admit its affiliation will be constrained to confirm his or her affiliation, which means the arbitrators in some cases can require that the parties disclose the individual funding the whole procedure. And it can be somebody subjected already to the sanctions. I will just need to go a few slides back to showcase some of the cases here. Here, it never ended up in a real disclosure. But here, in this case, they did have to disclose the individuals, which implied some negative legal impact, consequences for the funder. In fact, here are lots of issues that are still outstanding and open, because at times we may feel that arbitration is an extremely well-researched area, and we know it inside out. But said that, we all admit that the new setup, the new circumstances, in fact, generate some new issues and challenges, and while addressing them, we see we cannot disregard the entire concept of arbitration, not only the one of location of arbitration or any other one of side of it. Thank you. I'm happy to take any questions you may have. Thank you very much, Alexander. That's been very interesting. And in fact, I am sorry I did not let you know that after we've done 4 presentations, we will have a Q&A session. So if you have any considerations, any ideas you would like to share, if you have any questions to the presenters that have already spoken or that are going to present right now, if you have any objections, please make sure you ask all these questions as soon as we have the Q&A session.
It's going to take place in English, and we will hear the presentation by Sebastiano Nessi, an international arbitrator, arbitration and litigation partner with the law firm Curtis. Sebastiano is an arbitrator, is a law professor and author of various works on commercial arbitration, and he will speak about the battle of jurisdictions between Russian and British courts, one more very actual hot topic. Please go ahead.
Thank you. Great. So, no slides for me, unfortunately, today. So you will just have to look at me and listen to me. for hopefully no more than 20 minutes. Before I start, of course, thank you for the organizer, for organizing this fantastic week that we're having, and which started from what I understand yesterday. Last year, there were not that many foreigners in Moscow when you organized the conference on arbitration. I think that this year people are coming back, so it's a rather good sign. So what I want to discuss today is a topic which is quite dear to me, not only because it's a hot topic, not only because it's, I guess, interesting, not only because I had the chance to be involved in at least 2 of these cases, but it is sort the kind of topics we like in arbitration because it has plenty of court drama. And at the end of the day, you end up with one question, I guess we are all asking ourselves, which is, did we reach a deadlock in international arbitrations involving sanctions and Russian sanctioned entities? So let's maybe rewind where this all started. It started all, and I assume most of you, if not all of you, are aware of it, in 2020, when the Russian legislator introduced amendments to the Arbitrage Procedural Code, as the Lugovoy law, and where 2 key articles were inserted, as you might remember. So first we have Article 248.1, which is basically Russia's own access to justice clause, and which gives the arbitrage courts exclusive jurisdiction whenever a Russian party under sanctions claims it can get a fair hearing abroad. And then, of course, you have the second provisions, which is Article 248.2. That's the anti-suit injunction weapon. And as you all know, under that provision, a party may request a Russian court to prevent the other party from initiating or continuing arbitration proceedings in case of non-compliance with the injunction. Of course, the court is also empowered to collect damages for breach of the injunction. So fast forward to today and the use of these articles, and what we can observe first is that the use of these articles has exploded. As at the end of 2024, Article 248.1 has been involved in several hundreds of disputes, and there have been more than 100 requests for anti-suit injunctions under Article 248.2. So in practice, what do we see? What happened is that we have basically a Russian sanctioned party subject to an arbitration clause, which decides to bypass that arbitration clause and goes to a Russian court under Article 248.1, arguing they can get fair access to justice abroad. But here is the catch. The law doesn't spell out what access to justice or fair access to justice abroad means, or how serious the obstruction must be to ignore an arbitration agreement. And so the first question at that point in time was, how broad is that interpretation supposed to be? And the Russian Supreme Court, as you all know, gave us a strong hint in 2022 in the Ural Transmash case. And though technically it was based on Article 248.2, which concerns anti-suit injunctions, still what the Supreme Court decided is that it basically had that the sanctions alone were enough to presume the sanctioned party's right were prejudiced. Proof? No. Optional. No need to show how sanctions actually impacted access to justice to that sanctioned Russian party. And that opened the floodgates. A broad near-automatic presumption took hold across Russian courts. And you can have seen that in many cases, which most of you are certainly aware of. Public televisions of Russia, Moscow Media versus Google, VEB versus Barclays, all the courts ran with the same logic. Sanctions, no fair access to justice, jurisdiction of the Russian courts over arbitration agreement. Russian courts even accepted indirect sanctions or Western government press releases as proof that fair and equitable justice could not be succeed and obtain abroad. I think here of the Cisco Solutions case, the A1 Capital case, or the NTV versus Google case. And in the Google cases, of course, which made the headlines, why? Because the Russian courts went as far as to apply also the fine provision, so to speak, where with compounding interest, Google was basically fined with a number of $1.8 octillion, and these Russian media outlets, of course, have already applied to enforce those judgments in foreign jurisdiction, Turkey, Serbia, Kyrgyzstan, and South Africa. And that's rather relevant, and you will understand why in a second. Of course, you will probably all tell me, but what about the Ruschem Alliance saga, which you are certainly aware of as well. That was that Gazprom joint venture with the EPC contract with Linde Engineering for a massive LNG project. Linde pulled out after the Ukraine conflict and the imposition of EU sanctions. Ruschem decided to pursue Linde, several banks, and amongst which UniCredit, Deutsche Bank, and Commerzbank for payments under English law-governed bonds with ICC arbitration clauses with seat in Paris. And that, again, is relevant, and we'll discuss that in a few minutes. Here again, the Russian court stepped in under Article 248.1. And why so? Because the banks relied on EU sanctions as a reason not to pay. And although Ruschem was actually litigating before ICC tribunals and before English courts, the Russian courts nevertheless held that sanctions made arbitration, or at least a fair arbitration, impossible. Now, you would probably ask me, is there a different test between 2481 and 2482 of the Lugovoy law? No, there is not really a different test. The test is rather the same. Sanctions are presumed enough to kill arbitration. There have been a few cases, of course, there have been moments of resistance, so to speak. ANOBM Bank versus Brizani Decker, where the lower court in Russia initially refused granting an anti-suit injunction, basically stating that the RCC arbitration was fair, remote hearings were available, Russian counsel could have been hired, and initially then, as I said, refused to grant the anti-suit injunction, but the appellate court overruled this decision, again relying on the 2022 Ural Transmash decision. That's the Russian side of things. But then, when you go to the UK, you then land in an entirely different world. Because we've seen in the UK, in response to the application to 2481 and 2482, a cascade of anti-suit injunctions, anti-suit injunctions, anti-enforcement injunctions granted systematically to stop Russian proceedings allegedly breaching arbitration clauses. I can give you an early example, which I mentioned before, Barclays Bank versus VEB. You will remember that I mentioned it because Russian court assumed jurisdiction because of sanctions. VEB in the UK argued that the sanctions blocked the arbitrations, that they could not hire lawyers, not make payment, no fair hearing. The High Court replied, you have lawyers, you have Zoom, you have no excuse. Arbitration agreement stands, and the anti-suit injunction was then granted in the UK against the Russian party. The Ruschem story, which I also mentioned, played out in the UK. I will not enter too many into the details because the Ruschem Alliance saga basically is comprised of different cases in the UK, involving notably Deutsche Bank, Commerzbank, and UniCredit. You will remember, as I said before, the specificity of these cases is that the bonds were governed by English law, but the seat of the arbitration was in Paris. It was not in London, it was in Paris. And so came the question, do English courts still have jurisdiction to issue anti-suit injunctions while the court of the seat are French courts, not English courts? And interestingly, if you take, for instance, the Deutsche Bank case, the first instance English judge decided that because anti-suit injunctions were not available under French law, which was the seat of the arbitration, then English courts should not impose their system just because, and grant an anti-suit injunction, just because the bonds were governed by English law. That decision was overruled, but it didn't go to the Supreme Court. But in the UniCredit case, the Supreme Court had to rule on precisely the same question. And the UK Supreme Court ruled that since the French courts couldn't enforce arbitration clauses or issue anti-suit injunctions, because, as I said, you cannot seek an anti-suit injunction from a French court, neither can you from most of the civil law jurisdiction, then the English courts had to step in to protect the rights under English law-governed contract. Now, you probably all know that the English arbitration law is being under current reform, and if the reform passes, the law of the seat will be considered as the law governing the arbitration agreement. And that means basically in concrete terms that with the new law in England, as is, if it passes, most likely the English courts would not have had jurisdiction to issue an anti-suit injunction in the first place. Now, interestingly, in the Ruskem saga, as I said, the Russians courts issued anti-suit injunctions, the English courts issued anti-suit injunction, and a few months later, UniCredit went to the UK court and asked the UK court to lift the anti-suit injunction it had sought and obtained before the UK courts. Why? Because, as I said, a Russian court had ordered not only that UniCredit does it and seek the lifting of the anti-suit injunction in England, but failing which, he would have to pay a fine of $250 million. And that came the very interesting question. Can an English court lift its own anti-suit injunction it has granted in favor of a party, if a party then comes later and say, look, I'm under massive pressure here. I have assets in Russia. My Russian counterparty doesn't have assets in England. So basically, I'm at risk. So I ask you, even if I'm under pressure here, to validate my request and lift the anti-suit injunction I've been requesting from you a few months ago. And the English court, in a rather pragmatic move, actually agreed to lift the anti-suit injunction. So now let's take a moment to ask the key questions. What are the lessons we can actually draw from the current situation? Russian companies that are subject to sanctions have increasingly started bringing their dispute before Russian courts, as I said, even there is a valid arbitration agreement. Now, why did they so? Let's try to unpack quickly the thinking of Russian courts here. International arbitration is built on a basic promise. I think we all agree on that. All parties must be able to engage meaningfully. That means hiring lawyers, paying experts, funding procedural steps, and making submissions on equal footing. But sanctions, in the Russian court's view, pull that rug out from under the sanctioned party. And how exactly? We can just cite a few examples. Financial transactions are blocked or heavily restricted. Travel bans and visa issues preventing participation or coordination. Foreign lawyers often need special licenses just to get paid or appear before court or tribunals. Bank won't always process transfer for legal services or with major delays. And even arbitral centers sometimes require that only the parties, even if they cannot process payment from Russia, not their counsel, pay the advance on cost. So the message from the Russian judiciary is simple. All these restrictions aren't just annoyances. They are concrete and legal practical barriers, enough, they say, in their mind, to prevent access to justice for Russian companies under sanctions. Now, contrast that with what's happening in the UK. The English courts have taken precisely the opposite approach. Despite the same geopolitical context, despite the same kinds of sanctions that are being imposed, the English courts have held the line of enforcing arbitration agreements. But here's where it gets quite interesting and quite, I would say, worth thinking more about. Both Russian and English courts are looking at the same problem, which is access to justice under sanctions. They both acknowledge the hurdles, yet they land in completely different places. Look at the VEB case I just mentioned before. The London High Court accepted that sanction had narrowed the pool of available lawyers, but still concluded that VEB still managed to hire legal lawyers and legal representation and make payments. So the English courts are not denying the hurdle. They say it's certainly more difficult, but it's not entirely impossible, and certainly not a denial of justice. So you see, what happens today is that we are caught between two fundamentally different legal paradigms. One paradigm is rooted in perceived hardship. How do you perceive as a hardship? That's a Russian approach. The other in strict functionality. That's the English approach. So Russian courts treat sanctions and external disruption as enough to presume that justice abroad is fully inaccessible. English courts, by contrast, require a much higher bar. Arbitration agreements remain binding unless performance becomes literally impossible. Complexity, cost, inconvenience simply do not suffice in the eyes of the English courts. And that creates a blurred legal signal, because the same set of facts may render an arbitration clause unenforceable in Moscow, but fully valid in London. And this leads, I guess, to a deeper, still unresolved question: when does the difficulty becomes really impossibility in the eyes of English law? And how impaired must a party's ability to arbitrate be before an English court finally concludes that the arbitration agreement is no longer operable? And so far, we don't have a clear answer to that question. But we are already seeing the practical difficulties of all this situation, and that is parallel proceedings in different jurisdictions raising major problems around recognition and enforcement. Because if you take the enforcement from the English law angle, English courts are not going to recognize judgments from Russian courts if they think those proceedings were started in breach of a valid arbitration clause. But what happens if a Russian party takes a Russian judgment and tries to enforce it somewhere else, not in England, but in Asia, in the Middle East, in Latin America, as they did, you remember, in the Google case with regard to the 1.9 octillion fine? That is then for the local courts to have to decide on that. That is then for the local courts to have to wait what impact they want to give to English anti-suit injunction or anti-enforcement injunction abroad. That is then for the local courts to decide whether in the first place the arbitration was valid or not, and whether they will side with the Russian approach or with the English approach.
Sorry, Sebastian, there is 1 minute. 1 minute.
1 minute, it's perfect, it's perfect. And this brings us to a very practical point, which is only as powerful as you can imagine. Because Russians and court rulings matter mainly if the foreign counterparty has assets in Russia. And since 2022, most have packed up and left. So without assets to seize in Russia, Russian orders, Russian fines are largely toothless unless you want to enforce them abroad. And the same goes in reverse. Russian companies with no assets abroad and no assets in England, for instance, might ignore English anti-suit injunctions or anti-enforcement injunction entirely. And this is the UniCredit case I just talked to you before. It proves my point. You have an anti-suit injunction in Moscow, assets of a foreign company in Russia, The same anti-suit injunction in London, no assets. In London, what happens at the end of the day? Basically, the Western company asked the London court to lift the injunction because its assets is at stake in Russia. So where does all of this leaves us today? I think that we're staring into what I can only describe as a legal stalemate with no obvious exit. On one side, we have Russian courts slamming the door on foreign arbitration for sanctioned parties. On the other side, you have English courts doubling down on arbitration agreements, even if the sanctioned party can barely pay their lawyers, let alone book a flight or get a visa to go to a hearing. And it's a bit like War and Peace, but without the peace part in it. And so I leave you with the questions I asked you in the introduction. Do you think we have now truly reached a deadlock in international arbitration when it involves sanctions and Russian sanctioned parties? As far as I'm concerned, I think the answer is a reluctant yes. Thank you for your attention.
Thanks a lot, Sebastiano. Perhaps this is not an entertaining speech, but a very important one, I think. And it's very useful to have a view from outside. We all know the situation from inside, but it's still very useful. And at the end of our session, our star speaker and our headliner, Mr. Khawar Qureshi. Mr. Qureshi is a barrister, a King's Counsel, an experienced arbitrator, a law professor with a number of prominent universities, so there's a lot of things to introduce, but I think the most prominent part will be the report of Khawar itself, and it will be a review on the key decisions related to the bias of arbitrators.
Good morning, ladies and gentlemen. Thank you, Anna, for your very kind introduction. Can I begin by thanking our colleagues at the Russian Arbitration Center for inviting not just myself, but other colleagues from diverse jurisdictions, from the Far East, from mainland Europe. We still are a part of Europe, even though we decided that we were going to leave the European Union, and elsewhere. I'm delighted to be here after 5 years, and I look forward to coming again soon. To answer some of the questions that Sebastian's raised, he mentioned the Ruskem case and the decision of the Supreme Court. That was a decision that was issued by the Supreme Court on the 18th of September 2024. On the 24th of February of this year, the Arbitration Act 2025 came into effect, and Section 6A of the Arbitration Act provides that in the absence of an express choice of law for the arbitration agreement, it is the law of the seat that will apply. Hence, in that case, you would have had French law applying where the arbitration was seated in Paris. We can discuss the Ruskem and Unicredit case subsequently. Is there deadlock? Is there stalemate? I'm more than happy to discuss that. Sanctions are a very vexed issue. The right of access to justice is fundamental to states and parties, irrespective of their background. And that's something that I and many of us in the room feel strongly about. Conflict of interest, bias. Just some context, you have a copy of the paper that was produced. The paper contains a review of cases between 2022 and 2024 from ICSID, investment treaty cases, the PCA, UNCITRAL-related investment treaty cases, and the English Arbitration Act cases. If you want a more expansive review, we can go back much further and you can ask me for details. But the key points that I want to identify are essentially as follows. Firstly, when it comes to independence, what does that mean? Independence means avoiding relationships that can give rise to a conflict of interest. And what does impartiality mean? Meaning being able to apply one's mind free of bias, actual or apparent, ostensible. What we're seeing so far as the international arbitral institutions are concerned is a convergence of standards. The standards are unifying. What I want to do very briefly is identify for you what the standards are. But let's just pause to understand why is this important in the context of arbitration. Two reasons. Firstly, arbitration, if it is to be successful, it must maintain the trust of the parties. Equally, if the opt-out from the jurisdiction of the courts, except and insofar as there is a supervisory jurisdiction to ensure fundamental requirements are complied with, whether it's supervising the process, the supervisory court of the seat, or enforcement, ensuring that the New York Convention requirements have been complied with for an incoming arbitration award. This is because states have decided for decades, not least since the New York Convention of 1958 came into effect, that commercial parties and others wanted to opt out of the court process, and they were given freedom to choose so long as arbitrators behaved in a certain manner. And that manner is ensuring that they act fairly, ensuring they act impartially. But those duties come from contract. The duties that are imposed upon arbitrators are very similar to those that judges are supposed to comply with. Certainly in our jurisdiction in the United Kingdom, the test for arbitrators is the same for judges. We have had numerous cases of our courts. There's a case called Lockebell of the House of Lords, and more recently a case called Halliburton and Chubb, where it was confirmed that arbitrators must comply with duties which are reflective of the duties of judges. Judges owe their existence to statute, to constitutions. Their appointments are permanent. They cannot be removed except in very exceptional circumstances. Arbitrators are chosen. They're appointed by contract. So is there a fundamental difference in the existence of the arbitral tribunal and arbitrators that means that they must, of necessity, behave differently? So far as the rules are concerned, many of you will be familiar with the ICSID rules. Article 14 provides that arbitrators must be individuals of high moral character who are capable of exercising independent judgment. And they can be disqualified pursuant to Article 57 if there is a manifest lack of those qualities. The PCA rules of 2012, Article 11 provides a duty of disclosure. In England, the question that arose for the Supreme Court in a case called Halliburton and Chubb was, where does this duty of disclosure come from? And in England, the question has been answered by the Supreme Court that there is a duty of disclosure, but now again through the Arbitration Act 2025, there is a statutory duty of disclosure, Section 23A of the Arbitration Act. But there's a duty on arbitrators to disclose circumstances that are likely to give rise to justifiable doubts as to impartiality or independence. ICC rules of 2021. Likewise, Article 11, the duty of disclosure, and Article 14, the grounds for challenge. The LCI rules of 2020, that arbitrators must remain at all times impartial and independent of the parties. That's Article 5.3. An arbitrator can be removed by the LCI court if they're unfit. And what does that mean? Not whether or not they can do the treadmill for 5 minutes without having a cardiac arrest, but they don't act fairly or impartially between the parties. In the paper, you'll see that the LCIA has published anonymized decisions relating to challenges to arbitrators. 24 decisions between 2017 and 2024, of which only 2 challenges were upheld, so less than 10%. The SIAC rules, there are individuals here representing SIAC. Article 11, Article 14 reflect independence, impartiality. Hong Kong International Arbitration Center, likewise. And last, but by no means least, of course, the Russian Arbitration Center. The rules of 2021, Article 14.5, reflect the impartiality independence test. And our statute, the English statute, it's the Arbitration Act, Section 24.1, where if there are justifiable doubts as to the lack of independence and impartiality of an arbitrator, he or she can be removed. Now, all of you will be aware of the IBA guidelines on conflict of interest of 2004. You'll remember that they were then amended in 2014, and they were updated again in 2024. I can tell you in England, when they were first adopted in 2004, there were many arbitrators, many very distinguished arbitrators, whose view was this is totally unnecessary. Whether you call it soft law, whether you call it codification, arbitrators know how to behave, and they don't need these principles. As we can see from the decisions which we'll turn to, unfortunately, there are still some arbitrations who perhaps lapse of memory or lack of experience or sheer arrogance, unfortunately, have decided to behave in a way that has meant that they've been held to account by courts or other tribunals. And it's interesting that in 2024, the IBA guidelines were updated. You also should look at the 1987 general standards that were provided for by the IBA, the rules of ethics for international arbitration. But the 2024 guidelines look at General Standard 1, which provides for impartiality and independence. Look at General Standard 2, which imposes a duty on arbitrators to decline appointments or to cease to continue to act if they doubt their own ability to act in an impartial or independent manner. I suspect that's a general standard that is more honored in the breach or than the observance, because I've yet to come across a situation where an arbitrator has decided to inform the parties during the reference that somehow overnight they've realized that they can no longer act independently and impartially. And that's perhaps just a reminder to arbitrators what their duties are. Let me give you examples of how this provision works. There is what's called the red list, the orange list, and the green list, for those of you who are not familiar. There is the non-waivable red list, i.e. red flag, don't come in, or get out. It's like the sending off. 1.4 of the guidelines provides that this is a non-waivable red list item, where the arbitrator currently or regularly advises a party or an affiliate of a party, and the arbitrator or their firm derives significant financial income from that advice. That's non-waivable. That gives you an idea of where arbitrators should not be participating. What's a waivable red indication? It's Article 2.3.8. If there is a close family member of the arbitrator who has a significant financial or personal interest in one of the parties, or an affiliate of one of the parties, so it could be husband, wife, son, daughter, brother, sister, so long as the arbitrator declares, the other party may waive that. I suspect that's highly unlikely to happen. Certainly unlikely to happen if it's a sole arbitrator, I would expect. Orange, their disclosure is necessary whether or not you can be asked to step aside, debatable. 3.1.1, where the services have been provided for one of the parties in the case within the past 3 years as counsel for the party or its affiliates. Now, the green list, this is an interesting element. We'll come to how in the investment treaty context, what arbitrators have written, whether in awards or in lectures or even voting, the voting patterns for resolutions of certain institutions have given rise to challenges. 4.1.1 is an interesting provision. This is green list, which means this is okay. The arbitrator has previously expressed a legal opinion, such as in a law review, article, or public lecture, concerning an issue that also arises in the arbitration. But this opinion is not focused on the case. Now, of course, arbitrator challenges are fact-sensitive. The touchstone is independence and impartiality. And as these different rules illustrate, there is a convergence. The standard is independence, impartiality, reasonable doubts, justifiable doubts. The obligation on the party that identifies such doubts is to challenge promptly, not to delay, because that might constitute a waiver. Let me give you 3 examples from the investment treaty context of two examples of successful challenges, one failed challenge. The failed challenge relates to some extent to the new provision 4.1.1 expressions of view. Let's start with the PCA UNCITRAL decision. Deutsche Lufthansa versus Venezuela. Lufthansa, of course, airline that some of us travel on less frequently than perhaps we used to. A decision of the Secretary General of the PCA, Martin Zeppelek, of the 10th of October 2022. What were the facts? there was a BIT claim brought under the German Venezuela BIT by Lufthansa. It concerned the treatment of the airline's income derived from Venezuelan activities. The claimant, Lufthansa, appointed an arbitrator called Wolfgang Peter, a well-known Swiss arbitrator, who also has an affiliation with a South Korean firm, so it's Peter and Kim. There was an application made by Venezuela to disqualify Wolfgang Peter. On what basis? It was on the basis that one of his colleagues, Professor Pierre Tercier, who is known to many of us and respected by many of us, had in another arbitration, a claim brought by Air Canada versus Venezuela, been involved in the issuance of an award where the claim was substantially the same. There were 4 reasons that the Secretary General gave for upholding the disqualification challenge. First, the parallels between the 2 cases were evident. Second, that the arbitrator's independence and impartiality might be affected by the activities of other members of their law firm, in this case, Professor Pierre Tercier. Third, that the selection of Mr. Tercier's colleague, Wolfgang Peter, by Lufthansa, given that Air Canada had used Pierre Tercier, would appear to a reasonable and informed third party, not a paranoid party, the test is a reasonable and informed third party, to be more than a coincidence. And last, that looking at the situation in an extreme manner, Mr. Wolfgang Peter, Dr. Wolfgang Peter, would potentially have to call into question the judgment of a close colleague of his, Professor Pierre Tercier, if he was going to disagree with him, on a substantially similar factual legal matter. The second case, a case called Optima Ventures versus USA. The chairman of the administrative committee on the 20th of December 2022 had to decide whether, in the context of ICSID, Articles 14 and 57 were engaged. The USA had appointed an individual. The award described him as Mr. M. He's generally known as Professor M. He's the subject of a challenge in another case called ABHH versus Ukraine. And the question was whether the fact that this individual had been employed by the United States government in the past, more than 12 years previously, but was currently also employed by the US state, gave rise to a ground to challenge. The conclusion was that the past employment didn't give rise to grounds for challenge. There was nothing in the rules that prohibited the connection, the employment connection. Of course, you'd have thought that being able to exercise independent judgment means actually being independent of the party that's appointing you and not being an employee. But the conclusion was that the fact that he was currently employed created a manifest appearance that he lacked impartiality. Now, the last case that I want to refer to within the investment treaty context, and then look at some English cases before drawing some conclusions. The Silver Bull in Mexico case, a decision of the 21st of October of last year, an ICSID case. The background, Professor Philippe Sanz in an arbitral award attached a separate decision on the question of costs. And on the question of costs, Professor Sanz decided to engage in a discourse about the availability of third-party funding and the potential impact of third-party funding within the context of investment treaty disputes. The context was what Professor Philippe Sanz perceived as the disproportionate costs being claimed by the claimant's lawyers in comparison with the state's lawyers, money multiples of the level of costs being claimed by the state's lawyers. And the fact that this note was in the public domain, because of course ICSID decisions, much that emanates from ICSID is in the public domain, save where ICSID provides redacted decisions, this, it was argued by the claimants, gave rise to potential grounds to indicate that he lacked independent judgment, that he was predisposed in a hostile way towards parties that were third-party funded. The other two arbitrators concluded that all that the article had done was identified certain risks created by a system of third-party funding, but there was nothing in the article to suggest that Professor Philippe Sanz had displayed any hostility per se to parties that had third-party funding. Now let me turn to the United Kingdom and two very recent cases from the English courts to demonstrate the levels at which the English court will intervene with regards to arbitrator challenges. The first case is, of course, a case called H1 versus W. Now, you may be asking yourselves, why H1 versus W? What's one of the virtues of arbitration? Perceived virtues, confidentiality. As a consequence, our courts will start from the position that the names of the parties are to be kept confidential unless the public interest requires otherwise. The leading authority is, in fact, a decision concerning the Moscow City, a decision of 2004 of the Court of Appeal. So what was the case all about? It was a case about a claim under an insurance policy. An actor had been injured, a stunt had gone wrong, he'd been badly burned, the insurers declined insurance on the basis that what had happened was risk assumed by this actor. He shouldn't have been throwing a Molotov cocktail, which then ignited and burnt his arm. That was not the sort of thing that you do. But it was said that this was catered for by the stunt coordinator. Question, sole arbitrator appointed. Sole arbitrator made the observation, I don't need to hear the defendant's experts. I know who they are. But I don't know who the claimant's experts are. Does that give rise to justifiable doubts as to impartiality? Conclusion of the court, yes. Final case. Case called ATO versus
I'm very
Shell.
sorry, Khawar, there's just 1 minute left,
Sorry?
okay? Just 1 minute.
Yes, of course. ATO versus Shell. A retired judge of the Court of Appeal challenged. She had omitted to disclose the fact that she had been instructed by the law firm for Shell, Freshfields, to provide legal advice, to provide expert opinions, and had participated as a party-appointed arbitrator on multiple occasions, but had failed to disclose that. It's the failure to disclose that gave rise to the conclusion that she had to be disqualified. Ultimate conclusions. I know there's a lot of discussion about friendly, unfriendly jurisdictions and the difficulties in terms of traveling, difficulties in terms of paying lawyers. Have those eased up? We can have a discussion about that. The key question, I believe, is not trying to identify which is a friendly or unfriendly jurisdiction. It's engaging with the arbitral process effectively, choosing arbitrators who demonstrate those characteristics of independence, impartiality, and credibility, being very careful where you challenge arbitrators, because very few challenges succeed, being courteous when you challenge, being prompt in your challenge. So far as arbitrators are concerned, recognizing that disclosure is of fundamental importance. When in doubt, disclose. Repeat appointments, problematic. The biggest area that's vexed now is, of course, investment treaty arbitration world, where awards are public. You can see the decisions that arbitrators are making, and then there is a very serious concern about the political context and whether or not we now have to move to a phase where you can't be arbitrator and counsel at the same time. Thank you.
Khawar, that was, I think, extremely interesting, and a lot of space to think about. And now, once again, turning to Russian, коллеги, сейчас у нас есть возможность.
Colleagues, now we can discuss what you have heard. You can put your questions to the speakers. There are microphones, and you can use them in order to put questions to the speakers, and the organizers will help you with using the microphones.
I have a quick question to Mr. Qureshi. As you know, in Astana, Kazakhstan, we have AIFC arbitration rules, which are like very similar to LCA rules. So I had a situation where we were challenging an arbitrator, and we were challenging him within 14 days of the moment I became aware of the grounds for the challenge. And that challenge was rejected by an ex-English High Court judge on the basis that we didn't file the challenge within 14 days of the formation of the tribunal. No one knew how long it would take to form the tribunal, so we acted on the basis that it would be safer to assume that 14 days from the moment I learned. So my conclusion is that we should be filing the challenge like 2 times, 14 days from the moment I learned, 14 days from the moment the tribunal was formed. So what would be your recommendation in that case?
Hear me? Promptly is the point that I made right at the outset. And my advice would be, as soon as you become aware of facts that give rise to grounds to challenge, don't delay. I don't know who the judge was, we can talk about it afterwards, but you have an appellate who was it? You have an appellate process in the EIFC, don't you? So I would engage that.
Thank you for your talks, to all the panelists. My first question is to Mr. Qureshi as well. I just wanted to follow up quickly on the justifiable grounds to removal, because you were talking about the impartiality and, justifiable grounds, and I was just wondering if you could share your opinion, if we could consider justifiable grounds to be political views, because it's not something that's employment connected, it's not something that's council connected, but it's mostly, I think it's something that's most important to the process, and it's not something that you can put into, something that is considered and connected to the practice that we usually have had. It's mostly something that's new, so I was just wondering if you could share your opinion on that. Thank you.
This is a really tricky question, because a very smart, astute arbitrator will smile at you, will be very nice with you, especially during the coffee breaks, and they will not disclose how they feel. It's similar to judges. It will be an unwise individual who doesn't recognize the potential for their challenge, who leaks with regards to their political views. But if somebody is unwise enough to express their political views, and they are views that might impact upon decision-making that they're engaged in, let's say, for example, arbitrations involving Crimea, let's say, and they've expressed views that are potentially critical of a certain state or the conduct of a state, and that state's conduct might be engaged in the process, then I can see circumstances where the arbitrator might be challenged. But what we do know is that in a spate of cases involving the Russian Federation, the Institute of International Law, IDI, in France in March 2022 adopted a declaration which was supposed to be confidential, and the members of the IDI, somehow that declaration was leaked, and those who adopted that, who were in favor of that declaration, have been challenged, and those challenges have not been successful. So it comes back to the point that I made right from the outset. It's really very tricky and precarious to go down this highly subjective route of friendly, unfriendly countries. We know that we can have our closest relatives who can be far more hostile than people who are strangers. Hence, I wouldn't want to use the concept of friendly, unfriendly jurisdictions, because it's so transient. There was a jurisdiction that I know of that was friendly to this jurisdiction until recently, and is now deemed to be unfriendly. So how? Likewise, when you're chopping and changing with regards to institutions, I would suggest it's better not to create this sense of schizophrenia when it comes to maps and identifying where a red pin goes and trying to delete references to certain seats. Stand firm, understand there is virtue in the process, and understand that good arbitrators who exercise independent judgment and are impartial and are credible will try to reach the right decision. That's the key. Always remember that it's about these individuals. It might be difficult to come to London, but that difficulty is eased. It might be difficult to pay lawyers, but that difficulty is eased. Those difficulties can be, to some extent, overcome. Please do not abstain from the process. Do not reject the process. Engage with it. Over the past 35 years, there are countless examples I can give you of people who've decided, or states that have decided, we're not going to get a fair hearing, so we're not going to bother. And that's the wrong approach, with the greatest respect. We can all sit in this room and criticize different jurisdictions for their approach. I'm not sure that there is much to be gained, say, from giving them a reality check, but ultimately continue to engage.
Can I just follow up on what you've said? Your question and, of course, what you've said. In concrete terms, I think we all discuss about abstractly, what it means to be independent, not dependent, express political views, not express political views, challenge or not. At the end of the day, it is rather pragmatic, and it has to be rather practical. And I can just share very quickly an example I just had. So basically, there was an arbitration in Stockholm. One of the parties was Russian, one of the parties was non-Russian. The tribunal was composed of 3 Westerners, 3 English barristers, and eventually one of the barristers published things which were outrageously against the interest of Russian parties. A challenge was filed, and the challenge was dismissed because the arbitrator said that it was taken out of context and that it didn't change the fact that he would remain independent and impartial from the parties. Now, from a practical perspective, what choice do you have? You can, of course, go before the courts in Stockholm, but you have a very short period of time to do so. And hiring a lawyer in Stockholm, where you are a Russian sanctioned party, is quasi-impossible. So to file a challenge within that very short period of time proved to be almost impossible. So you're basically left with a decision where you end up with someone who you thought should have been removed, eventually wasn't removed, and the decision is not justified. Now you receive basically a letter from the SEC with 2 lines saying the challenge is dismissed, no explanation, nothing. You cannot challenge, and you have a client which tells you 2 things. First of all, the client tells you what we will do is that at the end of the day, we will basically challenge the enforcement relying on what the Supreme Court has said. In the first place, we have 3 members tribunal who are from the West. Basically, they are considered by definition not to be independent or impartial. And on top of that, we have one who made, these declarations. Practically speaking, this is what happens. Will the judgment be enforced in Russia? Very much unlikely at the end of the day. And just to finish on that, the question in those circumstances you are being asked by your client is it really worth fighting in those circumstances? And I agree with the point, you should engage. And you will certainly hear many lawyers telling you should engage. And I think we deeply mean it. But clients tell you sometimes, it's a political question whether to engage or not. And certain clients tell you we're not going to engage because it's a political question, and in light of the circumstances, and more importantly, in light of the tribunal which has expressed such views, and where one of the members was not removed, we are not going to engage. So there's also the difference between what we say in abstracto and how it translates into practice. But I agree with you.
Forgive me, just on that point, the example you've given is probably the individual who has wisdom in very short supply. There is, and I don't know who it is, in the room we have Tatiana Minaeva. Tatiana, are you here? Tatiana can give you a concrete example of a case that's now in the public domain where precisely that situation where the entity which is connected to the Russian Federation didn't engage. And it's an entity that should have engaged. Despite the fact that it didn't engage, the award was issued in a manner which was in its favor. Tatiana, I'm not sure if anybody can give you a microphone. Can you just share that experience with us? You don't want to? All right. Apparently, it's you can find it in different fora. She's sitting there. Ask her where you can read about it. I know about it. 2 silks, 2 English KCs, the state entity which supplies material that forms the basis for energy, ends with prom, didn't engage, but yet the award was issued in a manner which was rejecting the claim against it. So what does that tell you? It tells you exactly what I've been trying to say. It's very easy to be cynical, and I can be extremely cynical after 35 years in the profession, having acted for clients from all over the world and seeing my own profession abandon the Russian Federation in March 2022, and disgracefully. But that's not the way you approach arbitration or court. That's not the way you're going to succeed. We can all have extremely difficult cases, extremely challenging cases, but I'm certainly not an advocate for cynicism. Not here, not ever. Thank you.
Thank you. Can you hear me? Thank you very much, speakers, for gracing us with your presence today. I wanted to echo perhaps depart from what Sebastiano mentioned, but anybody can seize himself of the question if wishes so. Discussing the deadlock of international arbitration. Well, it would really be a deadlock if it was not moving. But I mean, recent developments have shown that it is moving, and in what direction? In less protection for international arbitration. Whether it's the new reform in English law that would not permit an English court to issue an anti-suit injunction when the arbitration is seated abroad, or whether it's the new use of the 248.2 to target arbitrators and counsels and hold them liable if they were to proceed with the arbitration. So in my own mind, it wouldn't be so much of a deadlock rather than a diminishment of the potential of international arbitration. Would you concur with this position or not?
The way you phrased it, sorry, I answered, but of course, I mean, the way you phrased it, indeed, is right. It's moving and in the wrong direction. When I use the term deadlock, I mean we're in a situation where we're witnessing a situation where there is little way out when it comes to having one dispute between 2 or more parties adjudicated in one and only forum, and naturally the forum which the parties have agreed on in their contract. Let's be honest, I mean, it's not a deadlock, the system is broken. The system is completely broken. And that's the problem, and we can of course engage into a long discussion with the institution of anti-suit injunction and whether anti-suit injunction actually assist or make that more complicated or worse, but it doesn't work. It doesn't work anymore when it comes to arbitration, and when you have basically state courts intervening and saying in one case, no, arbitration agreements don't work anymore, and I prevent you from doing anything else, failing which you will have to pay huge fines, and another party saying, or another party going to another country and saying you have to prevent them from doing that. And you have arbitral tribunals in the middle, which continue their work most of the time, if they can, and now which are facing indeed a difficult situation with the latest, let's say, procedural steps that have been taken under 2482 against arbitrators. So yes, the system, I think, in my view, doesn't work, is broken, and it also showcases something. Arbitration is a system which is fragile, which is extremely fragile, and it only works where not only all the stakeholders, i.e. the parties, the arbitrators, but also state courts play the game. If one of the stakeholders stops playing the game, the system just doesn't work anymore.
My name is Bernardo Cremades. I wanted to ask you, Sebastiano, the following question. Put yourself in the shoes of an arbitrator, not being in England, not being in Russia. Are we entitled to distinguish, when we talk about public policy, about political considerations, or when we have to enforce pacta sunt servanda, are we committed just because there are some sanctions? The same thing happens with the exequatur judge. Is he entitled to consider if there are international public policy from the legal point of view, or it's just political issue? We, the arbitrators, we, the judges, we are not committed by the political issues. We are committed by the transnational public policy, but not for the political. What is your considerations about that?
Yes, it works now. Thank you, Professor. I mean, you're asking me a question. I mean, I should be the one asking the questions, and you give us. I think it's a very complicated topic, because when it comes to state courts, you made a parallel with state courts and the enforcement point with state courts. I think state courts are indeed much more under the influence of the country they are based, because by definition also, when you have to enforce an arbitral award somewhere, you have certain notions where international public policy is considered. And in certain countries, that notion of international public policy is slightly different when they have to enforce an award. And you can very well see it. I mean, for instance, if we take Russia, I mean, they have a vision of international public policy where have they basically brought in certain concepts when it comes to enforcing awards in the sanctions context, which is different from other countries. Now, when it comes to arbitrators, where I fully agree with you is that arbitrators should be immune to a certain extent from politics on all levels. They should be immune on politics when they have to decide on a case. They should be immune from politics from the supervising courts, from the government, from anyone. Do they have to take on board? And that's another topic, and we can discuss for a long time. The question is, are arbitrators nowadays, and I had the privilege to discuss that point with Professor Al-Wahhab in Paris, are arbitrators more and more politicized? Because they are more and more involved into disputes with a political aspect of things. And that's also another issue. Are arbitrators nowadays completely immune from political consideration, or aren't they used in a way or other in the context of political issues where they even have to decide on aspects which become truly political aspects? But on the point of transnational, international law as a matter of public policy, I agree with you, but it's still, of course, debatable nowadays whether we should just restrain that to the transnational legal aspect of things, or whether we should sort of narrow down to certain concepts. But again, we could discuss that for a long time, because there are many issues which you have raised with your question.
For the Q&A session is now expired. I'm very sorry for those who didn't have the time to ask their questions, but I'm very certain that all of you may continue our discussion during the coffee break. I think we have earned some coffee. Before we go, I would ask you, I hope you don't mind, to say a huge thank you to all the speakers of this part.
Distinguished colleagues, we do understand that you want to have tea, have conversations, eat cookies, and so on. But still, let's continue our session. Please enter the room urgently. And if you are here, please note that we are starting right now, and the rest of the people are going to join us. And now we continue our session. So once again, we're going to discuss general issues in arbitration. It's like theater, it's the last call. And the first speaker is going to be Sergei Lisov, head of one of the attorneys of the firm Monastyrsky, Dzuba, Stepanov and Partners, and he is going to talk about the security for course orders against Russian companies. And a lot of presentations today, naturally, are dedicated to some traditional issues of arbitration, because interim relief, well, that's quite traditional, but today we can see the new dimension. What is to be done if the party is under sanctions? And Sergei is going to talk about Russian participants, which is going to be important in Sergei's presentation. He's suggesting some very specific practical ways of getting out of this situation. Sergei, you have about 20 minutes. Good afternoon, distinguished colleagues. I am grateful to Anna for organizing this session, and I would like to thank the Legal Academy and Russian Arbitration Center. It could be easier to make that presentation in English, but I tried to prepare some of the slides in English also. When I ask myself question, what am I going to talk about at the Russian Arbitration Day? So it took 1 year to gather all the information, all the articles. That's quite an important event, also research event. I wanted to be as far away from sanctions as possible, because my application had a better chance, because sanctions is something everybody is talking about. But frankly, I am fed up with going to the conferences and talking about decisions regarding jurisdiction of Russian courts and so on. And I wanted to talk about the future. I wanted to think about what's going to happen to Russian parties in the framework of international commercial arbitration, and what kinds of practical solutions could be there. One of the issues that we encountered, and also this is a problem for many participants of arbitration in Russia, so those are the security for costs rulings, based on the fact that Russian courts don't recognize foreign arbitral awards against foreign companies. And we're going to look at the slides. Well, here we can see the issues that rejection of the award is the precondition regarding security for costs. If the company cannot, for companies under sanctions, it could be difficult to pay even arbitration fees, because some arbitral institutions, LCIA, take the fees only from the representatives of the country or from the country. So if there is a company which is a Russian company that has certain difficulties of making payments abroad, so they have to hire new representatives. So the more structured is the payment, the more expensive it is. So it's hard to pay the fees, but it's also paying for the costs. It's even more difficult. there is a great risk that getting back the security for costs in case Russian company wins. So is it going to be corresponding with the Rule 11? And because there are positions of certain arbitration institutions that when you overpay the fees, the money is not going to be given back to you, and there is a risk that there is a similar fate which is going to be encountered by companies in arbitration. The issue is quite topical, and the lawyers that represent Russian companies encounter that, and it's not a secret at all. And foreign court rulings and foreign arbitral awards are recognized in Russia, and the companies win the cases. Maybe you heard in the news, and a lot of colleagues here in this room. So that was the victory of Interallo and Power Machines, and also Uralkali and Sibur and Gilon. At the same time, certain rulings were recognized and enforced in Russia, although those were the rulings made in foreign unfriendly jurisdictions. But there are also LCIA, SCC, FOSFA, and Korean arbitration court rulings were not recognized in Russia. The awards were not recognized in Russia. And here the ruling was against a Russian company. And here Russian companies are respondents mostly. The reasons are different. Now, for example, not recognizing the Korean award, it was said that it's the plaintiff is part of the same group of the companies of defense holding company. Accordingly, there is a probability that enforcement of the ruling or the award is going to lead to the situation when the weapons are going to be shipped to certain countries that we wouldn't like to have. For example, there is an article written by Marike and Ingeborg Edel, which is called Security for Costs Against Non-Sanctioned Russian Claimants, an overview under the Vienna Rules. And this article provides several examples. And one of those examples is the rejection of LCIA award by Stavropol Court. And the authors are analyzing the situation of how does it look from the point of view of Vienna rules. So how could it lead to security for costs ruling? Some regulations overview. So what is the basis for the arbitration tribunals regarding security for costs? So we have the CARB recommendations. They have, it's maybe the best document, and only in the latest editions of arbitral rules they started having the provisions that work with security for costs orders. Before that, the parties actually referred to CARB leadership and the criteria, the prospects of the success, the ability of the plaintiff to provide security for costs, also fairness criterion is there, and we're going to come back to it because fairness, equity is extremely important here, and it's suitable in this situation. There is an exceed rule which regulates investment hearings. Nevertheless, they provide quite detailed recommendations regarding just paying for costs, and also there is an example of Vienna arbitration rules, how the arbitration rules provide the provisions regarding arbitral costs. If the party can prove that the possibility of compensating the costs is under the threat. And the researchers that were specified before, Marike Dobrich and Ingeborg Redl, they believe that it's the trend of the approach, protectionist approach of Russian courts. So when we looked at the ratio of actually protectionist approach and security for costs, and professor in Hong Kong specified that when it's difficult to get to the assets because of protectionist trends, it's one of the reasons for security for costs. And this approach, a biased approach, is taken into consideration. And this trend is not brand new. And several years ago, there was a court ruling in England, Tetneft versus Boголюбов, and that was about interim relief, security for costs, and that's quite a useful guideline. But I would like to get to the ways to deal with those issues, because you do understand that the problem is there. The problem is quite topical and significant. And one of the reasons, here I provided the metrics of the arguments that usually exist when there is an application regarding security for costs, apart from the statement that it's not fair. And the first reason, which is provided, it says that financial position must be the main criterion for interim relief. It's specified in SCC guidelines regarding such applications, in particular in practice review of SCC, that first of all, you have to take into consideration the financial position. If a Russian party is in a good financial position, it could be one of the reasons against such an application. So if you get all the criteria, first you have to prove that the ruling of the arbitrators is going to be based on the country risk only, and there are no other reasonable arguments, and it's not acceptable to discriminate upon a party, but it's not enough. And if Russian courts don't recognize arbitral awards soon enough, that information is going to be conveyed to the tribunal and would be evaluated. So here's argument number 3. So unacceptability of taking advantage of procedural rights. You can say that the opponent is the only means of the opponent is to hinder the proceedings. If the security for costs ruling is not actually enforced, which is difficult to enforce, it could be a roadblock for the case. Then we can look at the assets in foreign jurisdiction. You cannot enforce the ruling in Russia when you disclose information about assets abroad. When the assets are frozen, it's not that bad. And a lot of companies had a lot of publicly available information regarding assets abroad. That could be an important argument against the decision. The possibility of enforcement, not just in Russia. Good faith behavior following other arbitral awards, counterclaim regarding security for costs, and also objections regarding the sum of money and the format. Quite often, the security for costs doesn't correspond with actual costs of the party, and in this case, it doesn't lead to total rejection, but at least it could lead to lower sum of money. Then you could think about alternative means. For example, if the Russian party encountered the security for costs order and you have to do something about it, well, it's much better to start thinking about it when you initiate the arbitration proceedings. And if you're a Russian plaintiff, you're going to encounter that problem. You should start thinking about it. You should start taking consideration the abilities of the client working with the jurisdiction. You have to conduct consultations with the colleagues. What can be done in friendly jurisdictions? What are the means of having a cash deposit, some guarantees, and so on? Escrow accounts in a friendly jurisdiction. In Kazakhstan, Serbia, and we didn't have practical experience in those jurisdictions. And we managed to get to 2 countries. Naturally, I cannot vouch for all of them, but these are the examples what you can think about to minimize the risks. Secondly, using Russian arbitration institutions with foreign offices. One of them is organizing this event here today, and you can get to the website of that organization and can find the arbitration offices of that organization. Also, it's possible to pay arbitration fees using foreign accounts, and maybe it's possible to deposit some arbitration costs in friendly jurisdictions. Why friendly jurisdiction is important? Because getting back the funds could be also threatened by sanctions. Also putting the funds through the notary public, it's something that works in Russia but doesn't always work abroad. And also bank guarantees, independent guarantees instead of deposits, but there must be a guarantor, must be some kind of a foreign entity. For example, a foreign company which is part of a Russian group or owned by the Russian group of companies, and the guarantees could be issued to by the company, or if it failed to happen, so you can have the guarantee of a foreign bank. Russian companies, notwithstanding the fact that a lot of institutions take advantage of exclusive jurisdiction of Russian courts, they need arbitration to get enforceable awards, and they very dynamically participate in arbitration. In order for this participation not to be hindered, we have to think how to oppose those security focus orders, and you have to think over how it could be enforced if you failed to win that battle, so that the defeat is as painless as possible and you could continue your work quite quickly and you don't waste a lot of time. And you have to think about the ways of enforcement. Thank you.
Большое спасибо.
Thank you, Sergey. And you have complied with our time limit, and it was very interesting. So we have 4 presentations to consider, so you can ask questions later on. So now, more postgraduate students will discuss Euro-Novid Courier principle in international commercial arbitration. The presentation is very interesting. I invite you to listen to it attentively. So I'd like to start with the fact that the Roman maxima is used in modern arbitration. And this principle makes it possible. Let me show you the slides, says the speaker. Here it is. So the principle does not bind the arbitrator with the arguments of the parties as far as facts of the case are concerned, and the arbitrator can go beyond what was presented by the parties, and thus we can see a kind of transfer of those things that were used in the state courts over to arbitration proceedings. Here's an example. Arbitrators may be independent to refer to those issues which they consider important, but the parties did not mention it even. And the next problem is how does it comply with the fundamental principles of international commercial arbitration, which is called autonomy of parties, and the principle of equitable relation to parties, aut alteram partem, the risks of violating the law or the right to be heard, taking into account these new arguments which, or rather not these, but other arguments which have been found by the arbitrator, can change the entire thing. Also, we should take into consideration the fact that within the principle of Euro-Novid Courier, the powers may be a little bit different in different legal systems. Thus, the state courts, while checking the arbitration awards and their enforceability and other aspects, they should recognize these powers because they are guided by their own understanding of certain national institutions, and they can rely upon their own understanding of certain things. That is why it is important to have specialized regulation for arbitration to be used at the international level. But it's lacking at the moment, and there are various approaches. There are various regulations, like Article 7, Prague accumulations. We have recommendations of 2008, and these are sources of soft law. And also it should be mentioned that the Uranovit-Curia principles is used for material law, but in this case, it doesn't deal with the refusal to enforce the award, but it also deals with the enforceability of the arbitral award. And thus, to what extent this principle is, or maybe it should be used. And it must be stressed that we can go over to the theories which vary. It is not only the question of how to use it. The traditional theory says that the principles the court knows the law used in arbitration and in courts is one and the same thing. The theory is correct, but for a limited number of cases. And it goes for Switzerland, for example, where this principle is part of arbitration proceedings. And there it is, in a way, limited also. The second theory is adaptive theory, and it says that the principle should be adapted to the special features of international commercial arbitration. And the ex officio judge also uses this principle. In the context of international commercial arbitration, we cannot use it entirely. Only in one case, it is a kind of obligation of the arbitrators, which deals with the costs, time of arbitration, and it's mixed here. And it's a mixed theory which is most widely used. This is a product of convergence of various things, and it gives grounds for certain relations of court and international law. And the facts and issues of law vary in different countries, like in Germany, for example, Switzerland, France. And in the United States, it's a matter of facts, more than that. And thus you have to prove the content of the applicable law. And from Roman German system, proactive features have been borrowed, and from the American system, lack of certain obligations. And it is interesting that there's a kind of procedural culture which differs in those countries. In common law countries, they mostly focus on studying the sources of law. Unlike civil law, countries like Germany, it's rather a must and not an initiative. And the fourth theory is autonomy theory. Uranovit-Curia is unacceptable for commercial arbitration. It's a different institution, and it is formed as a result of search for special rules. I don't think it's correct to say so, because actually Switzerland uses it as a part of arbitration law, and the arbitrators have their own opinion of how it should be used. So, in terms of legal analysis, we can have it at two levels. The first level is comparison of Roman, German, and American systems. And here, German and Roman countries, they do not regulate it at the arbitration level and mostly concentrate on the arbitration practice, while in the American legal system, there is a special regulation which provides for arbiters discretionary powers, like 34.2 article of the arbitration regulations, which provides for the proofs and procedural issues, and it gives grounds for the extent to which it should be used. And this is a kind of changing principle, because the arbitrator can comply on any type of approach if there is consent of the parties, concessional or any other. So, arbitrators may consider it expedient to use even inquisitional approach, like in the international arbitration law. If we use the second level, which is in a way deeper, then we can compare American and European systems, Roman and German systems, and see the variety of approaches. For example, Switzerland and France, they also differ in their approaches, though it's the same legal system. And Switzerland, for example, uses this principle in a very broad way. For example, if we aim at turning or reversing the arbitral award, we can use the special laws where the rights of the arbitrators to be heard have been violated. But since Switzerland is pro-arbitrary jurisdiction, it's not easy to use the principle specifically. For example, if the arbitrator, on his own initiative, uses these norms and not others, this should not be a surprise. It should not be unexpected. You should prove that it was unexpected if necessary. The new arguments, new norms should be cornerstones. In your opinion, you should prove it. And there's opposing position in France, which is due to special features of the national legislation. 116 article of the French Code lays down a special institution which provides for a possibility to provide arguments for any decision. And there are numerous cases which prove that courts of France resort to this approach very often. Finland is a more loyal approach. The Supreme Court of Finland considered a complaint, and the complainant applied to arbitrage for the damages, and he considered the changing of circumstances was not valid as a clause, and he used the law on trade representations, but the law of treaties was used by the other parties, and the respondents who actually lost the case applied to the court. But the Supreme Court says that the arbitrator did not go beyond the limits of his mission, because he remained within the limits of the demands of the parties or the injunctions made by the arbitrators. And thus, this claim was not met, was not satisfied. England and Wales is another example, because this is an interesting jurisdiction. In order to lift the arbitration decision on the basis of the Euro-Novit Kura principles, they should provide grounds such as substantial or serious irregularity, substantial injustice, and also serious irregularity should be proved, not just stated, and substantial injustice should be also proved. But what is it about? Substantial injustice, like by the English judge, it was explained that a party came to know about unfavorable legal norms used by the arbitration too late. For example, the party could not comment on it, could not study it, and could not reverse it in any way, because it was too late when it heard it. Thus, we see that the major limitation for using the principle is the right to be heard by both parties. According to the International Convention, New York Convention in particular, the application of this norm can entail a number of questions. As a rule, this right to be heard goes together with the right of foreseeability. Foreseeability is used differently by different courts, and they can go to opposing outcomes, actually. And in order to give examples, we can cite France, which is very strong in using this principle, Euro-Novit Kura. But the French court will never reverse the arbitration award, only on the basis of general regulations, or like the principle of injustice, etc. Hong Kong is another interesting approach. In the case by China Harding, there was very interesting line of argumentation, because all arbitrations were based on the United States law, and they used as applicable law the law of the New York State, and the court said that arbitrations could be independent in making their decisions. And the logic was that in this case, the parties could not expect that they would violate their right to be heard. In particular, take into account diversity of approaches and differences in regulation. We could resort to best practices and soft law. I think that it is necessary to think of the instruments which could regulate the application of the principle Euro-Novit Kura in international commercial arbitration. And I can also mention another problem which we come across often. The problem usually is not taken into consideration because, unlike the right to be heard and other principles, ne extra petita, so this thing does not affect the enforceability of arbitral awards. It is called due process. The arbitrators are usually aiming at flexibility of approach. But Euro-Novit Kura regulates the application of the law, which law should be applicable. And when parties are attacking their positions, which goes contrary to their own positions, then arbitrators use specific grounds for coming to the decision. The expediency and the effectiveness of arbitration is a kind of limitation to arbitrators. And the non-paradox says that if the arrow is not moving, it will never reach the aim. So if we introduce new regulations, like exchange of documents, submissions, etc., we will never achieve final arbitral award.
So there is a need to keep up the equilibrium, just a consideration. Now the means can essentially be split into two categories. The ones that can be applied before the arbitration, that's ex ante and ex post, the ones that come after the arbitration hearing. So in the first place, you position it firmly in the arbitration law, in the legislation. That is, for instance, if it is about the representation in the arbitration contract, it's called midnight clause because it does not come right away and it does not provide any detailed regulations on these issues. Now, lastly, last year in 2024, the Egyptian arbitrator Abdelwahab published a proposal, his own protocol regarding the application of this principle in arbitration. In particular, this protocol details all of the applications of this principle. And in this way, the authorities, the parties who are using this protocol can provide, suspend, restrict, or rule out some of the powers under this protocol. And he states that this protocol can include the procedural order, for example. You can also provision for terms of preference in this protocol, and there are also some clauses whereby in the terms of reference you can state that the parties agree on the ability of the arbitrator to initiate things in law, and they will not consider it as a breach of impartiality and independence principle. Fourthly, after the inception of the arbitration litigation, the arbitrator has a right to present the stance of the parties on the provisions. Now, if one party learns about a violation or a breach, it should right away report this to the arbitrator so that he can adjust the situation. So the possibility not to confine the arbitrator only to the legal provisions encourages more trust into arbitration as a way to settle any kind of litigation, because the arbitrator then is seen as a missioner initiating and providing for peaceful settlement. Thank you. Thank you very much, Dasil, for this very informed presentation. You can see you are very much in depth into this. Now we're moving on now. Our next speaker is Maria Vinokurova, senior lawyer of Dynwa legal firm. That's drafting on the arbitration clause for merger and acquisition transactions. What to consider in modern Russian reality. This is interesting because you can have many parties in these transactions, and this certainly can be extremely interesting and relevant. Thank you very much, Anna. Thank you, and good afternoon, colleagues. In the first place, I would like to thank the organizers and to join and echo the previous speakers in their thanks for organizing this conference, and thanks very much for the interest in my subject. Well, I believe my subject is somewhat away and aside from the subjects covered by the previous speakers, but I hope it will find some interest in you. In the first place, I would like to do a quick poll of this audience. Could you kindly raise your hands if you have ever supported M&A projects on either side or party of the transaction, if you've ever prepared the arbitration considerations for this contract? Well, that's half the room, right? Excellent. Now, could you kindly raise your hands if you have supported the M&A merger-related disputes. In the first place, of course, I'm interested in arbitration, or if you have heard about such disputes. Well, that's fewer hands, but we still have them, which is certainly excellent. In the first place, a few words about the M&A market in Russia today. On this slide, I'm offering some data on M&A transactions in Russia. That's the statistics published by the information agency called AKNTM. And here you have the data for 2021, 22, 23, and 24. And as you can see, over these 4 years, we are still keeping a pretty high level of merchant acquisition activity in Russia. We see some decrease in terms of the number of transactions in 2025. This is also forecast for 2025 and for the forthcoming years. But at the same time, one can note that the leftmost diagram shows that the average value of a transaction in 2024 had grown quite significantly compared to the previous years. Altogether, by and large, I think these are pretty inspirational data and pretty encouraging, which shows perhaps that the Russian merchant acquisition market is still alive, in spite of the fact that the media are working hard to create tension and mistrust in this. Now, let us move to dispute settlement in merchant acquisitions. I must make a reservation. There are quite a lot of analytical reviews and reports provided by individual law firms, investment companies that generalize the conditions and terms of the transactions which they support. Now, which mode the parties opt for to settle their disputes is always reflected in their reports and reviews. And in my analysis, I can see that 77 to 90% of transactions rely on commercial arbitration. And in this slide, I have a screenshot from the latest published review of the Denmark law firm where I happen to work, and as you can see, 89% of the transactions we supported included the stances, the conditions on settlement via arbitration. Here on this slide, I am demonstrating things that everyone knows of, I believe. That's about the benefits of arbitration compared to the benefits of state courts. Well, in the first place, it's all about the possibility of more detailed and careful examination of the terms of the transaction, documentation, the circumstances related to the transactions, the documentation, correspondence, the involvement of witnesses. It's about the possibility to appoint an arbitrator experienced in many transactions and his understanding of the commercial side of it, which is important for the parties oftentimes, so that they are sure that they will be able to fully present their position to the arbitrators. And also, I need to note the possibility to not only turn to the actual legislation, especially in terms of the enforceable Russian legislation, but also to extend one's vision to the practices available at large in M&A transactions and to the institutions that are already fully established in the English law, for example, and that are not quite as well shaped and available in the Russian law in practice. That is, we see in the Russian state courts, we have pretty scarce numbers of such litigations, such disputes. We lack practice and theory, and so no one really wants to blaze the trail and to do the testing and as we go basing, so as to face with all the costs of this process. All of this goes to demonstrate the importance of the properly formulated and operational arbitration reservation. Now, it is certainly no news that dispute settlement-related issues are not at all the top 5 or top 10 issues whereby the parties of an M&A transaction are ready to fight, to polish it to an almost ideal wording. In most cases, the parties have agreed on the arbitration institution. They've taken the standard reservation, and this certainly is not where they are going to fight to the bitter end. With regard to every single detail, said that it really is critical that this reservation works in the future and that it does its job duly. Now, regarding the selection of the arbitration institution, well, lately in the recent years, we've seen that the Russian arbitration institutions are seen as more beneficial. In particular, the Russian Arbitration Center ranked second is the Hong Kong Arbitration Center, where quite a lot of corporate disputes are administered, including the ones on the Russian law and with regard to the Russian law. So oftentimes the parties opt for Hong Kong as their dispute settlement venue. LCA, ICC, and SAYAC and DIAC are still very popular for arbitration administration and practice. Now, if we were to consider this in greater detail when preparing our arbitration agreement and our arbitration reservation, in the first place, it's a matter of confidentiality. This is at all times critical in M&A transactions, starting with due diligence, the transaction negotiations, the signing of the transaction-related documentation. So the parties are after making sure that the least possible amount of information goes into the media and out to the public, but oftentimes they do not think of what is going to be the future of this confidentiality should a dispute arise. I would call here on the following. I think it makes sense to think about this at the preparation stage, to study the rules of the given arbitration institution, how it treats the confidentiality of the arbitration award and the arbitration procedure, and to consider all of this when you form and word the terms of confidentiality in your contract. And of course, the parties ought to learn more about the regulations applicable in the arbitration venue so that they know how confidentiality is regulated there. And also, ideally, it's how it is regulated where the award is ultimately enforced, if possible. Let me give you a quick example, something we ought to think about right away, whether the parties are ready that the ruling, the judgment on their case will potentially be published on the website of the arbitration institution, arbitration enforcer. This can certainly help to create some particular stance with all the parties. If the parties understand they do not want this to happen, it's easier to agree on this right away when they're preparing the documentation rather than to leave this up to us in the future, where we're going to face much greater difficulties in finding an agreement. Now, here I would like to come back to the poll, the survey we just did with you 5 minutes ago. Why do we see so few arbitration disputes with regard to M&A transactions? I believe it is because this is the area where the parties are very efficient in pre-arbitration dispute settlement. That is, they consider the issues involving the relevant experts, that is the financial experts, the audit companies, mediation, and negotiations with the involvement of the commercial teams of the parties and the legal teams of the parties. In my practice, I've many times seen how the parties have managed to regulate the emerging claims after the agreement has already been concluded and signed, and it really is a very operational, effective mechanism. And it would be great if you could share your own considerations, whether and why the arbitration in merger and acquisition transactions is not as popular and common as with regard to other contracts. Now, considering the alternative dispute settlement, at the stage of preparing the documentation, it's important that it be clearly stated how this regulating is going to be done, what the timelines are for claim regulation and addressing, and also how the ways which the parties take to settle the dispute impact the overall timelines, because in M&A transactions the timeline is quite short and we have pretty short deadlines to initiate any kind of litigation. And that's exactly why it's important that we remember this when we prepare documentation per transaction. Now, lastly, the arbitration reservations and the arbitration agreements in complex transactions. Usually, we will never be able to see one M&A transaction where you just have one vendor and one buyer, one customer and one vendor. Well, no, this is never that easy. We'll usually see a whole package of documents where you have the stakeholder agreements, the rights and powers concessions. There's going to be multiple parties. The parties of the transaction will be involved. It can be several participants. It's the banks involved. It's going to be at all times quite a lot of participants. And in this regard, it's important for us. I mean, if we want to have an opportunity to bring together the arbitration proceedings per different documents regarding this transaction. So we have to have one single arbitration agreement, which is much more rarely the case, or we should make sure that the arbitration reservations in different documents per this transaction are compatible. Another issue we may have, given the complexity of the procedure and the big number of participants, is what's going to happen as part of this whole process if on the side of the vendor you have 10 individuals, private individuals, or 10 doers that cannot agree on some particular points, starting with appointing the arbitrator on and through to other things. Ideally, we should agree on at the stage of preparing the documentation how we resolve such disputes, so how we settle them. I mean, oftentimes we see they appoint a representative who usually is the person most involved in a particular business and who takes the lead, declaring that should there arise a dispute, he undertakes to present the shared consolidated stance on this. Yet another example, given the sanctions, it's become even more pressing and relevant, has to do with what's going to happen should there be a dispute if you had a holdings company participating in the negotiations, but the factual party in this transaction was a different person, a different company that can be sanctions-free. You cannot Google it in any way. It's pure and beautiful and is completely unrelated to the given holdings company. So at the stage of preparing the documentation, it makes sense to consider how in the future, should this be necessary, we can involve the holdings company to participating in this litigation and the proceedings, so that we are not in charge of settling this should this dispute emerge.
And in general, my main idea is that when you work at M&A deals, you should always look at the conditions in the documents. Also, on the part of dispute resolution lawyers, please help your colleagues check and double-check the documents and tell them how they can actually make sure that everything is fine, because if there is a dispute, they're going to come to you, and you will have to find new approaches to dealing with difficult situations. And in our wonderful book, Blue Book, I tried to write my article with some special checklist that you could use in order to discuss the documents, potential documents, and you could also trace your work during contract negotiations. Thank you. Maria, I believe that this is a very specific situation.
Present our second star speaker, Mr. Kevin Kim, the founding partner of the law firm Peter & Kim in Seoul, Korea. Mr. Kim will talk about artificial intelligence and arbitration, a fascinating topic that I'm sure is of interest to everyone. And you will probably see from the title of Mr. Kim's presentation, No Turning Back, that in his opinion, the future is already here, and it is only a matter for us to adapt to it, and I hope that Mr. Kim will tell us how.
Thank you. Okay, good afternoon. My name is Kevin Kim. In the previous session, Mr. Qureshi KC kindly introduced our firm, Peter & Kim. I'm taking Korean side of Peter & Kim. I've been a lawyer about 38 years. In my career, I did most of my work did litigation and arbitration. I have seen the evolve and changes in generation and generation, but I believed the AI, particularly generative AI, impacts on arbitration will be most significant in the future. I'm practicing in Korea. I'm living in Gangnam, working in Gangnam, but I also noted that we Korean citizens can stay in Malaysia for 60 days without visa. That's good to know that. Again, thank you very much for inviting me to speak. So start with some history. International arbitration, fundamentally a neutral system that were created for cross-border dispute resolution. Parties from different countries have different legal systems and different national codes. So arbitration has become the best middle ground system where parties can choose their own judges and resolve dispute in private. This has become the most trusted, neutral expert from dispute resolution in the world. But as arbitration has grown, it has developed some problems. The biggest is now very complex, very expensive. Many people criticize arbitration for becoming inaccessible. Many major arbitrations use similar players, and processes become very institutional. New generations of lawyers and even small companies can find arbitration word hard to navigate. Now, we are faced with the biggest new phenomena. Generative AI has hit the world, and the entire industry has been impacted. The arbitration world is not spared. Many are asking questions about fate of both younger and old lawyers and how our job will change. As with every major technical development is both a risk and an opportunity. I believe if used correctly, Gen AI can be a great opportunity for arbitration world. It can make arbitration faster, cheaper, and more accessible to new and existing users. Let me go back to the core principle of arbitration. First, party autonomy. It was for parties to choose their own dispute resolution framework, arbitrators, arbitral rules, seat of disputes. Second, confidentiality. This is key hallmark of arbitration. For sensitive business matters not be heard in public court. Third, efficiency and flexibility. National court has long had the reputation of being slow. I have seen some jurisdictions where it can take 10 years to deal with a single case. Arbitration is designed to be faster as a standard dispute resolution process. These principles made arbitration popular. It was designed to be inclusive of all users, less complex, and formal than court litigation. But we should bear these principles in mind as we consider what arbitration look like in next generation. Let's talk about modern challenges in arbitration. First, many modern arbitrations are big, complex, and involve many big law firms, arbitrators, and high-priced experts. This results in much higher cost. Second, how long proceedings takes now. Many major arbitrations can take up to 3 to 5 years to finish. Not only is the major burden on cost, businesses also face cash flow uncertainty when huge quantums are in dispute. Third, formality. One of the key improvements of arbitration over litigation is flexibility and informality, but over time, it has become similar to litigation with increasingly formal procedure. This also results in longer proceedings and increased cost. Now, some challenges that are not as major but become increasingly important in years to come. Younger arbitration practitioners may get less opportunities because major arbitrations are very high stake, which require senior lawyers. Similarly, smaller law firms may find it difficult to compete for major arbitrations because it was very resource intensive. So there is less diversity for counsel in international arbitration. Lastly, because of how lucrative these major arbitrations are, they are a priority for counsel. Because of this, some small dispute with low quantity may be overlooked. So, how can Gen AI change this? It can increase efficiency and reduce cost, though through this, it can increase access to arbitration. Let me bring you through some applications. First, most obviously, AI can assist tribunal in drafting its word. I'm not saying that AI will draft a word. Needless to say, a word shall be drafted by the tribunal, but tribunal can be assisted by AI without compromising integrity. The word should be accurate and enforceable. So the word put together complex fact, legal arguments, and expert evidence. Gen AI can review submissions and evidence in arbitration proceedings, then it organizes arguments and summarize key points, ensuring the word is logical and structured. Of course, Gen AI can also proofread the word, ensure there is no errors. AI can help the tribunal in formality if necessary. The tribunal must produce a word that conforms a certain standard. For example, the ICC award checklist. Gen AI can incorporate this standard into the review of the word. It will help prevent legal challenges later. Next, think about written submissions in live form. Written submissions can be converted into live form using the AI, using my voice and my face, arguing in front of tribunal. And tribunal can order AI to select certain part of the arguments at both parties in back-to-back to review relevant portion. That could be the smart arbitration. Even now, many tribunals ask when they submit post-hearing brief, they ask hyperlink of the documents. When you put the hyperlink, not only documents, but also the video clip of testimony of the particular witness is attached. So if we expand and use AI in appropriate form, then this smart hearing will be the normal procedure for the arbitration. Then this will make tremendous changes in arbitration practice. So, when parties make 900 pages of submissions, you're quite tempted to ask AI to summarize it. Or even you order AI to summarize in live form with my voice and my face for the tribunal to make the arguments. Then you have the issue, how we can guarantee the quality of summary. Then you have issue whether or not tribunal can disclose which AI program you're using, or the parties can use or recommend the particular AI to use the tribunal to use. So this is all the issues we are very, very hotly discussed nowadays. But what I'm saying is, smart hearing will become normal in the future. Fourth, document review. All arbitration practitioners will be very familiar with document review being extremely time-consuming. Gen AI can already progress its documents review capability, and I believe this will only get much better in time to come. This will save paralegal or junior lawyers effort, and I believe it can even reduce errors, in fact, that are missed because of human failings. The tribunal, as I say, AI can be excellent secretary to find relevant documents or sorting out documents in a certain order. So tribunal can ask AI at any time, where's documents? What was party's position? They can immediately answer to the question. Same applied to counsel. Fifth, legal research. This is a very easy one. Everyone will know that how time-consuming manual legal research. The junior associate paralegals spend time overnight. This AI in this particular situation can be extremely helpful, particularly when the tribunal is not familiar with the governing law. Of course, there's counsel, make the arguments, or legal expert make testimony or report on particular issues. But generative AI can assist tribunal to find relevant documents, translate the documents, explain more background of the case, explain more background of legal principles for the tribunal to understand legal concept or the legal principle of the governing law. Sixth, bias detection. It is a celebrated feature of arbitration that arbitrators, witnesses, or the counsels are often from very different cultures and legal system and speak many different languages. The truth is, everyone has a bias come from the system that are used to. I used this example in IGA conference before. In Asia, dragon can fly without any wing. But in London, any dragon you see have a wing. So, how you can explain Western arbitrators that dragon can fly without wing? So that's why the Asian dragons are much bigger than Western dragons. But that is one example. You can explain the background, the future, any bias tribunal may have, then Gen AI can identify and alert the tribunal and parties to overcome the problem. Same apply to colors, same apply to text. In Korea, 0 all means yes. We don't use X, X means no. So that is the thing you can explain in arbitration, but even though you omit the point, AI will alert you on that point. The last point is translation. You're hearing the translation here. You have wonderful translation assistants in this room, but translation is always quite difficult job. Somebody described it the most difficult things in the world. So Gen AI effectively assists you to translate. Simultaneous translation is always challenging, but simultaneous translation with subtitle or simultaneous translation with synchronized voice and face is available in AI assistance. I know that all these may invite a lot of challenges of manipulation, neutrality, and technical assistance. But I'm saying that someday we will overcome this problem. This AI perfectly assists us in many ways. Okay, let me turn to the area of arbitration where often overlooked and no less important. Smaller claims. Smaller claims should be equally well pleaded, well decided in the arbitration. This is where I believe Gen AI can make the most impact. Gen AI can simply prepare the format of submission and make typical dispute in a certain format where the tribunal can use it. Repeat.
Kevin, there's 1 minute left.
Thank you. So, can AI be party's joint expert in smaller dispute? I believe this is possible in the near future. These are certain smaller disputes that are also technical because it may be not economically efficient to use expert in such a dispute. AI can fill the gap by delivering technical analysis and neutral and cheaper. AI can take a bigger role in word drafting for simpler dispute with tribunal-specific instructions and guidance. Gen AI can assist tribunal draft a word. Finally, a key problem in the multiple industries is data privacy. This is tied very closely to key features of arbitration, which is confidentiality in proceedings, and major concerns of using AI is data privacy, especially because there is often very sensitive information being debated in arbitration proceedings. This is where the legal community must step in. This is not just an issue for arbitration. Lawyers must develop universal standard safeguard for AI practice. This is good guidance, but legal practitioners should go further and work with them, AI providers, to develop binding standards for live issues such as data privacy. So what is our role in this AI world? To me, it's about human leadership to ensure responsibility and transparency. I think nobody will disagree with AI can and will be more efficient than human lawyers, especially in calculation and sorting out documents. There are many ethical and practical concerns we must take lead in guiding AI through its decision-making, ultimately make a final call. So as I stated in the beginning of my presentation, I believe Gen AI can completely transform arbitration as we know it. But we must be careful with transformation so we maintain rules-based orders we have so carefully built. Again, thank you very much for inviting me to speak. Thank you very much.
Kevin, once again, I think it's a very fascinating topic. And now we have some time for the questions, so please go ahead. I understand the microphones are there in the hall.
Спасибо, Борис Круглик.
Thank you, Boris Kruglikov. Thank you for presentations. My question is as follows to Sergey. Sergey, as a rule, as far as I understand from your presentation and our own experience and Article 33 and 6 from Vienna regulations, the grounds for security costs are economic. Well, and in our case, it was the claimant's positions. Have you come across such cases when it is sanctions that serve as a background for the security for cost usage? And sanctions may be impediment to the potential use of costs. Or should there be a standard of concessional of all kinds of connections, like in Belarus, which there are special legislations that exclude enforcement in favor of unfriendly countries? Thank you, Boris. Certainly, the enforcement of a foreign arbitration award in a country like Belarus, where the claimant is incorporated, when there's no such possibility, thanks to anti-sanction regulations, certainly the arbitration panel will take it into account. But this is not the only thing, because financial reasons certainly should be primary, or perhaps at least they should be as important as the former ones, and they should not be based on the national identity as such. in Russia is a little bit different because in anti-sanctional regulations, we have a case conducted by Dmitry and Krasnodar. On the 5th of May, they made arbitrary award on the writ of execution. The award was in favor of a Dutch company, and the Russian courts refused to recognize the award because it will go to unfriendly non-resident anyway if the award was recognized. And in this case, the arbitration court overturned the award, and they said that in principle they did not promise to fulfill certain liabilities for the Dutch court, though there is a presidential decree which limits the scope, but there's no prohibition to use it. But since it has started in Russian courts, I think that as an objection, if you approach it like the Russian courts, or it's not prohibited but limited, I doubt that there's a direct prohibition in Belarus law. Certainly it could be used as a counter-argument. Any more questions? Good morning, colleagues. Thank you for a very interesting discussion and interesting presentation. My question is to Kevin Kim, if you don't mind. So you have just told us about AI, Gen AI, and its usage. And now it is used more and more widely anywhere in any sphere of our lives, and in legal aspects as well. We resort to it more and more often. But what about the responsibility? Who actually is responsible for the decisions used for the application of AI? Or, for example, if something is not of high quality, I mean the awards or decisions or whatever, or the level of the software used is not acceptable. Because any company now uses software not only popular in the world, but also created by their own supporters. So what are the world trends in this area, and what is your opinion of the responsibilities in this area?
Thank you very much for the question. It's always an issue, and there's a lot of discussions about how we make rules, how we use AI, and making protocol. If you imagine the situation before the COVID, in 2019, until 2019, people are just sick and tired of hearing any additional protocols or guidelines. So when I proposed video conference protocol in 2018, many people were very skeptical about it. But 2020, everybody adopted protocols in the video conference. So I think the same apply to AI to come. As of now, there's many issues whether how the parties can agree the protocol. So which program we are going to use, and when the tribunal want to use AI, then they have to disclose and because at the end of the day, the party should have opportunity to comment if the tribunal receive any report, any result from AI. So that should be guaranteed. And how we can guarantee that such an opportunity? It was still a lot of discussions. People have a lot of different suggestions. I understand some organizations more detailed guidelines, while the others still waiting for what happens to come. So as of now, there is no particular answer, but I see that there is some proceedings already, the party discussing using the AI in international arbitration. because there's so many documents involved, so many information involved, then you have a huge amount of money invested in the document management and the data management.
Thank you very much. My question is to Mrs. Buksunova about the Uranovit-Curia discussion. Maybe I'd like to share a recent experience that I had in a case involving an infrastructure project in Saudi Arabia. There were 12 companies, and all of them claimed for a particular way of distributing certain common expenses. So all of them put a certain figure on the table. And my decision was slightly higher than the highest of the one that the parties put forward in a certain position. So there was certainly an ultra petita issue in my award. However, I was sure that that was the correct and the proper way of solving the dispute, because I had to establish legal rules for the distribution of each of the different items. And of course, the 12 parties didn't agree on each of these rules for each of these items. So I was sure I had to be consistent legally, meaning probably qualitatively more consistent, than worried about the fact that quantitatively I was a little bit above the highest of one of the parties' petitions. It's a little bit complex. But my point goes to, the arbitration was seated in Madrid, by the way, and the courts have confirmed the validity of the award. Some of them, there's still some actions for annulment pending. I hope the courts will confirm the award. What the courts were looking for was the question about the right to be heard that you very well mentioned, which I think it will be in most cases the common way or the clearest way in which we can know whether the Uranovit-Curia principle has been respected or not, had been legitimately applied or not, which is, did the parties actually, as a matter of fact, had the possibility of discussing at length, referring to the actual legal criterion that was applied in each particular case? So, qualitative approach as opposed to a quantitative, more superficial approach, if I might say. But I was aware that the ultra petita objection would be raised, as it was raised immediately. What do you think?
That there is no common ground for application of this principle Uranovit-Curia in terms of no ultra petita. I think that I'm not have covered this question during this session, but actually it's a very controversial issue. So the principle no ultra petita has also negative impact on the application of Uranovit-Curia because it contributes to uncertainty of arbitral proceedings. Actually, I'm talking about the scarcity of regulation of no ultra petita. And due to this fact, we are forced to confess that we are stepping in the dark in terms of this question. First of all, I should say that we can't to be precise in this question that you have addressed. And I can raise one more question, because we don't have a special regulation. For example, when parties are, for example, referring to the norms of contract law, or when parties refer to norms of tort law. And the arbitrator is to decide whether their relations are referred to common contract law or tort law. And one of the courts said that the parties can't say that their right to be heard was breached because the nature of their relations were at issue. But at the same time, when parties, for example, lay their legal arguments and factual arguments when we are talking about, for example, the quantity, then we just can't say that I think arbitrator can exceed his powers when both parties are referred to contract law and the arbitrator decided the question on legal grounds of tort law. But I think that I'm a little bit far away from your question, but I want to emphasize that it's a question that's not really clear. Sometimes no ultra petita limits the application of Euronomic query, and sometimes not. So I think this one more interesting point that could be discussed, whether the contradiction between the quantity and quality in terms of application of no ultra petita and Euronomic query. Thank you for your question.
First out to the panel, Dami Gispada, Balsari Spasiba, very good presentation and input. Really grateful for that. But my question actually is directed to Kevin. And I'm just wondering, because you're cutting the edge for us all in the AI, and I'm just wondering, because, when one looks back at challenges to tribunal secretaries and the kinds of assistance they give, looks like there's been a very good run of 3 decades of tribunal secretary work getting by, as long as the panel actually takes the trouble to take responsibility for the output. Do you see that that is a viable path in terms of defending the greater use of AI, even to assisting the way evidence is evaluated? And that's likely going to be the way forward if cases come up in the future, when that kind of technology comes to the fore. Thank you.
That's exactly we're using to defend using the AI theory. In IBA Arbitration Day in Paris, we all talk about AI, and the biggest defense, actually, the normal, quite typical defense was that what's the difference between using the secretary, tribunal secretary, and using the AI in terms of the assistance? Quite similar. But actually, secretary is a human being, while the AI is the program, certain program. It might give a tremendous bias on the certain issues. So you have no control of doing that. So that's why we need some more protocol, how we control it. Because once I think the one thing really we want to avoid the situation is where a tribunal, without telling the parties, just privately ask some questions in AI, because you can ask the questions at any time using now. Then you have some impression. That impression is so powerful, and then you have parties have no opportunity and no way to defend the case on the point. So that is why but maybe same thing may happen in the secretary assist a certain portion without disclosing parties that certain information or he or she find was totally inaccurate, but the parties have no opportunity to comment on it because they did not know that. So we have the exactly same issues on that point. So I think whether or not we like or not, it is we will use AI eventually because the legal market will use AI, and then we have to find a way to overcome. But your point is absolutely accurate. Thank you.
The end. Thank you. Coming to the end of the second part of the first session, and I think that the speakers also deserve an applause and a thank you. And thank you for everyone. And I think that the organizers are now going to make an announcement.
Thank you so much, Anna. They also deserve a lunch. And we have a break which starts right now, but we shall be back before 1:30 p.m. We have 40 minutes for a lunch break, so please enjoy. Thank you so much again for the panel and for the moderator.
All right, so the organizers have allocated 1 hour 40 minutes for this panel session. So I'm planning to make good use of these 1 hour 40 minutes. And like in our previous sessions, we're going to give about 20 minutes for each of our presentations. We have 5 speakers and 4 presentations. So all the questions from the hall we're planning for the end of the session. After all the speakers have presented, as moderator, I will be asking questions at any time. So with this, we'll start. It's no secret that arbitration is as good as are the arbitrators that settle the disputes. So we all remember the big statements made by all kinds of law firms, arbitrators, lawyers, barristers, made in spring 22. At that time, I believe a new type of prejudice and bias, political bias, emerged, about which I frankly had never thought about, at least in terms of the selection of arbitrators and submitting challenges. So we've been living in this for 3 years. The arbitration is still there. So in any way, the parties still have to select the arbitrators. They have to file challenges or reclusions and to get their matters settled. So our first presentation is on challenging the arbitrators, given their political views and the current situation. So I would like to give the floor to 2 colleagues, Vadim Vainukainen and Daria Tokruk. Both are the practitioners, both work together, so you guys get 20 minutes. Dear colleagues, good afternoon. I am Vadim Vainukainen. My colleague is Daria Tokreva, and so together we have prepared a pretty big research into the challenges of arbitrators on account of their political views and political bias, prejudices of the arbitrators. And we would like to present to you today a brief preview of this report. The entire version of the report with all the links, references, sources is going to be available in the collection of materials from this gathering. But here we're going to briefly cover what we wrote about. Why do we present and make this report? Like Andrey said, since spring 2022, we've been living in a completely different reality. And over the time of our work, and even before that, we have managed to form a very special kind of expertise, in particular in terms of checking on the conflict of interest, checking on the prejudices, biases. So we have our own know-how regarding the in-house evidence and data of arbitrators. We've considered candidates with a magnifying glass, the social networks they have in all kinds of ways and on all kinds of accounts. So we would like to share this with the Russian party, with our Russian colleagues, so that you guys also have this experience, so you can take your own decisions, judgments regarding your candidates, regarding your arbitrators, and to decide whether or not you should appeal for a challenge. Well, like we already mentioned today, and maybe I need to mention this yet again, there is this very well-known statement by Jean Leliev an arbitration is only as good as are the arbitrators. And this is not an exaggeration. I mean, the formation of the tribunal is one of the most important stages of the arbitration process, so maybe the most important one. I mean, certainly what happens next is also of critical importance, but I believe not a single party, not a single lawyer wants to find himself in a situation when he has at least a little suspicion on that at the beginning of the proceedings, the arbitrator already has a formed opinion on how this procedure should end. In order to make sure we rule out these suspicions, there are two classical requirements to arbitrators. It's independence and impartiality. At times, they topped up with neutrality, which is a new criterion, which is referred to as the arbitrator being distanced from national, ethnic, cultural, or religious traditions that can impact the outcome of the dispute. Neutrality, as such, has already been enshrined in some of the arbitration-related regulations, in particular with regard to the single arbitrators as appointed by individual institutions. Now, in practice, oftentimes in commercial and investment disputes alike, there is an agreement that all the arbitrators have a neutral citizenship. Why is this so important? That's because considering the behavioral sciences, the economy, sociology, and other human being-related sciences, all our judgments, decisions, and behaviors are dependent on the behaviors and can be subjective.
And of course, they are human. So there are certain distortions, and not a lot of research is dedicated to that lack of impartiality and certain distortions. So even if you are not interested in American politics, you could see certain articles of American journalists when they try to predict certain rulings of the U.S. Supreme Court, and quite often they are right. And it's not that difficult when you have a lot of information what kind of rulings were made by that very justice of the Supreme Court, when you can look at the career of that judge. In arbitration, it's much more difficult to do it, also because of the absence of that massive information. But we have a lot of research, and one of that is research conducted by Weibel, and which was conducted in 2012, and they took about 400 rulings on investment disputes and background of 350 arbitrators. They had certain theories and tried to test those theories, and you can see some of their conclusions. These are the takeaways. As soon as that research was published, there was a lot of criticism emerged regarding their methods and the theories. I believe that that research is not of great scientific value, and it's not the ultimate truth. But in principle, it's a very interesting approach. Practicing lawyers, the way they appointed arbitrators, statistically, their intuition was right. Also, there was another research by David Schneiderman, 2010, and what is the value of that? Schneiderman got all the information regarding bias of judges and tried to apply it to arbitration. He tried to explain why three tribunals, when they looked at similar investment disputes, came to different conclusions. All those disputes were quite similar. Those were the disputes of investors with Argentina in 2001, because of devaluation of Argentinian peso, economic crisis, and here are those awards. 2005, 2006, 2007. In one of the disputes, Albert Vandelberg and Francisco Rezic decided that Argentina didn't have to actually adhere to its obligations in the conditions, but the same arbitrators recognized the guilt of Argentina in the beginning of economic crisis. Schneiderman, in his research, failed to establish the reasons. The models that he used didn't yield any results. And he had to make the conclusion that it's enigmatic. And although we cannot make any conclusions based on Schneiderman's takeaways, so the same arbitrators can come to different conclusions in similar cases. These takeaways are extremely important in modern life. Now, we live in the world of sanctions, and the practice is quite controversial. I believe that we're going to discuss it at this panel. That means that the arbitrators, they cannot rely on similar arbitration rulings. So the personal perception can influence the outcome. Some arbitrators and some law firms actually took public position regarding sanctions because the world has changed dramatically. Also, arbitration world, it's interesting to see how it affected the statistics of challenges. There is approximately the same number of challenges as before. We could discover some other numbers regarding certain objections, but regarding the candidates. And LCIA is publishing it in the 2023. There were a lot of objections, although we don't know whether those are Russia-related cases or not. But I'd like you to pay attention to the following, because what's different from challenges, objections actually I accepted much more often, in about 50% of the cases. And this number, 50%, motivates not wait for the arbitrator to be challenged. Maybe it's important to object early on. Arbitrators practically never open up information that could somehow question their impartiality and bias. That means that the time for gathering this evidence is the burden of the parties. And now my colleague Vadim Vonakanin is going to tell you about certain factors and the practice. Well, I'm going to start analysis of present-day practice. We're going to share our experience and also certain publicly available information. And the first case, that's when you get the chief arbitrator and the opponents provide the candidates that seem to be quite impartial and independent. But if you conduct your research, you can see that they can actually demonstrate anti-Russian views. One of the clear examples is the arbitrator. The partners of that arbitrator donated the funds to opponents of the Russian Federation, the armies of the opponents of the Russian Federation. And that arbitrator is ready to be the chief arbitrator, but then was excluded from the list. Then very often you can see the likes on the internet. Arbitrators could be quite active in social media, and they could either support the Russian Federation or condemn the Russian Federation. And then when they condemn the Russian Federation, they are provided as potential chief arbitrators. Well, they could be excluded. Also, a lot of arbitrators are members of state organizations, and they actually conduct anti-Russian activities, are looking for Russian assets abroad, and they don't disclose this information. As soon as this information is disclosed, they exclude it from the list. The next one is about challenges. The law firm of the arbitrator in February 2022 publicly announced that it refused to work with the Russian clients. Then, in a different case, with the participation of the Russian Federation, the arbitrator was challenged and opened up the information about the challenge, and then the Russian party expressed their reservations about impartiality. So that potential arbitrator decided not to be the candidate any longer. And the next case is the case about very serious situation when the arbitrator was a member of NGOs that were looking for Russian assets, helped to outline the sanctions policy, and was one of the key figures in those organizations, NGOs, and then failed to disclose this information. Then the Russian Federation challenged this arbitrator, and then in further cases with the participation of the Russian companies, well, he disclosed this information. The next case, quite an interesting case, and it's illustrating what could be encountered. We couldn't find one single case. We couldn't find any case connected with such things. The spouse of the arbitrator has active anti-Russian views, and as a Twitter account is a member of numerous NGOs and conducts the sanctions policy in order to denounce the actions of Russia. And after that information was discovered about the spouse, the Russian party actually raised that issue, and the arbitrator said that they have been divorced for 10 years and they don't communicate. And in this situation, there was no challenge. Here are several slides. Slide number 16, which is extremely important for our case. So that's about the Chinese swimmer and Franco Frontini. And this Italian arbitrator, Franco Frattini, published a number of tweets commenting on trash videos. And in the comments, he expressed a very strong anti-Chinese sentiment, said that China was not a superpower, and he in general condemned all the Chinese. And he had that case of a Chinese swimmer. Well, here we show the case study of Franco Frattini. So the publications in the media about the connection with those comments, actually this information was published after the award, and the Chinese swimmer actually filed an application to review that award, and the court actually accepted it and made two very important conclusions. First one, that the party doesn't have to check all the background information, but you must have due curiosity. You must look at your potential arbitrator. Then Charles Pansay, he was talking about Muslims and allowed himself to express very strong anti-Muslim sentiment. The Swiss court refused to reverse the award. And now I am moving towards the end, gradually, slowly. I'm going to I'm not going to comment on all the cases. So now we're talking about international neutrality and the general conclusion that we can make. The general conclusion is that quite often on the basis of the same facts, different rulings, different awards could be reached. Of course, it's very important to pay attention to aggressive tone of the statement, context, and so on. The most important conclusion could be that the body which is going to make the decision about challenges plays the most important role. And in reality, a lot is going to depend on the information that you provide to that body. I am really happy to make this presentation. Have a wonderful, wonderful conference. Thank you. I will have one question to our colleagues as a moderator. It's very convenient when the arbitrator is showing political bias in the interview, also on social media. But what about arbitrators that are biased but very quiet? Maybe we should use the methods of the Russian prosecutor's office? Well, actually, arbitration community is not that huge, and everybody knows everybody else. And we can always ask what people think about such and such person. You have to attend arbitration events. And, for example, there was arbitration week in Paris. The lecturer at the time of the lecture boasted of that practice of sending funds to the army of a certain country. Thank you so much. Thank you. Let's thank our speakers. And I am happy. Looks like lunch is over. We have more people in the audience. And European sanctions legislation shows that Europeans follow the sanctions and nothing is going to help. So there is no clause of responsibility. Well, it's impossible to deal with this. Now our next speaker is going to tell us about the best defense. Which is good defense? Is it possible to overcome no claims and no liability clauses under the sanctions regulations? I would like to give the floor to Sergei Morozov, DGP Litigation in Dubai, and Deputy Chair of the Management Board of the Russian Arbitration Association. Sergei Morozov, BGP Litigation, Dubai. Wonderful session, wonderful event. And I'm really happy that Russian Arbitration Day shows that it's an event of great quality. We listen to great presentations here, and you feel like you can see a lot of familiar faces, like you're meeting your former classmates. And my topic is less theory and more practice. And maybe practicing lawyers, representatives in arbitrations, also in-house lawyers, maybe arbitrators would be curious. So when we are talking about the clauses, like no claims and no liability clauses, this issue is more topical for the Russian persons that try to get the money back for non-delivered goods and services, and also for foreign persons, our foreign colleagues, those who are present here, including this room. And why do we discuss this issue? Why have I chosen this topic? I was a consultant. Recently, I was an in-house lawyer, and I can see a lot of different disputes, arbitration hearings, but there is no serious research that could help the parties, the clients who participate in such disputes. And special thanks to Vladimir Goroshenko and Alexander Zhurbin, who were indispensable for this research. And in the future, those future stars of arbitration are going to be here.
This is a topical issue because it deals with clauses which provide either no liability or no claims clause. And for foreign companies, it's of utmost importance. And because sanctioned persons are involved a lot, but also there are persons who are not sanctioned, but still sanctions are applied in their respect because of certain mistakes of arbitration or some other reasons. Although the sanction regulations have been in place for a long time, and in particular the latest ones in relation to what happened over the last 3 years, still arbitration or court proceedings have been various and diverse, and there's no unified approach as to the conditions, circumstances of their applications, or no liability, since the costs are involved. And in international arbitration, and in terms of overturning arbitration awards, they can reach billions of dollars or tens of dozens of billions of dollars. And that is why costs are very high. So I'd like to tell you about the history of the clauses, the way they are applied, and ways of defending oneself. And for you in particular, in practical terms, it must be interesting. So, for the first time, these clauses emerged in the late 80s after Iraq's invasion in Kuwait in 1990, when the UN Security Council adopted Resolution 661, which imposed economic and financial embargo on Iraq, and which is similar to what's happening now, it did not succeed, I must say, but still paragraph 29 of the resolution on a ceasefire contained the following provision that no claims should be made by the government of Iraq or any personal body in Iraq, etc. As to the clauses, the first wave of them deals with the same incident, Iraq to Kuwait, and claims number 1 and 2 contain the same points, and then Yugoslavia, Libya, and Tahiti, and others. So this is a whole history of these clauses, which followed the events or dramatic events which have been interpreted by our colleagues in the West in such a way. And usually the injunctions or non-enforceability or prohibition, they were very strict and direct. And it also prohibited any other measures which could be entailed by the non-enforceability and no-liability clauses. The question arose whether they should be assessed as the prohibition for the counterparties, like prohibition for any kind of possibility, or a set of measures. And the answer was it deals with a prohibition in terms of amicable settlements or arbitration or whatever. So there's no direct prohibition as far as no claims clause. So there are special conditions for applying no claims clause. So they should be cumulative, that is, when there's a set of elements required. If one at least is missing, so you cannot apply the clause. And this is a negative element in our work for defending Russian parties. So there should be a connection to the treaty or a deal. Also, 26.9 and 833 regulations contain sanctions for the enforcement of the treaty or deal at large, but then we should interpret the claim itself by the sanctioned person. So if they deal with the fulfillment of obligations. So as far as connection of the claim to the treaty or deal or the claim for recovering advance, they're absolutely different interpretations of advanced relief. There may be unsubstantiated approach, and this claim deals with a status quo statement which existed before the treaty was concluded or enforced. And complying with the claim should not entail positive outcome for the interests of the party, which could arise in the treaty implementation or deal implementation. In any case, not returning the advance for the products which were not supplied to the Russian party by a foreign party. In any case, it leads to creating certain assets because the property was retained by the party. And if the Russian party wants to get the advance payment, it will have losses anyway, because when a deal was concluded, the Russian party believed that it will go to an end anyway, and thus the claim for advance repayment will not violate the aims by the sanctioned regulation, because the Russian party will suffer anyway, be it a sanctioned person or not, because actually the person who is not sanctioned should not be liable to any kind of restrictions or sanctions, and the prohibition for claims, so no claims clause for the sanctioned persons and for the courts and arbitral tribunals considering the disputes on the repayment of debts or any other risks involved. Additional change is the change in the burden of proof, because the party should prove itself that Article 11 of the acting regulations should be used by the party itself. And thus the question arises how to return advance payment and interest. And the Ribal case and Stanko versus Stanko Import is an example, because the products were supplied to Stanko Import and advance payment was made, but the Ribal could not receive the license, and thus the contract was overturned or cancelled, and 9 million euros was the amount of damages to Stanko Import. And the ad hoc arbitration and jurisdiction, they were actually, they lost the dispute. And the Swedish court, accepting the case, considered that it was not ready to come to final award without special indication on the part of EU court, which is due to the regulations of the European Union or Court of Justice, is entitled to provide interpretation on using the European law. And thus the Constitutional Court of Sweden sent a request to the EU Court of Justice, which considered the applicability under Article 11 and the conclusion of settlement if the dispute could be settled in the first way, then it is liable to arbitration. Whether ex officio approach is possible for sanction regulation, and the very advance payment was at stake. And the Russian Association, I'm a member of which, we sent the conclusion to the court, though it was not considered by the proceedings, but still we turn to arbitration community quite often, because though Article 11 is not applicable for arbitration, it does not preclude consideration by arbitrators. And we believe that the consideration on merits of the case was preferable, though it usually goes through EU countries, but not for local arbitration, and the more so for the outside arbitration, even though Article 11 is used in arbitration. Still, it does not preclude consideration on merits of the case. It does not preclude the recognition by the state court of the arbitration awards. And this is important because there are certain time limits when you can apply for enforcement of arbitration award. And if you miss the opportunity and the time elapses, then you will lose it. So we believe that when the sanctions are lifted, the parties will be able to enforce the arbitration awards which were made before. In any case, Article 11 does not preclude the return of the advance payment. So there's a risk of expansive interpretation of Article 11 deals with the seat of arbitration, applicability of EU law, more complexities for appointment of arbitrators, anti-suit injunctions, and whatnot. And for EU countries themselves, there are risks of investment arbitration on the part of foreign parties, which may believe that their rights of properties were violated. So now conditions for applying the clause. So the consequences of using liability clause, no liability clause. So Article 11, Regulation 269, and Article 44 SAMLA. So these conditions should be used in a cumulative way, and the consequences may be no consequences, no liability of any kind, including criminal, according to EU law, or civil liability or whatever. So ways of defending oneself. So the best defense is offensive, as one of the world leaders believed. So if the fight is inevitable, you should be first to fight. So such processes are involved, which may be encountered by these clauses, no claim and no liability clauses. So you should understand that any kind of actions may entail sanctions. And also, we can cite the civil law textbooks in Moscow University that any kind of communication or action connected to counterparty should be fixed in any way, should be laid down. And in our group, for example, sanctions pack was provided by the counterparty. That is a set of documents, submissions, answers to the questions, and whatnot, in order to use them at the stage of first consideration of the case. Important for understanding that there's no connection of counterparties, and you could not refer to the sanction clauses. So such arguments that one of the conditions was not complied with. Second, using clauses only in the part of the treaty which is affected by sanctions, not in other part, because you can prove that the other parts of the contract which have not been affected by the sanctions, so cannot imply these clauses. So lack of bona fide of your counterparty, because sanction status of the claimant was never declared by the party, and alternative enforcement or alternative liabilities, like using escrow accounts or others, and there's a way of settling the dispute amicably. And additionally, there's an international investment arbitration, which is very topical for the sanction issues, and any other guarantees and mechanisms for sanctioned persons in order to have claims and damages are paid by the state, not by the parties. So these are latest cases for Fortunova and Baltijski Zavod versus others. So they provided money to the court paying credit notes. And this does not mean that the sanctioned person will be able to use unlimited credit line without any interest. There are mechanisms related to the third-party enforcement and other mechanisms which may be used so that the party should comply with its obligations, but the sanctioned person will get the money later on. International investment arbitration is another topical issue. Currently, it is a very good way of using investment claims because of sanctions. And the Russian Metallurgical Company provided such notification, for example, that because this way is very efficient, in particular for foreign states, not so much for Russian companies, but for Russian states which enforce international arbitration awards. But the question of jurisdiction arises because there are different definitions of the arbitration agreement, whether it should deal with the costs only and doesn't deal with such things as expropriation. But the merit case, in principle, is debt expropriation, like creeping expropriation by the state, or police powers of the state as far as sanctions are applied, and attributes, that is, the responsibility of the state. And
so basically, in spite of the seeming danger of these reservations, and in spite of the fact that they seem quite indomitable, there are ways to overcome them and to beat them. And in fact, there are lots of awards, and the number is growing. So it means that the people who are subjected to over-compliance and who are subjected to a lot of abuse will be exceedingly able to defend their rights at court. Thank you. Thank you, Sergei. Now I'll have a question to build on what you were saying. The European legislators have taken good care of their companies and legal entities so that they can refer to such reservations, whereas the Russian legislator, whom you elegantly mentioned in your presentation, I will not repeat this name, is also introducing a lot of sanction-related regulations, which we refer to as counter-sanctions, because we're not the ones to attack first, right? So the Russian individuals who comply with their counter-sanctions, do they have the same ways of defending themselves? And can they say, I'm not responsible for compliance with my own sanctions? Right, thank you for this question. And in fact, anything that's related to the public policy gets us to be somewhat extra cautious. However, in the Russian legal setting, the institution of public order is, I guess, even overly developed. That is about the execution of the arbitration-induced awards, or it's about challenging and lifting the awards, the judgments. So when there emerge the sanctions-related reservations, or Article number 248, or related to the sanctions, we see that not the foreign individuals, but the Russian nationals start using them, as we recently see with regard to the Hong Kong case. I believe the operational active mechanisms available right now are sufficient for now, but if the country is way too zealous and ardent in using these mechanisms, I believe it will rather be abusing of its right, because the mechanism is quite well balanced. So I believe it's about going the way that's agreed between the parties, ensuring the compliance with one's rights and obligations, and then ensuring the enforcement. Thank you. Let us thank our speaker.
Speaking part of our panel. So whoever is using the translation devices might change them. Sergei already mentioned that, well, if you're subject to sanctions, then likely you will not have a recourse against somebody who is not performing the contract. I guess the first question that everybody who was subject to the asset freeze at some point asked themselves was like, well, what about my property rights? Isn't it one of the most important human rights there? And obviously there is a very difficult interplay between sanctions, human rights, and particularly in the context of international investment arbitration. So our next speaker is going to address this topic, and I'm happy to introduce Anastasia Medvedskaya, who is the associate member of, well, I'll try this, Guernica 37 chambers in London. Anastasia, 20 minutes.
Thank you. И большое спасибо.
And thank you very much.
Yes, I'll continue in English for the sake of basically convenience, because my article was written in English, and so I think it will be better for everyone. It's a pleasure to join you this afternoon. It's a pleasure to speak amongst such esteemed colleagues, and I'm aware I stand almost between you and the next coffee break. So I'll aim to do something actually stimulating. And the topic of sanctions, human rights, and investment arbitration is not a light one, especially at this hour. But it is timely, and it sits at the crossroads between Andrey and Dmitry's panels. So some of the most pressing legal and geopolitical debates of our time. So the title is quite long, right? So let's try to break it down for convenience. Sanctions, as we know, in 2025, it's 2025, we still speak about sanctions. It's hardly a novel tool, right? So tale as old as time, song as old as rhyme. They've long served as instruments of state power and a sledgehammer of foreign policy. Sometimes effective, sometimes used with precision, often without, and often creating collateral damage. When we bring human rights into this interesting mix, the conversation inevitably turns to the Eugen Schvidler's pending appeal before the UK Supreme Court, as I will elaborate on this a bit more in details later on. The case essentially concerns the case of proportionality and the definition of the proportionality test in UK human rights law and, well, in the sanctions regime applicable to UK parties. And if we bring to the mix investment law and investment arbitration to the equation, we step into an ever more intricate territory, because suddenly the question of proportionality and interference with private rights, instead of focusing on the domestic interpretation, becomes elevated to a situation where treaty protections are at play, right? And so all of a sudden, the old debate about whether sanctions were actually compliant with international law becomes relevant. And all of a sudden, the state's conduct is at scrutiny. And we encapsulate the proportionality test in concepts as legitimate expectations, fair and equitable treatment, and the need to protect against expropriation. So at its core, the debate turns in two fundamental questions. Question one: is the traditional justice system unable to protect human rights in the context of sanctions? And question two: actually, can investment tribunals serve as viable forums for safeguarding human rights when sanctions go too far And hang on, I've prepared some slides, and I'll try to make it work. Ooh. No? No. Oh. You did. That's lovely. Thanks so much. Oh, that's a lot of text. Thanks a lot. Well, the problem of modern sanctions is that theoretically they should be compliant with international law, but the question of legitimacy of sanctions in international law is often overlooked. When I spoke with a very reputable Silk not so long ago over a coffee, she said that it was a purely academic debate. I believe it is not. Sanctions, though widely used and largely accepted in state practice, sit uneasily with the principle of non-intervention, which is a core tenet of international law. And this principle holds that the states should not interfere with international affairs of other sovereign states, because they're all equal. And that was actually declared by the UN General Assembly in 1970. That was further confirmed by the International Court of Justice in a somewhat known Nicaragua case. And how do sanctions fit in? Well, it's very simple. Sanctions are authorized by the Chapter 7 of the UN of the UN Charter. They have to be authorized by the UN Security Council. And these are typically adopted in response of threats to peace, breaches of peace, acts of aggression, and they carry full weight of international legal authority. And all UN member states should be bound. And Sergei mentioned an example just early on. But even there, the legal practice is not always clean. There have been instances such as the sanctions regime imposed on Bosnia, Yugoslavia, Iran, where the security imposed sanctions before formally determining that the existence of a threat to peace, as required under Article 39, was actually there. So this already blurs the legal line, even within this very much established international law multilateral framework. So now, in contrast, you have something called unilateral sanctions, and so those are imposed by individual states or coalitions without the Security Council's backing. And see, the thing is, that's the most of the sanctions that Russia is faced with. Why? Well, because Russia is a permanent member of the Security Council, so it's a bit complicated, right? But in fact, the question of whether unilateral sanctions are compliant with international law, often described as just, this is a moot or theoretical debate, comes into play because we need to assess it against the human rights obligations. For UN Security Council sanctions, you have to have a scrutiny of human rights impact of these sanctions. You can't just impose them. For unilateral sanctions, you basically have to exercise the power of your sovereign the way you see it fit. And in international law, again, if we go back to the legitimacy and we go back to the idea of countermeasures and Article 22 of the Articles of State Responsibility, for a unilateral sanction to be a lawful countermeasure, it must respond to a prior internationally wrongful act, be proportional to the injury suffered, be aimed at restore compliance with international obligations, and must not violate peremptory norms, and must be temporary and reversible. Okay. So again, even with the countermeasures, you can't just do however you like it. So, of course, that is very good in theory, and so those who believe that international law is dead is fine. And we see that states are free to conduct their own foreign policy, they can limit trade, restrict investment, withhold cooperation, that's part of their sovereign right. These known as retortion, they can be considered as lawful, but even those measures cannot just completely overlook the idea of human rights. So now, talking about the human rights implication, basically, should sanctions respect human rights, right? Well, this is not a long-awaited rant about OC licenses, access to justice. On a more serious note, international law distinguishes, or international human rights law distinguishes between absolute rights, like the prohibition of torture, slavery, which can never be limited, and the qualified rights, such as access to healthcare, education, justice, which can be restricted but under some legal conditions. On a less serious note, even if it may feel for certain counsel that the need to go through the 9 circles of hell by off-sea for receiving payment is an act of torture, it can hardly be considered as a breach of Article 3 of the European Convention of Human Rights. But if we talk about concrete examples of how sanctions did violate human rights, history shows that sanctions can go too far. And for example, in the 90s, sanctions against Iraq led to devastating shortages in medical supplies and food. In the case brought by Iran against the United States, the ICJ recognized that sanctions reinstated in 2018 risked violating humanitarian norms and ordered temporary relief of essential goods. That was the provisional measures case. And look, that worked, right? So, if we do take all of these examples, it follows that sanctions deemed valid under international law must still be subject to human rights scrutiny. You can't go around that. Although such measures may in practice encroach upon qualified human rights, any infringement requires careful evaluation. So the sledgehammer example of cracking nuts, etc., is not exactly the way things should be done. And so this framework stands in stark contrast to unilateral sanctions imposed by individual states, where human rights compliance is only considered when the sanctions are formally challenged, not before. The assessment is done after the individual has been sanctioned. And so if we do talk about the UK example, we have a very interesting case now pending before, a very interesting appeal now pending before the UK Supreme Court. I'll focus on Article 8 because Article 6, which is the right of access to justice, I think it's not so interesting. I think everyone agrees that this room is full of lawyers who did represent sanctioned parties, even against horribly difficult conditions posed by the regulator or European authorities, or UK authorities for that matter. But the Schwidler case is an interesting one because it poses almost a philosophical question to the Supreme Court. So just to recall, Eugen Schwidler is a dual US-UK national, was sanctioned in 2022 for his ties with Abramovich. He resigned from, ties with Abramovich and plus ties with Evraz. He resigned from Evraz board shortly after Abramovich's designation, but still was caught by the same applicable regime. So he challenged his listing, and that is pretty much something that also lawyers here are very familiar with. So he argued basically that the sanctioned breached Article 8, so the right to private and family life, and because his core argument was about the same old proportionality. Like the idea is that you cannot really hold accountable Eugen Schwidler for the actions of a state on which he has absolutely no possible interference. So his argument was the sanctions lack a rational connection to the government's foreign policy objectives. He asserted that less intrusive alternative existed and that the designation unfairly punished him for actions beyond his control. Obviously, the Secretary of State disagreed and countered, saying that the sanctions were part of a broader strategy to pressure the Russian government, were temporary and reversible, and therefore the safeguard such as licensing and judicial review were available to him, and so everything was basically in order, and that the Court of Appeal, reviewing that, upheld the sanction, citing a very known case on proportionality, Bank Milat, which sets a four-limb test. The first question is the objective sufficiently important? Is the measure rationally connected to it? Could a less intrusive measure achieve the same end? And does the measure strike a fair balance between public interest and private harm? And the Court of Appeal answered yes to all of these questions, basically. While acknowledging the harsh impact on Schwidler family and his life, the court concluded that public interest in exerting diplomatic pressure outweighed his individual hardship. And so the question to the Supreme Court can boil down to a philosophical one, which is, can a private individual be justifiably sanctioned for a conduct of a state? And actually, is it rational or is it more symbolic? Do we actually care about proportionality at this stage, right? So, again, sanctions are a very blunt and yet such an effective tool, so satisfying, right? I hereby salute my colleagues who are present in this room and who are dealing with delisting cases, and I do understand how difficult it is, both in the EU and the UK. This is an extremely difficult battle, and I mean, the coffee break that is looming will be a great opportunity for you to discuss that with them. So now, if we do talk about investment arbitration, in my 4 minutes left, the idea is, there are two ideas. The first idea is whether human rights violations can give rise to claims under bilateral or multilateral investment treaties and can be brought before investment tribunals. That's a difficult one because that actually goes back to the questions whether human rights violation can at all be actionable before investment tribunals. And we do have some case law on that. We do have some guidance from the Obasa versus Argentina case. This is an old case about positive human rights obligations and providing water, etc. So, of course, the counterclaim was not necessarily upheld by Argentina, but the tribunal said that, well, the tribunal acknowledged that international human rights obligations, whether based on or the treaty or general principles, form part of the legal fabric that governs investment disputes. And it's not surprising because it does somehow ring a bell about the systemic integration of Article 31.3c of the Vienna Convention on the Law of Treaties, which basically states that treaty interpretation must take into account all the relevant rules of international law, and in our case, human rights law. Well, this is not an established practice as far as I'm concerned. So the relationship between sanctions, human rights, and ISDS is much more interesting when we say that the nexus between human rights violations and investment claims violations lies only in a factual matrix. And actually, you would bring a standalone investment claim as an investor saying that the state's actions have violated your fair and equitable treatment, did expropriate your property for some reason. So when a state violates investors' human rights, those are not just human rights, but this becomes, as I said, a factual set that could be analyzed through the prism of an investment treaty. We do have colleagues who are pursuing those claims, so I'm not the best person to speak about whether there is success in pursuing those claims, but it is a very interesting practice nonetheless. What we do know is that there is a case about that, but just not Russian sanctions, Iran sanctions, okay? And so there is this case called Dayani versus Korea, brought under Korea-Iran BEIT. So it was a confidential case that re-emerged at the point of challenge. The dispute involved the collapse of a cross-border acquisition in the sanctions context, and basically the investor won. On that happy note, because it is a happy note, I will direct you to the reading of my article that elaborates much more on that, instead of boring you with case law. And thank you very much for your attention.
Thank you. Before you sit down, I have one question, if I may. You mentioned that basically all of those cases necessarily involve this scrutinizing the conduct of the state. And arguably, the state courts and investment tribunals are more used to that. Do you think human rights arguments in this context of sanctions regulation have any prospects of success whatsoever in front of the private tribunal in commercial case?
Thank you very much for this question, Andrey. I do think that those who don't raise don't drink champagne, right? We don't even know if they're going to succeed in investment arbitrations, but look, the only, my reservation about the purely commercial disputes and bringing human rights claim is that, look, I mean, if the base of your claim is a contract, it appears to me that it is a bit stretched to say that the tribunal would have jurisdiction to cover that. I mean, the other side would definitely object to that. But again, if you take that from a perspective that the contract was somehow impeded or the breach was embedded in otherwise a broader web of violations in which human rights were infringed upon, then why not?
Thank you. Well, I think everybody would agree that COVID actually changed a lot the way we work these days. So I don't think we see paper so much these days at all. And I'm now handling a case in Hong Kong, and the tribunal is about to deliver the second partial award in our favor, hopefully. And the tribunal comes back with a question: do you want us? Would the parties accept the electronically signed award as the award in this arbitration? And the respondent, who is apparently losing, says, "Well, yeah, of course." We, as claimants, have to be very annoying to the tribunal, who unsurprisingly sits in different parts of the world, to insist, well, actually, we would need wet signatures, please, because we're going to have to enforce it. It is a requirement under the New York Convention that we may have to submit the original of the award or its certified copy, and you never know which jurisdiction have what type of rules in this regard. So with that, it is my absolute pleasure to introduce our guest speaker today. Marike Paulsson has so many positions and so many titles, but I was kindly permitted to introduce you by the Secretary General of the Council for International Dispute Resolution of the Kingdom of Bahrain. Marike, the floor is yours.
Thank you. Well, we're off to a good start with Mr. Moderator referring to my many positions. So with that, and nobody laughs, gosh, I'm really not in Amsterdam. Anastasia, who is with me in the same mindset, is going to assist me about last night. And Julia and Valeria, can you come to the first row, please? Yes, first row, ladies.
Oh, that's nice, actually. I should do it next time. Thank you.
I stand between you and the coffee break, mindful. Yes. No, but you're also part of this. You're all part of this. If merchants see profit in peaceful commerce, they are less likely to deter it by fighting wars. I will repeat this until it sinks in, and that is my speech. But before I repeat that sentence, about last night, and about fairy tales, and about Sunday, I came to Russia and arrived Sunday morning, and I was taken to the ballet in the Bolstoy. What did I see? Julia, come. What did you show me?
Shurale, it's a Tatar ballet.
And where did it take place? Where was it?
You mean the ballet was, it was in Bolshoi, but the Tatar ballet is, I suppose, it must be somewhere quite close to Ural Mountains, as it is a story, it is a fairy tale about the Leshy from Tatar mythology.
Yes.
And it was nice. I hope you liked it.
I'm not sure you want this information to be revealed, but we were, as a matter of fact, invited by Julia to a restaurant where we shared a very nice meal and talked about vital topics of life.
Right, and it was, again, in the fairy tale, wasn't it? And we heard voices around us telling the fairy tale written by Pushkin. So I arrive in Russia and I come to Moscow and I'm just enveloped in fairy tales, and I come to beautiful theaters and I see stages transformed into forests with beautiful dancers. And then I go to a restaurant that is one of the most mesmerizing places that I've seen, from gold floors to crystal chandeliers and beautiful paintings and incredible food and desserts that were just so incredibly naughty, called nun puffs, with white cream, and Anastasia really enjoyed them, and we had wonderful conversations about life's questions. And so I decided today to stick with that theme of the mesmerizing fairy tales. And that brings me to the musical Don Quixote, the man from La Mancha. I see people nodding and others no clue. Go work on your art, I say. And so that musical has been referred to by the founding fathers of our world of international arbitration. Pete Saunders, who is the founder, the father, the author of the New York Convention, Judge Stephen Schwebel, who was the president of the International Court of Justice and one of the leading arbitrators, and incidentally, he was also an arbitrator in the Yugoslavia case. And then there is Vali Nariman, who was the legend of India. And they talk about that musical and the man from La Mancha and Don Quixote with this impossible dream. And why did they talk about this? Because in the 90s, some thought leaders thought, let's create a world court that deals with all New York Convention enforcement requests. And they said, that is the impossible dream from the man from La Mancha. So let's think about these stories and these fairy tales, because we're right there again in 2025. Now, I am supposed to talk about the chapter in this book, Mr. Moderator, is that correct?
Well, that was my expectation anyway.
And I so don't feel like it. You can read it, and if
but not necessarily, take your time.
You can read it, because if there's one thing I despise is to talk about something that you should simply read and not listen. I literally look in the audience and I see some people slightly asleep. So I will make it as interesting as I can. So since we talk about fairy tales and history, let's think about the beginnings of this. Today I've been listening to the incredible interventions, questions of the crisis, questions about arbitrators, questions about sanctions, questions about what makes a good arbitrator, questions about what makes great arbitration. And I am mindful that I can be quoted, that I can be filmed, and this is live streamed, and I will still make the statements that I'm about to make. Sanctions have been mentioned. We have been talking about where we are today, in which country we are today, and what is happening in the world. However, the whole idea of us, actors in international arbitration, was to take the political out. And perhaps we don't remember why. After World War II, there were leaders, the greats, like Piet Sanders and those who came before him, who came together and decided to create a neutral court, the International Court of Commerce. And that was somewhere between actually World War I and II, around those times of turbulence. And it was in that aftermath that Piet Sanders went to the United Nations and wrote the United Nations Convention for the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention. The idea was the ICC, the New York Convention, to take the political out. In the midst of unimaginable turmoil that the world was recovering from, the idea was to create a universe for international and neutral justice. The idea was to create a community of gatekeepers who would provide neutral justice. If merchants see profit in peaceful commerce, they are less likely to deter it by fighting wars. That was the spirit of the arbitration system that was created back then and that exists today. And that worked for a very, very long time. In the 90s, when this suggestion was made to have a world court, the leaders of that time, Martin Hunter, Stephen Schwabel, Piet Sanders, said, we are not doing this. We will trust our actors, we will trust our arbitrators, we will trust our international arbitration institutions, we will trust court judges. Piet Sanders was then again interviewed in 2011. And I'm very mindful saying this, being with my wonderful friends of the Russian Arbitration Center. He said in 2011, what is the future of international arbitration? Diversification. I'm also looking at my colleagues from Hong Kong. I think my colleagues from Singapore are here. Diversification of arbitral seats. He said the epicenters will no longer be London and Paris. It will be everywhere around the world. What he predicted was that international arbitration was going to thrive globally. In 2008, again the thought leaders came together. It was Dublin, ICA, Bernardo Cremades will remember very well, and Aubrey-Anne Vandenberg made a proposal to replace the New York Convention. Now, I worked for him. There were cases mentioned today, very familiar to me. And in full disclosure, he didn't really want to replace the New York Convention. He was asked to celebrate the New York Convention's anniversary and did that through the exercise of rewriting the New York Convention if he could rewrite it in 2008. It was welcomed with outrage, especially by the leadership of UNCITRAL. We shall not touch the New York Convention. Fast forward the Achmea case, fast forward the European Union wanting to overhaul the entire system of investor-state dispute settlement. And we found ourselves at UNCITRAL, the International Trade Law Branch of the United Nations, considering the idea of, again, a world court that is to address disputes between investors and states. Fast forward 2 years ago, where that Working Group 3 about investor-state dispute settlement gave inspiration to Working Group 2, commercial arbitration, where a state delegation proposed, and here it is, to perhaps replace the New York Convention or have a protocol or an amendment. We took and brought the political in. That is where we are today. I go to many conferences held by and convened international arbitration specialists. I listen, and I think you can talk as much as you want, and you can preach to each other, and you can talk about little tweaks, and you can talk about everything is great, but at the United Nations, states are bringing the political in. And it might lead to an overhaul of the system. It might lead to a replacement of the New York Convention. Why is that bad? Well, let me respond to the discussions about sanctions and why I was not worried. Because I believe in the New York Convention. And there's one case, the Cubic case, which was rendered, long and behold, by a US court in New York in the Second Circuit. A case that involved goods, assets belonging to Iran, and the question was, of course, can you enforce and execute because of the sanctions? And this court said, so it's a public policy argument, and this court said, no, there is no place for that in the application of the New York Convention. We only apply a very, very narrow concept of international public policy. It was the guardians of the New York Convention, the national courts, who kept the political out. That was the power of international arbitration, and that is the power of the New York Convention. And yet here we are, in the past years, Working Group 3, Working Group 2. It has now trickled into the OECD, where states want to replace bilateral investment treaties and take investment protection out. But what troubles me the most, and I know I'm live streamed, is that I go to international arbitration conferences like the IBA, like the LCA. I go to Paris, I go to London, and the political came in. All of a sudden we have to pick sides, all of a sudden we have to talk about what's happening in the world, all of a sudden we have to gloss the system of international arbitration with geopolitical turmoil. Whereas the whole origins of international arbitration was that no matter what happens in the world, we have this system of neutral justice. If merchants see profit in peaceful commerce, they are less likely to deter it by fighting wars. We need to get back to that origin. And so I am not here today to talk about my chapter. I can get into the drafting history, I can get into Article 1 of the New York Convention, I can talk about cases, I can have slides where I map out those cases, I can talk about the Vienna Convention on the Law of Treaties as to how to interpret Article 1. Does an electronic award fall under the New York Convention? But I frankly do not care about that much today. Because we can go nitty-gritty on the technical, but if we are not mindful of the fact that right now we have one role to play, the writing will be on the wall. I am appalled when leaders in international arbitration from leading organizations such as the International Bar Association come to technical specialist conferences and make political speeches, even though I do it now myself. And I will explain why. As some of my fellow friends and colleagues pointed out, we have all represented certain clients. We have all been on both sides. We have all been counsel for respondent. We have been counsel for claimant. We have been counsel in commercial arbitration. We have been counsel in investment arbitration. And many of you sit as arbitrators. You follow the rules of our system. You look at the IBA rules, you look at ICSID, you look at the LCA rules, you look at the rules of the Russian Arbitration Center of Hong Kong, of Singapore. You look at your rules of conflict of interest. That's what matters. And what do you provide? Due process. Our role is not to judge, our role is to adjudicate, and our role is to provide due process. And as counsel, no matter whom we represent, we do the technical. We do international arbitration claims, we do enforcements, we do annulments, and we focus on the technical. I vividly remember, and I have published about this many, many times, so I can say it, I've published about the Yugoslavia case. I've published about it in my book. I have published what I call the Russian doll theory, and I've asked these questions. And Albert Jan would say what we do, whether we are on respondent side or claimant side, we provide due process. That's what we do. And that's what we need to remember. And this is why it's important when international arbitration specialists come together, think about our advocacy. Think about communicating vessels. Think about how you communicate with the stakeholders at UNCITRAL and the stakeholders at the OECD and the stakeholders at the IBA, because that is your job. It's your job to be the advocates for international arbitration, for the Nuremberg Convention, for the ICSID Convention. It's your job in all the cases that you do, that like Bernardo Cremades you adjudicate, and like so many as my colleagues on this panel and here in this room, you provide due process to the best of your abilities and to the most ethical self that you can be. And so I traveled here to Russia and I entered a fairy tale. And so far I've had great fun. Somebody during the coffee break said to me, I thought you were only going to participate virtually. But this trip is incredibly intentional. And in 2025, there is one trip that I will not regret, and that is this one. And that is why I wanted you to sit here, and you, Yulia and Valeria. Because I've known you for a while, and you display incredible strength. And I'm going completely off script, Mr. Moderator. You have organized today's arbitration day, and there is now what I call the Russian Arbitration Week, because there's plenty. You show London and Paris how it's done. You take us to fairy tales. You put us in a beautiful room. You have all these speakers. This is incredible success. How many of you are here and in the room? How many events are taking place? How many institutions have come to Moscow? The interesting panels, the topics, it took an enormous amount of work for you to organize this, but most of all, grit and courage that you decided to move forward and organize this week, right now, in this year, in this moment. I am in awe and humbled by that level of courage and grit. And it's because of that that I got on a plane to Moscow and St. Petersburg to show you not my support, but my incredible admiration. Thank you so much. Spasiba. Thank you.
Well, actually, after this presentation, I think it would be best to close the conference with and take away the wisdom you shared. But unfortunately, we have our own rules of play. So I think now we have time, a little bit of time for questions. I think by my calculations, we should have about 12 minutes now. So any questions from the audience? Do we have? So Mike on the first row.
Russian, if that's okay. Вопрос к...
My question to Sergey and Vadim. In the professional community, there's a widespread opinion that in current conditions, in particular, Iberable versus Stanko import, well, to have arbitrators from unfriendly countries or European Union is too risky for procedural reasons and for the dangers to the outcome of the case. But still, Russian parties still continue to appoint arbitrators from such unfriendly countries. Do you believe that such risks are not serious enough, or perhaps it shows that there's a kind of tactical approach to sabotage the procedure from the very beginning? So what does it speak of? What does it prove, perhaps, in your opinion? Thank you, Anton. There are different approaches. Perhaps some people want to have a bomb with the delayed action explosion. We remember the last year case of the grain arbitrage. Despite all the turbulence, it did not go ahead. And I remember my experience of working with the Russian cases, Yuko's case in particular. There are lots of European arbitrators who, in reality, are professionals, true professionals, impartial and biased, despite of whatever is happening. And though there are certain things related to their nationalities, but still in any outrageous Russian court, they won't be able to prove it. And I believe that it depends on people as elsewhere. There may be abuses there, but still there are honorable personages and candidates for arbitration. I agree with it completely. We live in such circumstances where international arbitration was developing in the West, so to say. And certainly their powers are more expansive. If you want to find an arbitrator for a specific case, you would rather find more candidates there on the part of those who introduce sanctions. And I agree with Sergei that neutral candidates are available. There's no problem whatsoever.
Hello. This is a general question for you, Marike, and others in the panel. Trade is increasingly being weaponized, and trade underlies the international arbitration system. Because it has been going on in an unlimited sense and unilaterally, how much do you think when you say that the political element should not enter the international dispute resolution system can be controlled with unlimited weaponization of the trade? I understand it's an ideal that it should not get affected, but what tools do we have to make that happen?
I just didn't catch the last part, with unlimited use of the
weaponization of trade. I mean,
yeah, of trade.
Through sanctions, yes. Through different limitations that are put in, quotas that are put in, tariffs that are put in. There are like various measures which different jurisdictions are trying in their own way to maximize their own optimal interests. I'm not saying just the conflicts, I mean, just optimizing your own interests, right? I mean, through tariffs and other things. Or overproduction, I mean, by some jurisdictions that let's flood the market with overproduction. So in this scenario, like what tools do we have to control that this political and all this turmoil doesn't affect the international arbitration system's famed neutrality?
Thank you. You just asked the $15 million or $1 trillion question that many leaders around the world are trying to address right now. If I have the right answer, then I will have a different job, I think, tomorrow, like, I don't know, Secretary General of the UN or something. So my answer will probably not be correct. I think what's important is, and what I've seen with the various positions professionally that I hold, Mr. Moderator, is in certain spaces where we operate, we are in this beautiful crossover of politics, he's trying not to laugh, politics, law, and diplomacy. So when I worked for Secretary of State Madeleine Albright, there was a real intersection between politics and diplomacy and law. And in that arena, it's very complex. In the arena of the United Nations, politics is there, and that's part of negotiations, and diplomacy is the core of negotiations. And so I operate in that space as well. And it's because of that that I would very much urge the arbitration community to stand tall. And with that, I mean the following. I'm going to give an example that I find very helpful and inspiring. And it's kind of the happy space that we need right now. It's the space of sports. I don't know how many of you have attended the Olympics or watch it on television, but the Olympics move around the world. And this was also a New York Convention question.
athletes, when they become an Olympian, have to sign contracts. And those contracts have a clause for the Court for Arbitration for Sports. A decision was rendered, and one of these cases somehow made it all the way to an enforcement court, because most of the times it has to be effect immediately. And the question was, are those awards awards under Article 1 of the New York Convention, because in a way they're based on mandatory arbitration. And it was a Swiss judge who said, the Olympics move around the world, but its dispute resolution system is stable. It's in Lausanne. And I find that inspiring because these shockwaves geopolitically that are happening now, through my work with the Global Institute for Peace Studies, we sit with a lot of former heads of states of Latin America. And the president of the Inter-American Development Bank said, when certain men were elected into certain powerful houses, white, he said, I'm not worried. These are waves. They come and go. These are the political patterns that we've seen for decades. I am not worried. There will be stability again. And that's very hard for some of us to believe, but there will be stability again. And while we are existing in more unstable times, some things have to remain consistent and predictable and stable. And that is boring, but sometimes boring is good. And when we think about building arbitral seats, whether it's in Moscow or in Hong Kong or Singapore, well, already they exist, they're very, very successful. When we think about emerging seats, other seats, like in the GCC in Bahrain, what do merchants, actors in international trade, and investors want? Stability, predictability, consistency. And that is very much our job, to be those guardians of that boring, stable, predictable framework of international arbitration. So while what you just mentioned, sir, all those geopolitical concerning developments, what we need to do is to make sure that the system of international arbitration remains and that the system under the New York Convention stays intact. And there are two ways to do that. One is advocacy with the stakeholders in the room. So that is UNCITRAL, and that's OECD, and that's UNCTAD, and even bilaterally, so governments. It is your job to be the advocates for international arbitration. And two, while you act in the space of international arbitration as counsel, arbitrator, court reporter, translator, junior, paralegal, technician, you do it right. You do it according to the rules, you do it in an ethical way, and you protect it because people are looking at us, that we do the right job. So that would be my very simple answer, but of course it's far more complex in reality.
Thank you. We'll take one more question. Yeah.
Thank you. Thank you so much. And thank you everyone for the interesting session. I would like to follow up to Marike's presentation for the obvious reasons, because at UNCITRAL we sit side by side representing our countries at these negotiations that you have been mentioning. And indeed, I would like to confirm and second that the major norm-shaping negotiations and arbitration are happening now in international organizations. It's UNCITRAL, OECD, it's also UNCTAD, speaking about the bilateral investment treaties reform. So I wanted to ask you maybe what could be, in your view, some practical options for the industry and for the audience at this conference to engage in this norm making. And apart from that, being the representative of the Ministry of Economic Development, basically, who represents at UNCITRAL, I would also want to make a statement that we are open for the expert engagement. For instance, Russian Arbitration Center has been our long-standing experts and supporting us at this negotiations, trying to keep the expert arbitration viewpoints and the positions in the room at UNCITRAL. also in other forums as well. So maybe it would be nice to highlight to the people sitting here so everybody can have an idea in mind how they can, let's say, support this norm making and to be heard, knowing that it's very important. Thank you.
Thank you. Julia's my partner in crime at the UN, where we explore. So true. What is frustrating, I think, to us is, for example, when I went to the IBA in London, there are these amazing superstars of international arbitration who speak at those panels and who have incredible insights. And sometimes I'm frustrated. For example, in Working Group 2 and 3 both, when we talk about the role of annulment going forward, the role of the New York Convention going forward. How do you appoint adjudicators? How do you remunerate them? How does this work in practice? That we try to make our interventions, but we do it as state representatives. That's very delicate. And sometimes I thought, oh my God, if my friends from international arbitration would be in the room, they would say, wait a second, you cannot just replace setting aside provisions of every national law. They would say that's absurd. But they're not in the room, they are in the other room. They are with the LCAA and with ICA and with IBA, where they discuss cases. And everybody understands what they are saying because the others are also arbitration specialists. What we really need at UNCITRAL and OECD and UNCTAD, but especially UNCITRAL, is for those top specialists to find a way to be present during these negotiations and take the floor and give the state delegations, in a way, a reality check and a fact check, and explain to the state delegations, wait, the New York Convention does not apply. Wait, this is not how you appoint adjudicators. Wait, you cannot change a national provision on setting aside. Another practical thing that we would really need at the United Nations is for specialists, the best and the brightest, to submit papers. So you can actually, for example, the delegation that's with the Russian Arbitration Center, you can submit a paper. And often those who are with law firms have more resources to draft these papers. States don't. Also, when we submit papers, it has to go through government processes, and that can take months. So in other words, we need your help in these political and diplomatic arenas to protect the system that you exist in.
Well, with that, it remains for me to close this panel, which I had a great honor and fun moderating. I just hope that everybody in this room gets out of the room as inspired as I am. Thank you very much, and now we have a coffee break.
First of all, I wanted to thank the organizers. I think it is really very important to see the reaction in Moscow about the arbitration challenge we have nowadays. I remember when I was contacted to come and invited to come to Moscow, probably the person who called me to come wasn't convinced that I wanted to accept. And I said, of course, I go right away. I think it's the moment in which we have to go to Moscow because we, the professionals of arbitration, we don't care about the politicians, about politics. We are professional. And I think the best proof of how arbitration is working is that we have created a very depoliticized instrument. We are just professionals settling disputes, and that's the reason of our profession. And I think it's the moment to be in Moscow, it's the moment to support what you are doing, and is the moment to find settlement, peaceful disputes, so that we can continue doing arbitration. And the topic I chose to write first the article and then to come to this conference is especially due process. Because what we do settling business dispute is probably, could you close the door over there? What we are doing every day in our activity is due process. Due process, every decision we take, being just procedural, just on the merits, we have to take into consideration due process. But sometimes we see along the hearings those aggressive US lawyers trained. They come to us and they say, I want you to accept something, for instance, a paper to be presented out of time, not respecting procedural order number 1. I want to introduce at the very last minute some witness, an expert, and we, the arbitrator, say, well, that's not in the procedural order. And they say, well, if you don't accept what I am requesting you, take into consideration the consequences. I make a reservation. And then the arbitrator knows that reservation is meaning that the award is going to be challenged. And not only to be challenged, the award, probably the arbitrators nowadays is going to take personal responsibility, if not criminal liability, like we are seeing recently in different cases. What is the difference between due process, which has to be present in our decisions, and when it comes to an abuse of due process? Due process is something that we know from the history coming from many years ago. We saw that already Edward III in England in 1354 spoke about due process. Due process said that nobody can be condemned without he being brought to answer by due process of law. We see the same thing in different parts of the world. Spain, Castilla, in Aragon, recurso de amparo was exactly in order to protect due process. And we see due process as well in the Declaration of Human Rights of 48, speaking about the impartial tribunal and independent in the determination of the rights and obligations. And the same by the European Convention of Protection of Human Rights of 1950. I think every constitution nowadays, at least my constitution, Spain, speaks about effective legal protection. Under no circumstances shall a person be deprived of the right of defense. How it comes to arbitration? Of course, the constitutional mandate has to come to arbitration. The requirement of due process as a constitutional guarantee is something that has been developing in Anglo-Saxon and continental laws as a fundamental right of the citizen. In arbitral proceedings, the basic rule consists of submitting to the principles of equality, fair hearing, and the right of contradiction. The parties should be treated equally, and each one should be given sufficient opportunity to present their case. Due process in international arbitration requires the arbitrators to conduct the proceedings and consequently draft their awards in such a way that their awards are enforceable. And this means that they should make their best efforts to ensure that their awards are not subject to annulment in the place of the arbitration, and that they are also enforceable where the person entitled to enforce them wishes to do so. And the arbitrators considering due process has to take into consideration conventional and customary international arbitration law. Especially customary, we know the New York Convention, we know the Washington Convention, 65, and the customary, it's very important that the custom has to have an opinio juris so that the custom could be enforceable. And what is the opinion juris? The opinion juris in the custom is exactly what the arbitrators are doing, repeating, creating, endorsing with the arbitral awards, endorsing this due process in each case. And the matter of due process appears in different stages in the arbitration proceedings. First, on jurisdiction, ultra petita and infra petita should be taken into consideration. Then, about the arbitrability, res judicata, lis pendens, forum non conveniens, amicus curiae, the decision to bifurcate the proceedings. Then, in the constitution of the tribunal, the impartiality of the arbitrators, etc., we could speak about every part of the activity of the arbitration proceedings. And at the end, we could say, to conclude, that access to justice has to be respected and the reasonableness of the proceeding has to be reasonable. Everyone should be treated equally, everyone should be heard. But what is the difference between due process and what is the difference about the abuse of due process? And then we have to face a very important part of the arbitration proceedings. Is it important that the arbitration tribunal, that the arbitrators don't seem to be a weak arbitration tribunal? I think they have to be strong. They have to hear everybody, but they have to take decision. Sometimes there is a great danger of the effective development of the arbitration proceedings. When the arbitrator, I see at the very beginning of the arbitration proceedings, being a chairman, I see how the parties react to the proposals, and I see if they are aggressive or if they are reasonable. And the arbitration tribunal has to react. Because at the end, they have to respect the process, but at the end, they have to be effective. The arbitration with a weak tribunal, at the end, the arbitration cannot accomplish the adjudication process they are obliged to. And that's the balance the arbitrator has to take between considering due process and being, if we are facing an abuse of due process, especially threatening that kind of consequences of not accepting that request from the parties. And that's the reason why the arbitrator has to be diplomat, balancing the questions. And it's very important because at the end, the arbitration is the crossroads of different cultures. We insist the differences between the Anglo-Saxon formation and the continental law formation. And sometimes the arbitrator has to balance. We, the continental, we insist very much on the written phase of the proceedings. On the continental, we see that the written phase is more important. On the contrary, our Anglo-Saxon lawyers, they believe that important is the oral part. Sometimes we see that documents, there is a real tsunami of documents, and the arbitrators have to really to pick up the real arguments of the parties. It happens very often that after listening to the parties, even in the merits hearing, we, the arbitrators, have to tell the parties, well, what are you claiming in this arbitration? Because they throw to us thousands of documents or email after this email discovery that we don't know exactly what's the case about. The same thing happens with witness. I mean, it's really fantastic to see a QC or now a KC conducting cross-examination to the witness or to the experts. Are they really thinking that the one who has to be convinced is the arbitrator, the arbitration tribunal, or just he likes to make the theater, just he is conducting the arbitration cross-examination to destroy the witness, to destroy the expert, without taking into consideration that the principal part of the proceeding is to convince the arbitrators. Sometimes he is speaking to the transcript, or he is speaking, in the worst case, to the client who is paying his bill. He is attending to the cross-examination. So that's something that probably the arbitrator, after seeing such a cross-examination, has somehow to stop it. And is that a violation of due process? It depends. And it has to be a very good diplomat, the president of the arbitration tribunal, so that he convinces why he believes that is not necessary to conduct the arbitration in such a cross-examination and details. The same thing with experts. We are really fed up about experts in most of arbitrations. Why this abuse of legal experts? If the arbitration tribunal is composed by 3 legal professors or legal practitioners, is it necessary to present such a kind of expertise that at the end the question to decide has nothing to do with the technical expertise presented by the parties? Is the arbitrator entitled, is the arbitrator obliged to interrupt, to say, no, we don't need that? I mean, as you see, that's a balance he has to take about due process, respecting due process and abuse of due process by the parties. But it happens that the due process could be breached, and then the risk of the breach of the due process is that the award could be annulled, that the award, at the end, who is taking the risk of this annulment? Not the arbitrators, in principle, but the parties who wins the case, because he sees that even if he has won the case, the arbitration award is annulled because it was a violation of due process. I think it's important to see that the arbitrator could take responsibility, and we see nowadays the responsibility of arbitrators, because the arbitrators, they have a contract with the parties, and they have to conduct in a very efficient way the arbitration. If they don't do that, if the award is annulled, if the award cannot be executed, there must be some person responsible for that. And that's the reason why nowadays we see that the arbitrators are being liable in the civil proceedings cases before the tribunals, or even we see the criminal action against the arbitrators in such a case. That's happening because of the abuse of due process, and that's something has to be important to take into consideration. Nowadays, we can say that due process is not only a shield, but a sword, in the sense that due process could be protect the parties, protect the arbitration, but anyhow, the due process could be threatening the arbitrators in the sense that they could be consequences of violating the due process. Nowadays, the arbitrators have to be very good diplomats, balancing the doubt they have when he has to discuss with the colleagues about accepting this claim of due process or rejecting for the efficiency of the arbitration proceedings. It is very important that nowadays arbitration has to be respected. We heard in the session before that at the end politicians are criticizing arbitration. Politicians, they want to create arbitration tribunals. My answer to that is, do we need those arbitration tribunals? Are the politicians just creating bureaucracy, just creating bureaucrats in order to be sitting very quietly as a public employee with good salaries, good retirements, and I don't know, important thing in investment arbitration, in arbitration, commercial arbitration as well, is the confidence of the parties. The parties have confidence in the way arbitration, commercial arbitration, and investment arbitration is now proceeding. And that's the reason why I think we cannot listen to politicians that nowadays they want to modify everything. And instead of accepting that the business community is very happy and very satisfied the way it's done in the arbitration nowadays, they want to create something new. And we see that Ancitral, Group 2, Group 3, they speak a lot about creating things. The European Commission, they are very likely to introduce arbitration tribunals, which are not arbitration, but judicial tribunals. We have to accept that our system is functioning. And in order to conclude, I will tell you what happened to me a couple of months ago. I was in Qatar, and for one reason, I wanted to visit the president of the Chamber of Commerce, and I asked for an appointment, and when I opened the door, the president of the Chamber of Commerce, who is one of the members of the royal family, said, "Mr. Cremades, I know you, and I know you very well." I say, "Well, why do you know me?" When you happen to be arbitrator in the Wintershall case against Qatar, in which we were discussing one of the most important natural gas resources in the world, in that case, you deliver an award. And that award, I must tell you very frankly, is the reason why, enforcing the award, we have had this economical development in Qatar in the last years. I was really very proud, and I think that's the way arbitration is doing and conducting nowadays. Even if when we deliver our award, we don't know, probably for years, and in one Congress, we heard that the award has been ratified or annulled by an arbitration tribunal, or we see some consequences, but normally we just deliver our award. We don't know what's going to happen. In that concrete case, the Minister for Natural Resources, who used to be at that time and now is President of the Chamber of Commerce, said, "Mr. Cremades, your arbitration award was the reason of our economical development of Qatar." I think we have to be very proud. Arbitration is working very well. In Spanish we say, "Virgencita de mi vida, que me quede como estoy." Please leave things like they are. Thank you.
Thank you, Bernardo. Now, let me introduce. Теперь позвольте мне представить.
Now I'd like to introduce our next speaker. This is Maxim Asachi, and Maxim is partner and founder of Asachi Dispute Resolution. This is a specialized company on IR, and he is a solicitor for England and Wales, Russian lawyer. Also, he can practice in the state of New York. And Maxim represented clients in more than 25 arbitrations in different fields. Maxim also is participating dynamically as an arbitrator, HKC arbitrator. Also, he was the arbitrator in LCIA and Russian Arbitration Center. I believe that now in every investment arbitration, the government is questioning the jurisdiction of arbitration, which was formed for the investment disputes. And that's why the issues regarding the jurisdiction, well, this is always a preliminary issue, and Maxim is going to talk about judicial review of non-exceed awards, so the matters of jurisdiction. Maxim wrote his article in English, so maybe he's going to speak in English.
It's a great pleasure and a privilege to be here. Thanks very much to the Russian Arbitration Center for organizing this conference. And thanks to you, Dmitry, and your excellent team for putting together this tremendous panel. The topic I want to discuss today is judicial review of non-exit awards on jurisdiction at the post-award stage. Specifically, I want to look at the standards that national courts should apply when reviewing arbitral jurisdiction in investment treaty context. Now, as many of you know, questions of arbitral jurisdiction, that is, whether an arbitration agreement exists and whether a particular dispute is within or outside the scope of that agreement, are generally always subject to review by national courts. And arbitrators' findings with respect to those matters are provisional only and generally not final. What is less clear, however, is how national courts are supposed to review those jurisdictional findings at the post-award stage. Is it a de novo standard of review, that is, full and complete rehearing of the matter with new evidence, new arguments at the post-award stage, as if the underlying arbitration never existed or happened? Or is it more of a differential type of review, where some deference is afforded to arbitrators' findings on questions of jurisdiction, and new evidence and fresh arguments are admitted in limited circumstances only with the court's permission? So my question today is, what is the appropriate standard of review when it comes to investment treaty awards? Is it de novo? Is it differential? Is it something different? Now, to answer this question, I suggest we look at three things today. First, the framework that applies to review of arbitral jurisdiction globally. Second, the practice of certain countries with respect to review of jurisdiction. And third, and finally, we'll consider what would make most sense for investment treaty awards in light of the unique features of investment treaty awards and the challenges they pose to national courts. Now, beginning with international framework first. A natural starting point in any discussion of the standard of review of arbitral awards is, of course, the New York Convention and the Ancestral Model Law on Commercial Arbitration. Now, the New York Convention grounds relevant to jurisdictional challenges are found in Article 5 of the Convention, and many of you will be familiar with the language of this provision. A foreign arbitral award may be refused enforcement where, among other things, first, the arbitration agreement is not valid under the relevant law. That's the ground that deals with the existence and validity of the arbitration agreement. That's Article 5.1a. And second, the award deals with a difference not contemplated by or not falling within the terms of submission to arbitration. Now that is the question of scope of the arbitration agreement, and here we're looking at 5.1c. So what we can see from these provisions is that they are not terribly helpful when it comes to review of arbitral jurisdiction. They do not tell you the sort of factors that the tribunal national courts, can or should take when reviewing arbitral jurisdiction. All they do is essentially reaffirm the power of the reviewing court to refuse enforcement of an award in certain circumstances. Now, you can look at the model law on commercial arbitration as well, but the answer is going to be the same. That is, these founding instruments are practically silent on the nature or mode of review that national courts should apply when reviewing jurisdictional matters. So, in the absence of any meaningful guidance from these meaningful instruments, courts across the globe essentially had no choice but to develop their own standards. And in most cases, they developed de novo, full review of jurisdiction. I do not, of course, propose to discuss all the relevant jurisdictions. Instead, we're going to look at two in particular. First, England and Wales, and second, Switzerland. Why these jurisdictions in particular? Well, because these are very good examples of two principal models of review. England and Wales, de novo review, at least until recently. Switzerland, limited, more differential review of arbitral jurisdiction. So starting with England first, English courts would typically conduct a full and complete rehearing of the matter, not just review, both with respect to matters of law and with respect to elements of fact. They would give no weight to the tribunal's own view of its own jurisdiction, however full was the evidence before it, and however carefully deliberated was its conclusion. So it doesn't matter that you may have arbitrated this particular jurisdictional point before the tribunal for months, if not years. It doesn't matter how much evidence you adduce to the tribunal on that particular point, nor does it matter how prominent or otherwise the tribunal is. From an English law perspective, for an English judge, it's irrelevant at the post-award stage. Now, the rationale for this approach is that, and judges repeatedly emphasize this point, the court should not be placed in a worse position than the arbitrator for the purposes of determining challenge to jurisdiction. Now, as a result of that approach, fresh evidence and new arguments are permitted as of right, even in circumstances where the party challenging jurisdiction participated in the underlying arbitration. In theory, courts may refuse the admission of new evidence at the post-award stage in the exercise of the case management powers. In practice, circumstances would be extremely rare where courts would feel comfortable saying no to fresh evidentiary materials at the post-award stage. Now, the same de novo standard that I just described applies both to commercial and investment treaty awards. Courts do not generally distinguish between these two types of awards when reviewing matters of arbitral jurisdiction. Now, just to illustrate how this de novo review could work in practice, let's look at a very recent challenge before the English courts against a high-value, high-profile ancestral award against the Czech Republic. The underlying arbitration was initiated by Mr. Josef Stava, a Swiss national, and the company he allegedly controlled, Diag. Now, this was a very fact-heavy, very complex arbitration dispute that concerned an investment in a blood plasma venture. The Republic challenged the tribunal's jurisdiction on multiple bases. A major aspect of the challenge was the allegation that there had been no qualifying investor in that dispute on the basis that the shares in the claimant had been transferred to a trust. And that, according to the Republic, meant that the relevant company was no longer controlled by the Swiss national, and therefore the necessary requirements under the underlying Switzerland-Czechoslovakia bilateral investment treaty were not satisfied. So was the company still under the control of that Swiss national or not? That was the key jurisdictional question. The tribunal said it was, and assumed jurisdiction. The first instance court, Justice Foxton, agreed with the tribunal and dismissed the challenge. The Court of Appeal, however, disagreed with the findings of Justice Foxton and set aside the award in part. Now, to put this in its proper context, the award was rendered in May 2022. The Court of Appeal rendered its decision just days ago, literally last week, almost exactly 3 years after the award was rendered. The challenge involved multiple witness statements, voluminous expert reports on Liechtenstein law, a 2-week oral hearing, just the first instance, hundreds of new exhibits and legal authorities, and it resulted in 2 lengthy judgments, 100 pages each. So much for efficiency of international arbitration. And I'm using England and Wales as an example only. It is by no means an outlier in the way it treats jurisdiction at the post-award stage. France, Sweden, Canada, the Netherlands, they all broadly adopted the same approach to review of arbitral jurisdiction. Now, before moving on to Switzerland, just one quick point on this jurisdiction. That approach to jurisdiction that I just described is going to change slightly thanks to the reform of the English Arbitration Act. So hopefully the scope of review at the post-award stage will be narrower going forward, but we shall see. So at the other end of the spectrum, we have Switzerland, a jurisdiction that has traditionally employed a more differential approach to review of jurisdiction. In Switzerland, courts typically would not review arbitrators' determinations with respect to questions of fact. They may review determinations with respect to questions of law, but in terms of new evidence and new arguments, generally new materials are not admissible at the post-award stage. So a much more differential and much more accommodating review when it comes to arbitrators' findings on jurisdiction. A very good example of that approach is a relatively recent decision in the Rikofi v. Vietnam case. Again, it was an investment treaty arbitration seated in Switzerland. There was a negative jurisdictional ruling from the tribunal denying the submission that the investor had properly qualified within the terms of the relevant BAT. So the Swiss Supreme Court, when reviewing that challenge, stressed and stated very clearly that it will not supplant or complete factual determinations. It's not its prerogative. It would defer to the tribunal's findings on these matters. All the court would do, it would review whether the finding had been correct. And in that particular case, the tribunal concluded that indeed the members of the tribunal had got it right, and therefore dismissed the jurisdictional challenge. Now, Switzerland is not the only jurisdiction that employs that somewhat differential, more accommodating approach. You also have Singapore, for example. In that jurisdiction, there are likewise limitations as to the type of fresh additional materials that can be introduced at the post-award stage. And the US, potentially, where the parties can agree to insulate the review of most jurisdictional questions at the post-award stage. Now that we've looked at those two principal models of review and hopefully have been able to observe some of the potential concerns with some of those models, let's return to the question I posed at the beginning of the presentation. What would make most sense for review of investment treaty awards? Now, I submit there are very good reasons to argue that de novo review may not always be appropriate and that a more limited review of jurisdiction could make more sense for investment treaty awards. And there are at least 3 reasons that would support this proposition. First, to state the obvious, challenges to jurisdiction in investor-state proceedings are often complex. They often involve very tricky issues of public international law, state succession, human rights, questions of treaty interpretation, not to mention very complex issues of fact. Now, in a typical commercial arbitration, you're dealing with a binary type of outcomes. Is there a valid arbitration agreement? Yes or no? Is this particular dispute within the scope of the arbitration agreement? Yes or no? It's far from being that straightforward. In investment treaty context, take, for example, determining whether there is a protected investment. The tribunal will usually face a range of arguments as to what did and did not constitute a contribution, what assets were or were not owned or controlled by the investor, and when they came into existence. So very different questions indeed. So that depth of a factual inquiry the tribunal has to undertake would be very, very unusual even in a large commercial arbitration case. It's not obvious to me that national judges in all relevant jurisdictions are sufficiently well equipped to deal with those matters. Given their background, given the sort of cases they are dealing with, they are not public international law specialists. And some commentators argue that in most instances, the arbitrators whose award is being challenged are far more experienced and better placed and better qualified to determine those jurisdictional matters, which would then be reviewed de novo again by national judges. Second point here, and relatedly, because treaty cases are complex, they tend to take longer and are often more costly to resolve. Well, that means that a set-aside decision or any unjustified attempt by national courts to reassert the reviewing powers, the national domestic level, may come at an even greater cost for efficiency of international arbitration. So I just referred to that set-aside decision in England, and English courts tend to be very efficient, very quick. Even in that case, 3 years after the award was made. Third, de novo review may pose significant difficulties in terms of fairness and can potentially be used to abuse the process and incentivize a recalcitrant party to essentially hold back the relevant evidentiary materials until the award is rendered. And once the award is rendered, surprise, surprise, we have new evidence, you need to reconsider the whole thing again. So the party defending against the challenge essentially will face not one, but 2 full hearings before different adjudicators on the exact same issue. Now, the time and cost it may take to resolve these issues, first before the tribunal and then before the court, may be very significant. And the thing is, and we've been there before, even if you ultimately prevail, i.e. the challenge is dismissed, there's considerable prejudice to the party defending against the challenge. So should we bid farewell to de novo review for investment treaty awards? Well, not so fast. There are also factors that would in fact militate in favor of a more expensive review of jurisdiction at the post-award stage for investment treaty awards. First, don't forget that investment arbitration tribunals deal with very important public international law sovereign issues. They often arise in public international law out of public international law instruments and involve review of states' public policies, acts of legislature, executive and judiciary. That nature of the questions tribunals have to decide could in fact suggest in favor of a more expensive review. So it's very important that the tribunals get it right, because if they don't, there will be very significant consequences for the entire state, not just a business company, not just an individual. Now, second, that concern about disparity in the level of competence, knowledge, expertise between arbitrators on the one hand and judges on the other may be overblown. Look at judges in Switzerland, Swiss Supreme Court. Look at judges in the UK. Of course, parties are not happy when the award is set aside, but I'm yet to hear someone saying that, well, the judge just didn't get it. They didn't understand the issue. No, judges in leading jurisdictions may be sufficiently well equipped and well qualified to deal with complex public international law matters. And courts very often in other contexts do deal with public international law matters. Questions of immunity, human rights, standards for payment of compensation in the context of appropriation. Courts in leading jurisdictions routinely deal with those matters. A third point here about the so-called inherent dangers of de novo review and the difficulties they allegedly pose to the efficiency of the process. Now, question is it the case that parties choose investment arbitration because it is an efficient process? Maybe, but you'll find difficult times trying to find empirical evidence to support this. And leading commentators, including Anthea Roberts, for instance, she thinks this argument is misplaced. Her view is that in commercial arbitration, it may well be that we expect arbitration to be efficient. In investment arbitration, that argument simply doesn't work, in her view. So, pulling the threads together, and I'm sorry, it's probably a lot to take on, and I'm not offering any answers. So, yes, there are very good arguments to support the view that de novo review jurisdiction can help ensure legitimacy of the arbitral process and guard against the risk of jurisdictional overreach. That arguably is potentially important given the nature of important sovereign issues involved in the tribunal's determinations. At the same time, a full review of arbitral jurisdiction can lead to considerable inefficiencies and defy the presumed intention of the parties to have proceedings largely detached from national level. And these considerations could potentially justify substantial deference to arbitral tribunals when dealing with matters of jurisdiction. I'm out of time, just two final points. The first is my first takeaway. Matters of arbitral jurisdiction are complex and require very careful attention. Second, investment treaty awards are sufficiently distinct, if not unique, to require very careful attention and potentially treatment different from the one that has been accorded thus far to commercial arbitration awards. That's it. And thank you very much for your attention.
Thank you, Maxim. Before you lead, may I ask you one question? So I understand that you are proposing to have in place uniform standards of review, correct?
No.
No. So what you are proposing it then?
We may well have different standards of review. I'm proposing to stop thinking about matters of jurisdiction in a monolithical way. I'm suggesting to critically assess where we are now and think whether a better standard or a different standard would be more appropriate for investment treaty awards.
And I think the question is not the preparation of the local courts, but probably the lawyers. I can give you the example. I was in the tribunal appointed by the Russian government in the Pugachev case against Russia. And with the arbitration tribunal, we had to decide where the seat was. And I proposed to go to Madrid for different reasons. Everybody was in the room, the three of us, and they said, well, but do Madrid have experience? The Court of Madrid do have experience in investment arbitration? Say, no, but what we need is reasonable judges. At the end, we delivered our award. It went to the Tribunal for Annulment, and it went afterwards to the Constitutional Court of Spain, and they ratified the award. Why? Because the presentation done by the lawyers were convincing. And normally, at that level, in every country, you find the most prepared lawyers. And if the most prepared judges, if the lawyers are at that level, probably the guarantee of the investment arbitration awards are also guaranteed.
I'm not sure if we still have time to amend the article that was already submitted. If there's an option, I would do that based on this suggestion.
Thank you, Maxim. So we heard a lot about politicians who want to create a new arbitration forum. We are We heard from Bernardo his recollection about the Working Group 3 and the European Commission proposal to create a judicial investment court. And now let me introduce the next speakers, Andreas Schregenberger and Rodrigo Care. They prepared their joint article on the creation of the tribunal in respect of sanctions and claims between Russia and the European Union. A short introduction of the authors and the speakers. Andreas is a counsel at Gabriel Arbitration in Zurich, Switzerland, and he is admitted to practice in Swiss courts. He acted as an arbitrator, counsel, and secretary in more than 35 arbitration cases. Andreas got his law degree from the University of Zurich, and he received LLM degree in the Georgetown University. And Rodrigo is a senior counsel at Galadari Advocates and Legal Consultants in Dubai. Rodrigo is admitted to practice in the courts of New York, Italy, and DFC. Rodrigo acted as counsel and arbitrator in more than 40 huge disputes under the rules of the ICC, LCA, ICSID, DIC, DFC, and DGM. Rodrigo received his law degree in the US and in Italy. So, gentlemen, who is going to start? Both of them in parallel. Okay.
Yeah, okay, perfect.
If it's split.
Yes. Спасибо. Я очень рад быть в России.
Well, I'm happy to be here in Russia, in Moscow, with my friends, among my friends, rather. My colleague Andres and I, we have studied how difficult it is for the Russian investors to be in Europe, in the world, where they encounter lots of problems. It's a problem to do business, to live normally. And it is hard to have fundamental rights as well. I'm sorry for my Russian, it is bad. And now I'll go over to English.
So we have a few slides. I'm not sure who is dealing with them. Okay, so I'll ask Andrey to be my navigator. Thank you very much. So the idea of the Sisyphus struggle, going back to Greek mythology, Sisyphus was a person convicted by the gods to roll a boulder uphill for eternity. And every time the boulder will go up and he will reach the peak of the mountain, the boulder will go back at him and his struggle will continue again. And we think it's a little what we're seeing today with the political situation in the world, and in particular what is affecting companies from Russia in their investments abroad. And so we see in these slides the asset freeze. And why in this tribunal in particular we're looking at the situation of the European Union, because very clearly the majority of Russian assets are in Europe. We're talking about 300 billion euro, of which over 200 only are in Belgium, frozen by Euroclear. Of course, there are some assets in the UK, and in the United States and in Switzerland as well. But really, the majority of those assets, in our understanding, are in the European Union. And why obviously, Europe now is, next slide, Andres. Europe now is at a crossroads. So we have seen in the last few months with a few changes in the political landscape in the US and also in Europe. Europe is a bit shifting its historical stance as a very close ally of the United States, where the new president, President Trump, has warmed up the situation. The EU seems to stick with its approach. And so we have yet to see how that situation will evolve. But I think a prediction that can be made is that the EU law of sanctions will become more and more important in the future than it is today, where the EU was so far a follower of, in particular the European Commission was following OFAC regulations. Today, we might go to a world where the EU will become the leader, will become the leading enforcer when it comes to Russian sanctions. And so what are Russian investors doing in the meantime? Next slide. We have seen the first investor-state cases arising from the current situation. As Professor Cremades illustrated, investor-state works. There are treaties, there are protection. There is now 70 years of history of these treaties being enforced and rights being asserted in arbitration. But the problem is what happens next when you have an award. You might get a novel jurisdiction. You might get an award which never gets enforced. An example that comes to mind in the Tatneft versus Ukraine case. Tatneft won the case, but I don't think Tatneft has got paid yet. And so how of course, Professor Cremades might disagree, but we think the problem with the investor-state treaties today is that they work very well, but the problem is what happens after that. The problem is enforcing those awards, and we have seen that with ACMEA, and I think we might see that again with these awards. And so we look back at the past, and now I hand it to Andreas. They look at what we think is the important example in the past of the Iranian tribunal.
Rodrigo, thank you so much. I also want to take the opportunity to express my extreme gratitude to be here today with you and to have the opportunity to present the proposal of a Russia-EU Claims Tribunal to you. Rodrigo and I believe that the past is important to understand the present and to anticipate and have visions for the future. On the present slide, you see a brief overview of the historical Iran-US crisis. It is well known that Iran is extremely rich in oil, and the Shah, the former Shah of Iran, during his reign in the 50s to the 70s, tried to diversify the economy beyond oil, and for that reason attracted a lot of investment, in particular from the United States. At the same time, the population of Iran was not very So large segments were not very happy with this development, as they did not adequately benefit from these developments. This was one of the reasons why the Islamic revolutionaries were popular enough to overthrow the Shah in 1979. And the climax of the Iran-US crisis was in November 1979, when Iranian protesters invaded the US embassy in Tehran and took around 50 US nationals as hostage. In response, the then President of the United States, Jimmy Carter, froze all Iranian assets subject to US jurisdictions, and all the US corporations who had investments in Iran tried to attach Iranian assets with the US courts. Now you can imagine this was politically a very tense situation and very hard to overcome with diplomatic means. Then that's why we think we can draw some inspiration for the present situation between Russia and the West, and in particular the European Union. What was very helpful for a successful negotiation of a solution in this scenario was a third-party intermediary in the form of the government of Algeria, which helped the two states to indirectly negotiate a treaty or a series of treaties which are famous as the Algiers Accords. As part thereof, they agreed to establish a new independent international tribunal to settle all the claims between their countries and the respective nationals. I think this is, for the time being, enough of the past. Of course, history never repeats itself in the exact same form. So on this slide, you see some differences between the situation from then and now. In particular, in the Iran-US crisis, there were only two nations involved, while today multiple nations are involved. And you can say that the current situation has a global reach, while the situation in the end of the 70s was of limited scope. Also important was that the banking connections at the time were not as elaborate or as globalized as today. And I think this is then, with this I give back to Rodrigo, because I think this is an important factor today.
I can address the next one. So what is the current situation? So in Paraguay today, as much as Iranian investors and Iranian nationals have been locked out of the markets for until recently, this is a situation that Russian investors and Russian nationals are seeing now. With the sanctions bite not only at national level, but also secondary level, they even bite in countries which do not have sanctions regimes. Today, even in the UAE, even in Turkey, it's difficult for Russian parties to operate, to make financial transactions, because of course all banks need to operate in the international financial markets. Next slide. And so what are currently the remedies? Well, one remedy technically could be a claim before the ICJ, but that would require the Russian state to espouse the claim. Another avenue is the Human Rights Court, and in particular in the EU we have the European Court of Human Rights in Strasbourg, but there is consolidated jurisprudence under the Bosphor case that the European Court of Human Rights will not give relief if the sanctions derive from EU legislation or what the so-called equivalent protection principle. That is, EU law already contains, according to the European Court of Human Rights, enough guarantees, and therefore the ECHR cannot review that legislation. Then we have friendly jurisdictions, UAE, Turkey, and Hong Kong. But again, even in those jurisdictions, we have international banks, international companies operating, and that creates difficulty. Finally, investor-state arbitration. We saw some pending cases in the past. We've seen pending cases involving Russian investors. But again, as discussed earlier, the problem is getting these awards enforced. Andreas, next slide. But I think it's very interesting to look at the recent precedents in the EU Court of Justice. Only last year there have been 75 cases filed by Russian nationals challenging EU sanctions. And I find very interesting, in particular, in the so-called Friedman 2, because Mikhail Friedman filed two cases, one where he succeeded, and the second one against certain other measures, where that challenge was rejected by the EU court. And interestingly, the EU court said that fundamental rights are not absolute, and their exercise may be subject to restrictions. So we have the EU court saying that fundamental rights are not absolute. I think it's quite a development for a jurisdiction like the EU. And that makes us wonder whether rule of law is still there, whether Europe can still shed a light in terms of what the rule of law is. In the UK, we have seen in January 2 cases going to the UK Supreme Court. One is Schwidler, and the other one is Dalston Projects. Dalston Projects is a case where a Russian national had a yacht in England, and that yacht was frozen just because the person is a Russian national, nothing else. It's not sanctioned, it's not involved in any particular business, and his vessel was frozen. And then, of course, there have been some developments also in Switzerland, of which Andreas will tell us.
Yeah, I mean, I maybe just say one thing, that I have been in touch with the SECO. Some of you might be familiar with the SECO. It's a department who gives licenses on the Swiss sanctions regime, and I asked them last week whether there was any successful challenge of a delisting application ever in Switzerland, and they did not want to give me a direct response. So we must assume that there was never one so far. If you want to have details to which body you have to do an application, then you find this information in our article. That I hand over back to Rodrigo.
Thank you. So next slide. So when it comes to investor-state arbitration, as discussed, there have been precedents, there are pending cases. Those cases may succeed on certainly arguments concerning expropriation, breach of fair equitable treatment, and full protection and security in some cases. And of course, states will likely present defenses based on public international law, doctrines such as clean hands, and state countermeasures. But in some of these cases, it is possible that the Russian investors might prevail. But then the question comes as what happens to these awards? We have seen in recent EU sanction packages, there is something called a primacy of EU law and no claims provision. So there might be an argument for European states that all claims involving sanctioned entities are not enforceable under EU law. And then here we go to the next slide. That is what we think Sisyphus struggle. The moment Russian investors obtain an award, obtain a judgment that can be in investor-state tribunal, can be in Moscow, here in Moscow under the Lugovi law, can be in a state court. The problem is that as much as the boulder can go up on top of the hill, that boulder goes back at the investor. And we have another example in the Dayani case in South Korea. Iranian investor challenged certain measures enacted by South Korea, won the investor-state arbitration, but then that award was never enforced because South Korea refused to pay the award because of US sanctions. And with that, we look at what is the solution that Andreas and I are proposing, and I leave Andreas to tell us.
Thank you, Rodrigo. I mean, for the audience, isn't that striking? We actually have not a rule of law, but a rule of the boulder. And in that respect, I also want to remind the audience of an early presentation today by my Swiss colleague, Sebastiano Nessi, who mentioned that, or raised the question whether there is a deadlock for Russian parties in international arbitration. That's precisely where our proposal locks in. We believe that the establishment of a new international tribunal to settle investment claims by Russian and Belarusian nationals against states deemed as unfriendly by the Russian Federation, or nationals of unfriendly states against the Russian Federation and Belarus, is indeed necessary to overcome the current struggles. Of course, the just mentioned scope could be expanded so that all countries who have adopted sanctions against Russia would be part of this tribunal. Here on this slide, I just want to draw your attention in particular on the security account. We think that a security account mechanism which would pay the proceeds to successful claimants would be very important to incentivize parties to comply with the respective award. And this would actually then in the end guarantee the rule of law and a fair access to justice of the parties. To the institutional framework, that's the question how such a tribunal should be established, what should be the basis for it. Here we think that one can draw a lot of inspiration from the Iran-US Claims Tribunal. Overall, the key performance indicators of the new tribunal must be inclusivity, neutrality, and effectivity. In our view, the following key features of such a tribunal are essential. First, a neutral intermediary. We submit that only countries that have not adopted any sanctions against the Russian Federation are realistically acceptable for such role from a Russian perspective. We are thinking of countries who have maintained diplomatic relations with Russia, in particular since 2022. This includes countries like Turkey, Brazil, or the United Arab Emirates. Then second, we think, because as I mentioned earlier, multiple countries are involved or are affected by the sanctions, it would be straightforward to have, in a practical approach, only a treaty first between Russia and the EU as a significant political bloc. Very important would be third, accession mechanism, which would allow parties to automatically gain the status of a membership. This would be advantageous for countries which are not party from the beginning, like the UK and the United States, which have significant stakes in this crisis, and they could join without having to renegotiate the treaty's core framework. Then, finally, we think it should also be possible that certain states can ad hoc participate and use the rules similar to the exit facility, to the exit additional facility. Then the tribunal architecture. This touches upon the question how, also not on what basis the tribunal should be set up, but how, what features it should have, and how it should be specifically designed. And here we think that most of these points can again draw inspiration from the Iran-US Claims Tribunal. I reckon we might have someone in the audience who actually served for the Iran-US Claims Tribunal, and we might maybe in the Q&A hear whether this is a realistic approach. Regarding the jurisdiction, we suggest that there is a definition of competence in terms of personal and substantive jurisdiction, and it would be important that all claims arising from sanctions, expropriation, and breaches of international law should be covered. Regarding the procedural rules, we suggest that the tribunal adopts the UNCITRAL arbitration rules, modified to address unique institutional needs, and here it would be for the benefit that the new tribunals, the new arbitral tribunals, could take a reference in particular to the existing case law of the Iran-US Claims Tribunal. For the legal seat, we propose a seat with unquestioned neutrality of the government, for instance, the IFC or the offices of OPEC in Vienna, and both of these countries have, also their state courts respectively, have in our understanding extensive experience in the enforcement of awards. Then finally, the chamber structure. This might be one of the most sensitive points, who should be the arbitrators, and as a basic working proposal, we would say there are 3 chambers, 3 arbitrators representing all the EU member states, 3 arbitrators representing the Russian Federation and Belarus, and 3 arbitrators from neutral countries, and they could be selected either by mutual agreement or alternatively by appointing authority who guarantees neutrality and holds sufficient international posture. And that could be, for instance, the Cairo Regional Center for International Commercial Arbitration. Then we already come to the end of our presentation. Here we have tried to break down again what makes our proposal incredibly attractive to overcome the present struggles. So you would have, instead of fragmented jurisdictions, you would have a unified forum. Instead of political interference, you would have a neutral adjudication. Instead of enforcement barriers, you would have a security account mechanism. And instead of endless legal struggles, you would have a final binding resolution. We are aware that this is a very ambitious ambitious proposal, but we think it's worth to discuss it, and who knows, maybe some politicians get interested. To conclude, we believe that breaking Sisyphus cycle is essential to restore the credibility, the resilience, and the overall effectiveness of the international legal system in the face of the recent backlash. Thank you so much for your kind attention.
Thank you, Rodrigo, Andres. It's a very interesting proposal, and I think and I expect that you will receive a lot of questions at our Q&A session at the end. Probably I missed it, but tell me please, do you propose creating an appellate body as a part of this tribunal, or national courts at the seat of arbitration could review the words delivered by that tribunal?
Actually, because it's such a new proposal, personally, I didn't have considered this question. I actually also don't know how it was in the Iran-US claims tribunal. I don't know whether there was an appellate body already in the claims settlement declaration. But I'm happy, of course, to discuss and to hear what the audience thinks.
Well, if I can add to that, no, as far as I know, Judge Jameli can correct us, but there wasn't. So Iran-US tribunal awards were usually subject to the jurisdiction of the Court of The Hague, and The Hague was chosen at the time because the Netherlands was considered a neutral forum to settle the kind of disputes, and the composition of the tribunal was also made neutral. There were Swedish judges, for example. Today, Netherlands is no longer a neutral jurisdiction. That's why we think there are other jurisdictions that will have the role. And we think that having that tribunal subject to the Curial Court of, let's say, the DIFC, or why not, the courts of Istanbul, could be an option with sufficient guarantees.
Thank you. Thank you.
Thank you so much.
Let me switch to Russian now. У нас будет еще два доклада.
We have two more presentations. First is prepared by Sabina Geydarova and Vladislav Strazhenetsky. Sabina is an administrator of the Russian Arbitration Center, also a student, 5-year student of High Economic School, and Vladislav is candidate of sciences and is professor of the same university where Sabina is a student. And their presentation deals with using the alter ego doctrine in the arbitrations with state companies, state-owned companies, sovereign debt. And the second presentation is also deals with the alter ego doctrine with investment arbitration. I know that they have a kind of a same cross approach, so I think that they will have both approaches to alter ego in terms of different elements of our legal realities. Thank you, colleagues. So you will speak Russian as far as I understand. Thank you. Thank you. I'd like to start with my gratitude to the organizers because I really enjoy all that's underway here and their presentations, and the previous report is fantastic, just fantastic, because it's a breakthrough proposal. And we would also like to deal with an interesting topic, that is legal status of state companies, their assets. And it is not only law of corporations which inspires us, but I think that all legal personalities with state participation, state corporations and unitary companies, all kinds of entities, any form of entities which is related to the state. So why we decided to discuss this topic? we see that there's a lot of geopolitics involved, and the state companies is a kind of a mechanism of pressure on the state.
And actually, very often they are the ones attacked. And the other reason that makes it all very relevant, I think, is that as more awards are presented by the investment arbitrations, they start very actively seeking for the governmental assets, and very often the assets of the public companies are exactly the stuff everybody wants to find and to file claims against. And in fact, there are lots of exposures here. Russia and Kazakhstan and India have already come across this, as well as Iran, Nigeria, and we have a very long list of players, and I believe this subject is going to become exceedingly relevant. Now, why is this an issue? No, I believe it's because us lawyers were used to thinking in the dichotomies. We have the state, we have the government, and we have the legal entities. So it's one or the other. Now, where do we place the governmentally run companies, the public companies? And there can be no clear answer because we have a whole range of things. The government can own these companies, it can own the shares, it can form the policy of these companies, it can appoint the leaders, the governance. There is a huge range of ways in which the government can demonstrate its genetic link to this legal entity. Now, the most interesting thing in terms of exploration is whether or not the public companies can identify themselves with the state. There is no answer. There is no clear-cut answer to this. And there are no clear borders. I mean, there is no such thing as the borders of the state, and the borders of the legal entities are also quite dynamic. They're quite flexible. So when we started looking at what's going on with the public companies in different jurisdictions in international law, we've come to understanding that there is no one harmonized standard, there is no one way of approaching them, of evaluating their assets, their legal essence. It's interesting that there seems to be no general shared harmonized approach. Where can this be relevant? We'll take the sanctions. We know that the public companies get under sanctions for their connection to the state, and that's the red flag. I mean, if you're related to the state, you can be entered into the lists, and there are lots of examples of that. The next example on our slide is the investment law. Again, can a public company be considered an investor, or a public company that's an investee of the state, or that invests in the government, and then it is not directly an investment? I mean, we have seen an interesting consideration here as to how we qualify the web. Is it a legal entity? Is it a body, an authority of the state? That's what the arbitrator determines. And that's what we observe, like Iran against Bahrain recently. The public banks of Iran were not able to defend themselves upon the investment agreement, and I think it's great news for the investment companies, and there is no single answer. The next area is international liability. Can a public company can be attributed with all these actions, and is there international liability? I mean, is the government going to be liable for the activities of a governmentally run company by a public company? Well, if this public company de facto is a governmental body, if it exerts some sovereign functions, if formally it is not part of the authorities, we've seen such solutions. We have certainly written articles about this, and there is a lot to think about, because here the question is, what is the sovereign function? And in every state, the range of functions is going to be different. Like it can be managing the public assets, that's public activities. Is it sovereign? Can it be delegated to private individuals? How does that work? It's all going to depend on the context. And another area where this emerges is the immunities. The Convention on Immunity from 2004 defines the state in a very broad way. And here the question arises, I mean, does the state have the immunity of the assets that it has? And here it's interesting. I mean, can you sit on two chairs? Can you protect yourself with the immunity? Can you say that you are an independent legal entity? In fact, this is the paradox that directly follows from the UN Convention. And in practice, this problem is already coming out as visible. Next, the liability for the debts of the state. Can you take away the assets, the property of a state company to resolve the commercial or investment arbitration and to say this is the alter ego? I mean, there is no such thing as splitting the assets. It all belongs to the state, so you can take away all these assets. Can you? There are more cases like this. We have done our best to demonstrate how this works, and it's a question of how this alter ego doctrine should be applied and whether it has any borders. And it's an interesting legal case. I mean, this very particular status of a state company can emerge in purely contractual relations when the state company starts referring to contingency. And here, everyone has a temptation to say that the company, the state company, has different standards of predictability because of its different status, and the different criteria should be applied. And because it's related to the state, the contingency criteria should be applied different from the ones that are applied to other companies. I mean, that's the top of this iceberg. Now, another question is the law applicable. Oftentimes, the local incorporation will respond to us that all of this is regulated by the national law. The national law envisions an independent legal status for such a legal entity, and that's it. So that is an independent legal entity. However, if you consider the standards in international law, if you consider the approaches that are already established, in particular the de facto public authorities, it is not very clear-cut. It's not exactly very clear. I mean, when we talk about the state immunity, in international law, it's an autonomous notion. I mean, the state is an autonomous notion. There is no clear-cut notion, but on the international level, at least on the UN court practice level, we see it's not exactly tied to the national legislation of the country where this company was established. As to the alter ego doctrine, if we consider it in terms of the place, the venue of the assets, the applicable law as to where the assets are, many jurisdictions do not really consider the local incorporation. They are not restricted by them. They apply their own standards, their own qualifications, and whether or not this company is the alter ego of the state, whether it is entirely independent legally or not, is another issue to discuss. Now, before moving on to the specific illustrations Sabine is going to make, I just want to make a quick conclusion. Well, there are more cases like this coming up. We really have to keep track of it. It's a lot of risks for all the companies that are related in one way or another to the state. But I need to note that the alter ego doctrine, in spite of all the benefits that can be proposed, contains several deficiencies. Mainly and usually the alter ego doctrine is used by the Western jurisdictions, to which it's really difficult to explain how this can be the case. You create a company by a federal law, you appoint by a judgment, an instruction of the executive authorities, the controlling organs. You can have a controlling public or state participation there and say it's a legal entity. It's an independent legal entity. So there is a lot of mistrust there. However, if you consider it in terms of the legal traditions, in particular of Russia, I mean, this is not done to drive away the assets. It is not done to violate the law. It's not done to abuse of the rights. It's done as a special way of developments. It's a tool of developments. It's a tool of managing this public asset or serving the public cause. I mean, this is what is so special in the way that the state powers are executed, implemented here when the state acts through the state-run companies. And this is something our Western colleagues do not always quite understand, I think. I mean, at least they're not quite aware of it. Now, next, when we talk of alter ego, we see there are two interested entities, individuals, that are fighting against each other. It's the public company and the creditor that is trying to take away the assets, the property. Oftentimes, the analysis is restricted to these individuals. Now, there are also the innocent parties, the stakeholders that can be there, the third persons, the staff of this company. I mean, the circle is quite big. Whether the concept of alter ego violates their interests is an open question. So we are going to continue this research. And Sabine is going to introduce a few very colorful examples of where this doctrine was used. Yes, thank you. Yes, I hope you can hear me. Thank you very much. Indeed, yes, when we were writing this article, we decided to split this research into common law, civil law jurisdiction. On the website, you will see the international law and the European Court of Human Rights and investment cases. Why should we talk about the national law? Because the national law generates the roots that are going to flourish in international law and investment disputes. In the United States, where the public companies use the alter ego doctrine, they refer to the Bunny case. Now, what's the point? The essence. The Supreme Court of the United States considered the most important question, whether or not the National Bank of Cuba can be considered as the state, because it was about the issuing of a creditor. So the Supreme Court of the United States said state companies have this separate legal personality, which extends to the national cases, because that's the principle that emerged in corporate law, but then it was further extended to international law. But what's interesting is that the Supreme Court said that we recognize the state company, the alter ego, if you have the relationship between the agent and the principal. They use the extensive control factor, and the alter ego is established when we try to do fraud, the so-called fraud, through the state company. In fact, the Hispanic case placed the foundation for holding the companies liable through alter ego, because this case raised the issue of whether we could hold the state responsible, liable through the state company. But here the question is, what is this extensive control factor? And in fact, the national institutions of the United States explored this a lot until the case emerged in 2018. It will be against the Islamic Republic of Iran. And the point is that the question was about the immunity, exactly about the immunity in In 1997, in terrorist attack in Jerusalem, a number of American citizens were injured, including Jenny Rubin. So they initiated the litigation in the national courts, trying to work through Iran's assets in the United States to claim their debts. They relied on the loan immunity, the Foreign Immunities Act in foreign states, and the courts had a question. There is point 1610 in this law that says that you can actually claim the assets from the states if the states are sponsors of terrorism. Whether you can claim the debts of the state, not through the assets that are used for commercial activities, but whether you can collect them through the collection of the ancient Persian artifacts that were worth a lot of money. So the Supreme Court of the United States said this law is not used to claim the assets when they are used for commercial activities. And here you see the limited immunity doctrine. And so it comes out that in different cases, the alter ego doctrine is used for different legal issues. In one case, it's to claim the debts, and in another, it's for holding liable. So altogether, the factor Benek were then used in other cases of the national courts of the U.S. What's that? First, I talked about the comprehensive control, and the Supreme Court in the United States explained that this includes the degree of economic control of the states as the distribution of the benefits, the profit of the organization for the benefit of the state. It's the evaluation of whether or not the public authorities are the actual beneficiaries, and whether or not the recognition of this separate legal personality is going to make it possible to foreign states to get a benefit in the procedures inside the U.S. Now, on the other side of the Atlantic Ocean, we have England and Europe. And if we turn to the English doctrine, it says the following. On the whole, the English courts did not like using the corporate veil puncturing doctrine, the alter ego doctrine, roughly speaking, rudely speaking, is a sub-institution that removes the corporate veil. The English courts, in fact, are trying to preserve the separate legal personality for the state companies, but in the recent cases, in Walter International Holdings Ltd against the Republic of Congo, the Supreme Court of England and Wales said that the state companies do have a separate legal personality. Now, to understand how this works, you need to consider the formal registration of the legal entity, the external transactions, what they are aimed at. But most importantly, it's about whether the company of Congo, a state company doing the mining in Congo, is the alter ego of the state. And in this case, you had exactly the puncturing of this corporate veil through the alter ego doctrine. And the court analyzed and said that we cannot say it's a self-standing legal entity because you have the current accounts that were not audited, it's the dividends not paid, it's the profits of this company that were directed to fund the expenditure that usually is funded by the government. In Europe, in the meantime, we usually move into the civil law jurisdiction. There, you have the so-called alter ego doctrine. It's not there, but you have a different doctrine. It's the emanation doctrine. And again, this emanation doctrine can be found in the awards of the European Court on Justice and in Paulsson and other sources. British gas policy that talk of a three-tier test, whether the public company provides public services, whether the activities are carried out under the control of the state, and whether the organization has special authority relations. Now, I think it's interesting to cover the recent case of 2025, of February 2025, that's the Parisian court, and its judgment regarding claiming the debts of the state if the assets are sanctions. Now, interesting, whether or not the sanctions are placed by the UN. It's Israel versus Iraq. So Israel is the Dutch company who is the claimant who used to supply the equipment to Iraq. Now, the defendant was Iraq, the Montana management, the Panama company that managed the assets of Saddam Hussein. So what is interesting is that the claimant, the plaintiff, had the ICC judgment from 2003 and 2006, and it required that Iraq pay the debts. Now, the problem was that the Montana management funds were under sanctions with regard to the UN Security Council resolution of 2018. 1518 was the number. So the Security Council had the issue of material and of procedural nature. Now, in terms of the material nature, this Montana management, is it the alter ego of the state? Is it the emanation of the state or not? Talking in terms of the emanation doctrine. So they said, yes, Montana management is the emanation of the state because these debts were used to support the regime of Saddam Hussein and were managed by the state officials. But why was the claimant unable to get the government pay for the debts? In order to collect the frozen assets in debts, you had to have the permission of the General Treasury of France. So the claimant did not get this permission, so he was not able to get anything from these assets. And lastly, I will just try to go very quickly through this. We have this alter ego doctrine, and we need to make a disclaimer here that in international law, there is no such thing as formulating the alter ego doctrine, but it is used through other institutions and other legal documents, through the investment tribunal, for example, and they certainly turn to the practice of the national courts. So ICJ never really was asked whether or not we're going to use the alter ego doctrine, but the question was whether the Central Bank of Iran is a company based on the judgment of the Agreement on Friendship of 1954. And in fact, they said that other companies indeed are companies as goes in the treaty or Agreement on Friendship. However, the Central Bank cannot be this individual, this independent, separate legal personality. As to the European Court of Human Rights, it's interesting, and it is true that it has considered a lot of cases of public companies that have to do with the Russian Federation, and there are lots of cases like this, and I think Moscow against Russia was a very well-known one, where you have the exact criteria of when we can talk of holding the state liable in line with the European Convention on Human Rights for the activities of the private individual or a company. So these criteria are now available on the slide. It's the need to assess the legal status, the nature of activities, the autonomy of the political power, and the nature of operations. Now, if we're talking about the investment arbitration, we should talk about the investment disputes as well. Now, talking of the colorful investments cases, it's Mafedini versus Spain. Now, here, what's interesting is that the tribunal did not apply the alter ego doctrine or Article 4, but it worked out a two-tier test. That's the structural and the functional criteria together. The structural criteria included the independence of the legal subjectivity of the company, it's the organization of the activities of the company in line with the state legislation, the venue of registration, and the private or public activities of the company. There is also the functional criterion, which includes other elements. That's the control of the company and the creation of the functions. And I need to note that these criteria are not mutually replaceable. No, they in fact top up one another, they complement one another, and make it possible to analyze it. Just 5 seconds I need. So the VBRF case is interesting, and here we need to come up with a disclaimer first. First, they initiated the constitutional arbitration and then investment arbitration, and then they went on to execute this award in the national court. So the question was whether the WebRF was a hand of the Russian Federation or the continuation of the Russian Federation, the extension of the Russian Federation. Now, this WebRF, the expert report was written by Anton Nozoskov, who said that WebRF cannot be considered as a public authority because it's not part of the public administration authorities, unlike the federal services and ministries, and has no sovereign powers, and besides, it is not a legal entity of a particular type, and it is used in the public sector in the Russian Federation. It's normal when in the public sector of the Russian Federation, the public companies are present, serving the public procurement. Also, he said, yes, they have the charter, they have the organization of WebRF, and it's not against the structural organization that we usually have in the limited liability companies, for example. But the tribunal objected and said, well, WebRF has a separate legal regulation, which is not natural for the separate legal personality. So if you consider how the positions are spread in the company, there is a big presence of the government, and in fact the chair of WebRF can be appointed and dismissed by the president of the country. And here they had a link, a strong link with the public authorities and the ability of the public authorities to impact the activities of WebRF. Now, I think the important thing is, in the first place, understanding the nature of the public company, because the public companies differ from jurisdiction to jurisdiction, and Alexander talks about this as well. And it's interesting that the lawyers do the risk planning. In fact, they ought to understand that if the investment dispute is initiated against them, they should be ready for the fact that against them they might use the alter ego doctrine and the criteria that can be different depending on the jurisdiction, but you can single out the control criterion. But how this is disclosed really and how it works out, how it plays out, it depends on the law applicable. Thank you. Thank you, Sabina. Thank you, Vladislav. Sabina, when you were talking about the extensive control factor, we got the definition of the Supreme Court that was published today with regard to Citibank versus Совкомбанk. Our Supreme Court, I think, indicated exactly the same circumstances, talking of whether Citibank and the Russian Citibank are both in solidarity in debt. Now, Nikolai Sokolovsky, the lawyer of Asbury Legal Solicitors Bureau, Nikolai, has experience in representing the interests on LCA and KC and in disputes burdened with the sanctions. He also works on disputes in the courts in Great Britain, in the European Union, and provides the counseling in different categories of Russian disputes. Colleagues, good evening. I would like to thank my colleagues very much for making it possible for me to speak here. Especially, I would like to thank Sabina and Vladislav for touching upon the subject I'm going to talk about, the alter ego doctrine with regard to the implementation of investment arbitration cases. I prepared a presentation where I'm going to present the main ideas for your convenience, and I hope it's not going to be very boring, and I hope I will not keep you away from the other activities following our discussion. So, today I'm going to talk about the application of alter ego doctrine with regard to the investment disputes, in particular with regard to the judgments against Russia. Russia is one of the leaders in non-execution of the awards of investment arbitration, in terms of the number of the non-executed awards as well as in the number of the compensations non-paid. Now, in practice, it's really difficult to get this paid through the state assets because most of them are protected by the state sovereignty, and what is not covered by the state sovereignty is insufficient. So this kind of claim is possible through the alter ego doctrine that makes it possible to equate the state and the public company and to hold the state liable. In the context of alter ego doctrine, the most interesting issue is the sovereignty and how the foreign jurisdiction can have an impact here with regard to the assets. Now, a few words about the history. In the international and national law, the state enjoys the immunity from the foreign jurisdiction, including the judicial jurisdiction, the preliminary enforcement, and the preliminary legal acts. Up to the mid of the 20th century, we had the doctrine of absolute immunity, and I'm sure we all know about that. But more common now is the doctrine of limited or functional immunity, in line with which the state only has the judicial immunity with regard to the actions presented in the sovereign capacity, and it does not extend to the activities or actions of commercial nature. The property-related interests of the state only extend to the property that is meant for the sovereign functions. The key case here is Germany against Italy, that has to do with the immunity. And here, the international law confirms that the state does not allow any interference of international jurisdiction. The immunity has procedural nature and does not depend on the seriousness of the violation of the norms. Now, the foreign jurisdictions can only, in this case, interfere if the state rejects its immunity, which cannot be interpreted in an extensive way. The subject of dispute is always the sovereign activities of the state in terms of the national and international law enforcement. The arbitration is seen as a direct refusal to interact. However, the position of the international law and the national law order are different. Now, the judicial immunity is determined at the stage of executive procedures. So the immunity at the stage of exequatur depends on the nature of the actions. Now, the foreign court should not have the jurisdiction if there is no clear consent from the defendant. Now, there is a ban on the extensive interpretation, which means that the state can only accept the jurisdiction of the arbitration. And this is what the UN Convention relies on. The Washington Convention and most of the bilateral agreements relies on the refusal of immunity with regard to the exequatur by the International Court. However, here we go back to the national legislation that, in fact, determines the rules for the execution of the award. So the state can act in a sovereign way to ensure the enforcement of the arbitration judgments. However, the acceptance cannot mean that the state has to implement this in a foreign jurisdiction. In a number of states, this extensive interpretation in France, in Germany, is not exactly the same. Now, in other states, the exequatur withdrawal is available in the national legislation, and in many, in fact, it goes against the international regulations. Now, the Russian practice also has the extensive interpretation of this as the refusal to have the judicial immunity, the alter ego doctrine. Now, this doctrine, in fact, emerged from the common law as a response to the limited liability of the legal entity. This doctrine makes it possible to identify the legal entity and the control entity in order to hold both liable for the obligations of each other. The grounds for this equation is the de facto lack of independence of a legal entity, and it's also the abuse of control in the corporate form of a legal entity by controlling participants to pursue unfair objectives or to escape from liability. In fact, colleagues have said that the similar doctrine exists in continental law, like in emanation. As to the collection of public debts, you can identify several features of the alter ego execution. Now here, it's about the reverse puncturing of the corporate bill. That is, it's about involving the controlled entity to the debts of the controlee. Now, the judicial analysis is there to understand whether the commercial activities of a state-run company is replaced by the public functions. In fact, this fact of the state's 100% involvement is not grounds strong enough to use the alter ego doctrine. Now, within the puncturing of the corporate field, when serving the constitutional arbitration, we exactly have the issue of the constitutional obligations. The international practice demonstrates that alter ego doctrine is used when the immunity is determined in respect of specific property that is not covered by immunity rationa materia. Now, the alter ego doctrine can be used in judicial and extrajudicial procedures. The judicial ones are about getting the consent of the court to manage the assets of the state company that are auxiliary together with issuing the exequatur. So the rejection of the exequatur also extends here. Now, the non-judicial ones do not cover the immunity. Next, I would like to talk about some key cases. One of them I believe is the most discussed one and the brightest use of the alter ego doctrine is the WebRF case. And it's not arbitration, it's the case considered by the Supreme Court of the Ukraine. I'm not going to go through the details of this case. I believe many of you who are interested in the application of the alter ego doctrine and the execution of the investment arbitration awards know of it. Now, I know that this case is the first one in practice, in the experience, when the state court has recognized the WebRF as the alter ego of Russia and noticed the importance to collect the assets that were the bonds in the Prom Invest Bank of the Ukraine per the debts of Russia. The judgment of the Ukraine is entirely reliant on the international practice, and there is no novelty here. But the important thing, however, is that this case shows the trend to protect the private individuals against the foreign states. Now, we have the WebRF and another case considered by the Supreme Court of the Ukraine, and that's the case of Gazprom International. The Ukrainian organization Slavutich Invest turns to the Gaga court. And in the first instance act, the appeal court rejected the removal of the measures, referring to the award of the Court of Ukraine. However, at the same time, there is no sufficient analysis with regard to the application of the alter ego doctrine. And you can read quite a lot of views demonstrating that the judgment is not grounded, considering the nuances I've mentioned already, that's using the alter ego doctrine and the state immunity. Just a few words regarding the violations the court has made. And I would also say a few words regarding the due order for the consideration of the application from Slavucic in the Netherlands court. And now the court in the Netherlands should have followed the presence of the immunity of Russia in terms of serving the recognition of this application. Now, the decision, the award, is not based on the voluntary rejection of immunity by the Russian court, but only on the understanding of the national rights. So this the withdrawal from the immunity only has authority in the Ukraine. Now, if the Dutch law does not consider this as possible, then the Dutch assets of Gazprom, the international, seized in supporting the recognition of the enforcement of a future Ukrainian judgment. So no grounds there for refusal to issue future executorization. That means the WebRF case confirms the possibility of recovering the Russian assets from Gazprom International, and it is not then a defendant in this case. So this is against the overall public order and should cause the rejection of executor based on the Ukrainian judgment. An important thing here is that the presentation of a one-off lawsuit relies and implies the recognition of the liability. Now, if the only risk is the alter ego doctrine, we should then conclude that in this case we are going to have a contradiction with the res judicata principle, because in this case we will then hold the individual liable in both areas of liability, which I believe here we have another ground for recognizing this judgment or award as contradictory to the public law of the Netherlands. Now, considering the last case, I wanted to demonstrate the fact that the application of the alter ego doctrine essentially is not about instilling a new lawsuit to a new individual, to a different individual, and holding this different individual liable in a repeat fashion, but indeed it is exactly about establishing the grounds that would make it possible to execute the judgment of the investment arbitration, and yet will not be targeted at the repeat consideration of the same grounds for liability of the individual that already has been held liable. In this connection, let me refer to a pretty well-known case, Chabad versus the Russian Federation. Chabad is the institution that filed a suit to the American court with regard to the requirement to the Russian Federation, a number of Russian religious organizations on religious text collection. Now, Russia was in the early 2000s against the jurisdiction of the American courts, referring to the immunity. The first instance court rejected the immunity application, quoting the lawsuits that had to do with the violation of the international law and nationalization. Now, after this judgment was made, Russia rejected participating in the procedure. The remaining defendants appealed against this award, and the ultimate judgment made no analysis with regard to the Russian Federation. However, it made a conclusion whereby the first instance court had the jurisdiction due to considering this dispute. This award was not executed, and in the year 2020, there was established a legal practice in accordance with which a withdrawal from immunity was inapplicable to cases like the Chabad case. So once this practice was well established, Chabad turned to the court in a repeat fashion to collect the assets from the American companies that are controlled by the Russian Federation, including using the alter ego doctrine. So this initiated the new circle of consideration, and once an important practice was formed by the American court, the Court of Appeal agreed with the companies controlled by Russia and made a conclusion whereby the previous judgments by the appeal court were not strong enough, as not motivated enough, and the Russian company had an interest in having this case revisited, concluding, therefore, that the judgment to meet the demands for the suit were well grounded. Now, with regard to Chabad, the requirements were exactly focused on the Russian assets, and therefore, based on the alter ego doctrine, it made no sense to consider it as consideration, as this was the initial and the primary requirement. Now, concluding my presentation, I just need to say that the withdrawal from the state authority, the executors, became well established in the international practice, albeit not quite used in the international law. The application of the alter ego doctrine is part of implementing the award, so the immunity does not extend here. The example from the Ukraine shows that the events of 2021 have reinforced the trend towards increasing the national sovereignty and the extension of the alter ego doctrine. Now, with its withdrawal from the sovereignty that makes it possible to apply the alter ego doctrine, have now extended to the national judicial procedures against the foreign states. In this edition, Russia cannot protect itself with a reference to the immunity from collection, because the state's agreements in many jurisdictions is considered as rejection, refusal of immunity, including with regard to executor. Now, abroad, in the location of executor issuing, it is believed that the state should consider exactly the same grounds as the ones taken by the court. Now, as the alter ego doctrine is used to execute the award, this exactly prevents or precludes the execution. The current trends, I believe, will force Russia to mirror the reaction of other countries, that is, to start using the restrictions of the immunity. In 2016, the Russian court issued the executor already issued with regard to the Tatneft case, whereby the court recognized the refusal of the immunity and also considered it possible to collect the assets from the Ukrainian organizations as part of executing the judgments. The latter events only encourage the spread of this practice. Thank you. Thank you very much, Nikolai. Or would you have any questions to the speakers? You have the floor. Thank you, Sergei Alekhin, LB.
It's in English to the two speakers that presented this wonderful idea about the EU-Russia Claims Tribunal, which is fascinating, I believe. There are two observations and one question. The first observation, I think it's important as a matter of factual record, and this is probably me speaking slightly in defense of ISDS overall, is that the Dayani matter that you mentioned involving South Korea and the Iranian investors was actually successfully concluded to the satisfaction of the investors, which have received their compensation ultimately. In 2020, they have successfully arrested or put an interim charge over shares of a subsidiary of a South Korean state-owned company in English courts. And in early 2022, OFAC granted a license to South Korea to pay, effectively to Iran, to the Iranian investors, a certain sum of money. The rest, unfortunately, is slightly confidential, but as a matter of factual correction, I think it is important. My second point concerns the thesis about the primacy of EU law, and I hear you on this, but wouldn't the other approach be to regard the matters that are of interest to potential ISDS tribunal, not as whether a tribunal could decide on the legality of EU sanctions regimes, but the interpretation and application of EU law on a domestic level. And here we have Mikula 2, we have Androkopoulos, we have CMC versus Mozambique that have discussed this notion in a similar context. Again, we could spend hours, I guess, discussing those cases, but I think it's an interesting approach to think about this not as the, again, legality of EU sanctions from an ISDS perspective, but the legality of the application on a domestic level. And my third point is a question. Would the proposed mechanism extend its jurisdiction only to claims of Russian investors against EU member states? Or would it also cover claims by EU investors against Russia over arguably similar measures that might have been taken by the Russian state? So that's an open question. And a brief comment, and I will switch to Russian if I may.
The presentation we had on alter ego, the first presentation, I think was interesting, and I think it would be interesting to draw a parallel between the notion of alter ego and the principle of monetary gold. In the ICJ case of 1952, which then was well established in the East Timor case, whereby ICJ, through the court, was not able to issue the award, to make the judgment, if it covers the interests of the third party or the third state. In our practice, we had an attempt at applying this monetary gold principle to the argument against the undue claimant in arbitration. That is, the defendant says that the claimant, the public company, is not a due claimant in that case. I mean, the one minor peculiarity was that we're not talking about BIT, we're talking about the interlegal agreement on a particular investment project implemented by a public company that then filed a lawsuit to the arbitration court against the state. And the point was that the principle of monetary gold could be or could have been used with regards to the due or undue nature of the claimant. Thank you.
Thank you. Your questions. I'll ask the first three questions regarding our proposal. So regarding the Yanni case, yeah, I agree with you. OFAC eventually did grant the license, but when did the investor actually receive the money? And has he received all that he was owed by South Korea? That's, of course, that's confidential. That's confidential, but having the license being granted and having the funds wired, that's a different point, right? And certainly the existence of the OFAC regulation gives an avenue for the investor to resist further. Second point about the EU law, no claims provision on the primacy of EU law. Switching the focus to another controversy in investor arbitration, which is the ACMEA, right? The intra-EU issue. Ask all the investors that won awards against the Kingdom of Spain, or against Italy, or against the Czech Republic. How many of them have been satisfied? How many countries they had to fight in the district, in the DC district, in Australia, in the UK. So as I think Professor Cremades rightly said, we have today a tendency of focusing on procedural issues, which ultimately sabotage the enforceability of the award. And third point, regarding, you asked whether this will also serve EU investors against Russia. Yes, of course, this is a bilateral mechanism, exactly as Iranian US tribunal was a bilateral mechanism. Then Iranian investors didn't use that mechanism that much as maybe they could have, but that's for other reasons. But the system itself is made to serve both sides. And why we think that is important? Because we think that some developments are taking place to resolve the current situation. I'm sure we all heard about the EU register for Ukraine. So I think the choice is going to be, are we going to a system which is unilateral, like the EU register for Ukraine, which is as unilateral as the compensation commission, UN compensation commission for Iraq was, and we know what happened to Iraq and how the Iraqi state was able to assert its rights, and what happened after that. So I think Russian investors have to make a choice. Either we're going to a mechanism which is unilateral, and they're just going to ignore it or resist it as much as they can, or they take a seat at the table and we find a solution which is equitable for both sides. Thank you. And I think the question was, yes, was for...
Sergey, thank you for your question. Rodrigo, thank you for your answer. I think we'll take one more question from the audience, and then we will be rounding it up. Thank you. We had a question out there.
Former judge of the Iran United States Claims Tribunal. Certainly, I appreciate the proposal. Of course, the detail of it, there is a lot to discuss. But a major point over the settlement, in addition to the security account and the return of and the release of the assets, frozen assets, was that the United States would withdraw any claim against the hostage takers and no liability for the taking of the embassy. Those claims would be paid by the United States itself to the nationals of the United States. Whether such a solution could be available with your proposal vis-à-vis EU or Ukraine, I don't know. That is an issue. But with regard to the composition of the Iran-US Claims Tribunal as a proposal, there are a lot of things, but most important one, I think, is composition of at least 5-member chamber rather than 3. The problem is that we constantly face by majority voting, that is the rule under ancestral, you will always find the chairman in serious trouble to agree with the excessive demand of the American or the Iranian. And that didn't work. So I thought maybe that is something. There are, of course, a lot of other details that can be worked out later. Thank you.
Thank you so much for this input. Maybe on your first observation, of course, I mean, now in the interest of time, it was extremely condensed. I mean, there were other requests also from the Iranian Republic. I think they also wanted to have the remains of the Shah and the state. I think that was also part of the negotiation, also the mass. So, of course, in the current situation, it would have to be carefully balanced which stakes should be part of this settlement negotiation and agreement. And on the second point, I understand that there were 3 chambers in the Iran-US Claims Tribunal, and the second, one of them was precisely, the scope of their competence was to decide when there were questions of interpretation, because the claim settlement declaration, as every legal text, was not 100% clear and gave room to interpretation. And perhaps we could also have for the Russia-EU Claims Tribunal a specific chamber which would help to, I have to go once back, and I also, because there was extreme positions between the US arbitrator and the Iran arbitrator, the president would more and more defer unclear questions to this chamber, which would then decide this. I'm not sure I have 100% understood this, and maybe something similar could be implemented in the Russia-EU Claims Tribunal.
Very much, yes. We had a full tribunal for interpretation and application of the treaty disputes between the two governments. All the chamber members would get together, therefore would become 9 members. Also, we had the issue of if a chamber faces an important issue of interpretation, would relinquish it to the full tribunal. But that you are talking about happened only once. They found it quite impractical because every case we were dealing one way or the other with interpretation. As a consequence, that was only one. But the dispute between the two governments, and of course there is a lot of other things that we can discuss.
Rodrigo?
Yeah, I think we can add to that is that the Iranian tribunal was established at a time where this was still an idea that there was no, or better, there was no discussion that co-arbitrators or party-appointed arbitrators could be in a way partial, or could in a way tend to the side that appointed them. And I think the Iranian tribunal with US arbitrators, Iranian arbitrators, and usually Swedish judge chairing the chamber was a reflection of that. Today, that I think that the mechanism of party-appointed arbitrator is also getting in discussion. Why not? We could have a tribunal where all arbitrators come from neutral countries. You could have arbitrators from UAE, from Argentina, from Kazakhstan, from Nigeria. Why not? So that tribunal not necessarily has to follow that particular setting. Could have a totally neutral composition of the panel.
Maybe briefly on that point, Mr. Cremades, you mentioned that in each jurisdiction at a certain level there are highly skilled judges, and I would say that the same holds also true for arbitrators. So I think the pool is quite big when we take all African countries, which are mostly neutral, and Latin America. I think we would have a relatively big pool.
You can find very good arbitrators everywhere. Nowadays, I think situation has changed. Arbitrators are not an elite of European university professors. Now you can find arbitrators very well trained all over the world.
Thank you very much. And on this promising note, I propose we terminate our session. Thanks a lot, everybody. And please enjoy the cocktails. Goodbye.